Better, my lord, please. My lord,
All mentioning list give to my court officer.
82-year-old petitioner, my lord. My lord.
My lord.
My lord. My lord.
My lord. Give all mentioning list to my court office. My lord.
Okay.
Yes.
My lord, I am one matter, my lord. I need to move unlisted.
You give the mentioning list, giving the reason, I will see to that.
My lord, item number monthly list 151. Honorable Supreme Court declared the law to bind all court of India. Till date, no effect. Please kindly better wait for release.
স্যার আমারটা শুনবে স্যার স্যার
Yes. Where is unlisted?
শুনবে বলুন
No mentioning give the urgency. I will not take any further. Yes. What is
বলবেন তো
what is
এই যে
unlisted?
সব নিয়ে এসছি টিপটিকে দিয়ে সব আমি উইটনেস বক্সে দাঁড়িয়ে আছি
Today, when you will move? Okay. So. Go to the DRT. Go to the DRT. Once you receive the notice on 20th, now we are on 23. Once you prepared the writ petition, why you have not prepared the application under the 17 before the DRT? You could have been make an application before the DRT. Instead of filing a writ application, you could have been prepared the writ application before the authority. Yes, what is unlisted?
May I have your office kindly, my lord? Still, my lord, the financial bid was when I am second lowest bidder. My lord, the first lowest bidder, my lord, does not possess the necessary certificate issued by the Petroleum and Safety Organization. It's the tender for medical oxygen, nitrogen, hydrogen. My lord, during the technical bid, I gave a representation. These are the essentials which he does not possess. My lord, again, my lord, without having those documents, he has been financial bid, he has been given, my lord, the L1 bidder and the L2. My lord, I am challenging, my lord, any day the work order may be issued. My lord, I want to move it tomorrow, subject to your lordship.
Madam, may I have your lordship's leave, my lord?
Tomorrow, short notice, tomorrow.
Madam, may I have your lordship's leave, my lord? Yesterday's matter, your lordship granted me leave, my lord, that adjudicating authority quorum non judice, my lord, appearing as item number 21.
No, I told you to be fix after 10 and 9th matter. Why 22?
It's 21.
You have brought to notice to me. What I told you?
It's 21.
I told you after 10th matter, this may fix. These two matters may fix. One is the maritime zone matter, and another is this matter. Why you are playing?
It's 21.
Item number 153 also is mentioned on Monday. Also has been directed to appear in the first 10 matters, my lord. That also has gone to 150.
You brought two notice to me. I told you to fix that after 9 or 10 matter. Why it has gone to 22? They are not paid to you. That only the court can ascertain.
It's 21. But I'm mentioning on notice. Should I come back at 12?
Come at
2:30?
Come at 1.
1 minute, most
If it is not reached,
perfect.
if it is
perfect.
not reached, come
If
at-
not reached at 1 o'clock, 21. Okay.
you do one thing, you all go to the Chief Justice, so tell in the court for 25, my staffs are insufficient to maintain the list. Once I am preparing the list in the chamber, but they are modifying the list coming in the court cannot do anything. They are not reading the order. When the file is to be fixed, I think this is the only court which is giving the date in the order. But my officers are not able to go with the order.
My lord, only one, my lord, humble prayer.
Every day, what is going on? I have reported to the chief, I have reported to the RG, but you are not. What do you want? You want to do a disciplinary proceeding? Yes. Give.
My lord,
Only,
may
only
I,
one humble prayer, my lord. If matter was filed,
What can be done? Tell me. Transfer me from this court, from this high court. That only can I say. You are seeing. That's why I only can do direct pass, or I can only set this cause this. I cannot go to the department, bring your file. I cannot sit at 9 p.m. to see whether the list has been correct or not.
Fine.
So you persons are giving, I am giving the date in your mentioning list. Even that they are not giving that, so I am paralyzed.
absolute, my lord, absolute.
The court is totally paralyzed.
Yes,
If the staff will not support
my
this
lord,
court.
my lord, my lord.
So what can be? Every day I know, every day you are mentioning, every day I am keep putting the date, but the file is not coming. The department is just two rooms after, but the file is not coming.
We are also failed.
What can be done? Yes.
may I, my lord,
I'm not accusing anybody. I'm not golden hand. He is in custody for more than 21 years. But at least has been cleared, I would
Which matter? You the mentioning me, silence.
Lord, 186 of the monthly list, my lord, your lordship, please to direct the railways to file a report in the month of March. That report has not yet come till date. Lord, I'm praying whether if the matter can be coming up as to be mentioned, subject to your lordship's satisfaction, at least to ensure compliance.
may I be permitted to mention this matter, my lord? This matter has been filed and never not in the list and never heard. My lord, due to an intervening new law, the business I carry on now requires a license to be obtained, for which an application has already been made. The statutory time for either rejecting or accepting that application is long over. My lord, the matter is pending before your lordship. In the meantime, what presses the urgency today is 2 or 3 days back, my lord, some complaint has been filed before the police, and now I am being called by the police. It is a matter, my lord, where ultimately we will be praying your lordships for a direction upon the respondents to consider and at least act on my application, either reject it, then I will go up in statutory appeal, or accept it, in which case, my lord, I will have no further grievance. My lord, may this matter, my lord, subject to your lordship.
Can you mention the reasons?
Yes, my lord, the reasons are mentioned already. And my lord, may I also at the same time, of the same person, a connected matter with the same business, if your lordship deems it fit, my lord, it is connected, both reasons are mentioned, my lord. Great. My lord,
So when the IBC proceeding is going on, what the court will do here?
has been.
So you go file an application before the IBC, they will pass the direction upon the director to consider it. What the writ court will do? You're not in the court. You have been removed. You have not challenged the removal of your.
Removal, this.
So what you want now? Give the.
My lord, may I only say this, since it is a pending matter, my lord, may I effect service again on the GP because of the change of the regime?
See, when the date will be fixed tomorrow, you will get the date.
Yes.
Then you mention issue the.
Very well, I'll come.
Yes.
Your lordship's kind leave to mention a similar matter. Your lordship has given me time.
Just I refuse, Mr. Chatterjee.
Your lordship gave me time.
2 days was
7 days.
there. Why you not prepared the 17 application?
We have filed it. We have filed it, but we can't get it listed. Cannot get it listed. Today, my lord, is the date. Tomorrow is the
When
date.
you filed?
Yesterday. 20th is the notice. 21st we prepared here and then filed it, my lord, on the 21st. Today, my lord, I'm mentioning, they have said that they have taken, my lord, they're going to take possession tomorrow morning. I can't do today. I'm sorry, today. And we've written this down. And I've got the lordship's last order also. 7 days just to move it and direct the DRT to take up.
Similar matter.
Similar matter.
1 बजे रखो.
Grateful.
My lord, may I have your
आज के एक्ट.
बाकी? और एक?
Despite my application pending,
Who?
applying to Madrasai for judgment. By applying to it, I have necessarily have considered the circular, then any action on the circular is government. Taken possession. I will not take more than 5 minutes. I will take tomorrow or day after.
There is no ground of MSME section 10 application.
There is no. No, that is not a state by your. Let the matter now, otherwise you leave the matter here.
On the last 5 minutes when the matter was fixed for hearing, they said that there is no credit application on the ground of MSME. First time they said so. Recorded in the order. Till date, matter we have not preserved the copy of the yesterday we went to the police station to check that there is already an order state on ground of the high court. So they have to show them to the staff that there has been no order, matter has not been preserved.
This will check when the lordship takes it. Correct, of course. Can you fix it tomorrow or day or tomorrow? Or these are Monday. The reasons are on Monday.
When the matter is fixed before the DRT? 31st.
Or like the lordship passing the other one.
31st is fixed. Let it fix on 29.
My lord,
To notice to the other side.
my lord, may I have your lordship?
Give the date.
Challenging the lookout circular, I filed this writ petition, my lord, and by the strength of the interim order, I was allowed to travel abroad. But every time I travel abroad, I have to file an undertaking, my lord. My lord, for business purpose, I'm traveling abroad again on 10th of August, my lord, and I have to file an undertaking. My lord, this matter may be kept under to be mentioned next week any day, my lord, kindly.
My lord, may I have your kind leave?
Traveling the abroad is not an urgency. Yes.
My lord,
Traveling abroad is not an urgency.
Undertaking,
Yes, give all mentioning list.
my lord, may I have a kind leave to mention a my lord, may I have a my lord, may I have a kind leave to my lord, may I have a kind
My lord, it's an urgent matter.
my lord. My lord, may I have a kind leave to mention a matter, SIR is with my lord.
We are not getting any passport other thing, my lord.
Call the list.
Item number.
I
My lord,
The bank accounts are frozen.
my lord, may I have a kind leave to mention the matter, my lord, you have passed civil orders, my lord.
May I mention only one?
The so-called notice is caused. The respondent number 2 is directed to consider the representation made by the petitioner within 4 weeks after giving an opportunity of hearing to the petition to pass appropriate order. Yes, next. Call.
My lord,
My lord, I am for the petitioner.
mention.
My lord, 2 and 3, my lord, I'm praying for a short passover, my lord.
No, I'm for the
For the,
petitioner, my lord.
my lord,
Both the matters listed as to be mentioned.
I am for the petitioner, I am praying for extension of your lordship's order.
my lord, My lord, they have filed a CAN application, my lord. My lord, they have filed a CAN application, my lord.
Just a minute. My lord, I'm sorry, my lord. My lord, this matter your lordship recollects. Already written notes of argument has been filed. Now, when your lordship proposes to pass the order, he is coming with supplementary affidavit wherein the petitioners after retirement are in occupation unlawfully in the railway quarters. Sorry, Farakka barrage quarters. And I have filed the written notes of argument. If your lordship permits me, I can, my lord, start my argument. Because on every, just a minute, sir, on every.
My matter, my.
No, it is your cup of tea. I'm not denying, but it doesn't mean that every time you will file with new some papers so that this, with greatest respect, this court may not pass the order.
No.
Yeah, that is the thing going on.
Kindly fix any date as per your lordship's convenience. Let the matter be finished. I have no difficulty. I have
Very
no
well.
difficulty in arguing before your lordship. But today, my lord, I believe, my lord, half an hour, more than half an hour has passed. Where your lordship was taking, I'm mentioning, my lord, kindly extend the order for a couple of days and fix the matter as your lordship pleases. There is no difficulty, I think.
They have no locus standi also on the last occasion. আমি বলছি তো জজ সাহেবকে কি মুশকিল আমারটা আমি বলবো তো
আমিও তো আমার
হ্যাঁ
What is the, where is the CAN? You filed the CAN?
can
CAN number?
can
see of 2026.
yes
597021.
opposition to supply এটা আবার কি? করে বলো রে ভাই হ্যাঁ ঠিক আছে already written notes are exchanged.
My lord, may I hand over the copy?
New documents are coming every day. আরে আমার দাও written notes এর
These
মাধ্যমে
are not the new documents, my lord.
What is the CAN 3?
Lord, can see, my lord, you kindly consider one thing, my lord, the petitioner before lordship in item number 2, there is society, my lord. So that consists of, my lord, several members. Some of the members have been granted benefit, which I am also asking for. That document I have collected
এইটা দাও
in 2024.
এইটা
The petition has filed an application being CAN 3 of 2026. Have you received the CAN?
yes can 3 I have received.
Serving the competent counsel for the respondent. You will deal with the affidavit or not?
My lord,
Deal with this, with an affidavit?
short affidavit, my lord.
The counsel for the
will
respondent
be-
press for
yes,
time
sir.
to file affidavit in opposition to the CAN application. Let affidavit in opposition file within a week. Reply if any date within a week thereafter. Full stop. Let the matter appear on
ওটা আলাদা কেন বলছি
on 18th of August 2026 under the heading adjourn motion within
18th
10
August
matters.
করছো তো
Interim order is extended till 18th August 2026 or until further order whichever is.
grateful to you. My lord, only one indulgence I am paying, my lord, the matter will retain under the heading to be mentioned.
No, no, urgent motion within 10 matters it will come
My
on it.
lord, my lord, deeply obliged.
Yes.
Both the matters.
Chief
Two
also,
are-
Lord. In chief, there is no can, but she is similar.
Two can carry then, three only. interim
Maybe
order
some
extended
can
till
will come, I apprehend.
Your apprehension will not do.
Or, my lord,
I'm appearing for the
I'm appearing on the application, my lord, I'm led by Mr. Siddhartha Banerjee.
Where is the order?
My lord, yes. The last order, my lord, it is on 10th of June 2026, my lord.
Which was the respondent? You are?
For the state.
Yes, what is your objection?
My lord, I was
Of interim
led
order?
by Mr. Partha Chakraborty.
Ah.
Due to his illness, he is not attending court. Due to his illness, he is not attending court today. So, my lord may explain order.
The matter is listed as to be mentioned on the plan made by the counsel for the petition. Counsel for the petition submitted the interim order is till 24th of June 2026 and prays for extension of it. Learned counsel for the state submitted, the learned counsel for the state submitted, Mr. Partha Chakraborty is appearing representing the state having some difficulty that according prays for adjournment. In view of the submission made by the counsel for the parties, the interim order is extended till 2nd September 2026 or until further order whichever is allowed. Let the matter appear on 2nd September under the heading adjourn motion.
My lord, may I be pray one thing, my lord, kindly extend more the interim order.
September.
My lord, till the end of September, my lord, it will.
Second, no.
I'm
Interim order I cannot. Yes. Yes, next.
Lord, I appear for the petitioner. Lord, the petitioner is a manufacturer of wagons. Well, for the purpose of manufacturing, supplying wagons to the railway.
Pranam for the respondent.
Lord, there are two agreements that are required to be entered into. One is a land agreement, where certain lands are allotted for the railway siding, and two is the railway siding maintenance agreement. But insofar as we are concerned, both these agreements were entered into and have been renewed from time to time. There's no difficulty with that. Well, under the private siding agreement, there is the provision for maintenance of the private siding. Now, if the private siding is to be maintained by the railway, they will naturally raise bills for maintenance charges, which I will have to pay. If, however, railway does not maintain and the entire maintenance is done by by the petitioner, in that case, naturally, nothing is to be charged. Now, this was the arrangement that was going on. There was no difficulty. The difficulty arose for the first time in the year 2021. If your lordship will kindly have a look at page 108. 108, my lord, the Eastern Railway raises a bill, my lord, on the petitioner on 28 July 2021. My lord, your lordship will see there are 4 bills. Bill period, 5 bills. Bill period 2017-18, 18-19, 19-20, 20-20, 21-22. For 1 crore 18 lakhs 34,000 and odd. My lord, this is on account of, my lord, siding, my lord, maintenance. Your lordship will
Yes,
kindly.
inspection charges.
Yes.
Maintenance and inspection charges.
Now, my lord, we immediately say that what are you saying? Because you have not done anything, all that has been done by that. That is also in 2021. Please see 120.
Yes.
So, my lord, bills for 5 years raised together at one time. We say that what are you saying? We are shocked and surprised to receive the above mentioned demand notice for payment of maintenance and inspection charges for the period 2017-18 to 2021. We are unable to reconcile any request as per agreement mentioned above to the railway. Furthermore, since inspection of the siding, entire maintenance from the takeoff point onwards has been done by the company at its own cost from time to time, as directed by the station authorities. If any inspection or maintenance was carried out by the division, please provide us details of any such maintenance carried out. So, my lord, this is what we say. And then, my lord, they write to us at page 121. In connection with the above subject, as per clause number 8 of the agreement, you are liable to pay maintenance and inspection charges. Well, that is same. Now, so far as clause 8 is concerned, if your lordship will kindly have a look at page 68.
Yes.
Now, page 68 says, my lord, maintenance and other charges to be paid for the portion of the siding within railway land and outside railway land. Now, my lord, so far as this is concerned, if your lordship sees, applicant shall also pay to the railway administration towards ordinary maintenance of the said siding within railway boundaries such and such, permanent subgrade work, etc. Charges shall be paid in advance within 7 days after every 31st month. Such yearly payment shall include all items up to the last date of respective bills, provided the entire cost of recoupment, ballast, renewal, replacement, strengthening, permanent way, etc. So, they have to do these works. Now, our contention is you've
No,
done
the
nothing.
applicant shall also to pay the railway administration toward the ordinary maintenance and the siding with the railway boundary.
Yes. And, what shall be provided that the entire cost of recoupment of ballast, renewal, replacement, strengthening of permanent way, etc. shall be deemed to be special repairs. Applicant shall agree to pay special charges on demand for expenditure. Now, they have to, therefore, it is not really by way of a tax. It is, the service charge. If they render the service, they'll get it. Our only contention was you have not rendered the service. How can you claim it? And after 5 years. Now, so far as these disputes are concerned, there's an arbitration clause at page 87. Well, these disputes will ultimately have to be resolved in arbitration.
87.
Page 87.
Yes.
So, now, so far as this correspondence is concerned, it goes back and forth. I'll not trouble your lordship with all the correspondence. Finally, what happens is, if your lordship will now straight away come to 164. Well, this is 3rd July 2026. Now, this is what the railway writes. Subject above, it is stated that realizable amount for different charges, example, maintenance and inspection, interest and maintenance charges, and OE maintenance charges from the petitioner is to the tune of 1,40,57,000 for Shialda division in the pending details. And my lord, they give my lord details of the charges. Please see again the periods. 2017-18 to 21-22, 22 to 25, then there's a 22-23 period, and then my lord, July 22 to 25. Now, my lord, so far as this is concerned, we're very important. The next, my lord, portion. Parties have been approached several times for making the above payment by issuing letters in different times and also a telephone. But the party is not responding and delaying in making payment. Now, my lord, under these circumstances, it is requested to adjust the above amount from existing pending dues of my lord, the petition against Eastern Railway. Now, my lord, this cannot be done. Now, my lord, I am supplying railways, wagons, I am raising my bills, they are making payment of bills. Now, suddenly they say, on account of our claim for maintenance and inspection charges, we will adjust from your bills. Now, my lord, so far as the law is concerned, the law is very clearly, my lord, laid down in this regard. Three, my lord, propositions of law. My lord, your lordship remembers in Raman Foundry, my lord, there was clause 18 of the general conditions of contract, where, my lord, the Supreme Court said that no, it has to be a liquidated ascertained debt. Only then can you appropriate it. And there was a specific clause in the contract which says you can appropriate it. Yes. Now, my lord, in Kamaluddin Ansari, the Supreme Court said that no, it does not have to be a specified sum. If the contract allows you to do so, then you can do so. Now, my lord, so far as these two cases are concerned, ultimately in all these cases, there was a contract. And the contract provided for, my lord, appropriation of, my lord, dues of, my lord, the railways or the authority from any other bills of the contractor. There is no such contract here. So, my lord, neither Raman Foundry nor Kamaluddin Ansari have any application. Now, my lord, the question is, what are they trying to do? They are trying to, my lord, claim set off. So, I have a claim against you. I will set it off against, my lord, your claim against your bill for supply of wagons on me. Well, I'll just show your lordship, my lord, one judgment in this regard. Well, this law is very clear. Well, this is a fairly recent judgment in Bharti Airtel. Well, the Supreme Court. Well, I don't want to multiply judgments at all.
Reference table.
Sorry. 2024 SCC online SC page 4.
Yes.
Well, please straight away come to, my lord, paragraph 50.
15.
1-5.
Yes.
Set off in generic sense recognizes the right of a debtor to adjust the smaller claim owed to him against the larger claim payable to his creditor. Then, my lord, your lordship will please see, my lord, paragraph 17. At least 5 different meanings can be ascribed to the term set off, namely statutory or legal set off, common law set off, equitable set off, contractual set off, insolvency set off. Then, my lord, paragraph 19. Contractual set off is a matter of agreement. That was what Raman Foundry and Kamaluddin Ansari were concerned with. Contractual set off is a matter of agreement rather than a separate application of set off. The parties are free to mutually agree on the outcome they desire. Being consensual when expressly stated, the normal rules of set off regarding mutuality of credits or debts, liquidated debts and connected debts aspects relevant and noticed below while dealing with statutory set off, etc. The contract, however, should be within the bounds. So, my lord, if the contract provides for it, you can do it. Then, if your lordship sees paragraph 21, statutory or legal set-off is created by a statute. For example, Order 8, Rule 6 of the Code of Civil Procedure states that where a suit for recovery of money is filed, the defendant can claim set-off against the plaintiff's demand for any ascertained sum of money legally recoverable by the defendant from the plaintiff, but not exceeding the pecuniary limits of the jurisdiction of the court. It requires that both the parties should fill the same character as they fill in the plaintiff's suit. The defendant may, at the first hearing of the suit and not afterwards, unless permitted by the court, present the written statement containing particulars to be set off. Now, my lord, this is very important. For set off in law, the obligations existing between the two parties must be the debts which are for liquidated sums of money demands which can be ascertained with certainty. Both debts must be cross mutual cross obligations, that is cross claims between the parties in the same right. My lord, I have given you, my lord, a contract to build, you have supplied some material, same right. Then, my lord, paragraph 22, a few judgments of this court and the high courts allow the defendant to claim equitable set-off in respect of an unascertained sum of money payable of damages. So, my lord, when it is unascertained, equitable set-off can also be claimed in respect of an ascertained sum of money. However, the claim for an equitable set-off must have connection between the plaintiff's claim for the debt and the defendant's claim to set off, which would make it inequitable to drive the defendant to a separate suit. It has been accordingly held that the claim for set off should arise out of the same transaction or transactions which can be regarded as one transaction. Equitable set off is allowed in common law as distinguished from legal set off, which is allowed by the court only for an ascertained sum of money and is a statutory right. So, my lord, the three distinctions, my lord, the rest of the set offs are not, my lord, relevant because it ultimately deals with set off in IBC. So, my lord, here, no contractual set off, no equitable set off because it's not, my lord, arising out of the same transaction. My lord, whether it's ascertained sum of money or not will be decided in arbitration.
Yes.
Now, my lord, my learned friends had, my lord, threatened to ultimately withhold monies from my other bills or to recover monies from my other bills. Now, my lord, when I filed this writ petition, thereafter, my lord, curiously, my lord, perhaps realizing as to what is the law of the subject, my lord, they have, my lord, released the current bills that are, my lord, pending payment. But, my lord, the threat as to, my lord, whether they will adjust from, my lord, the future bills, my lord, because I'm continuously supplying to the railways. Well, that is, my lord, in question. And, my lord, what they have done, for which, of course, I'll have to approach another forum. Now, my lord, because of this, they've stopped taking delivery of wagons for which, my lord, orders had been placed, wagons manufactured and put, my lord, in inspection made and put in readiness for delivery. Well, I am only, my lord, presently concerned with this. I'm troubling my lordship with only this. The law is clear, and my lord, Raman Foundry and my lord, Kamaluddin Ansari were both discussed in Gangotri Enterprises. I think I should just, my lord, for completeness, show your lordship that one judgment.
What about the arbitration?
Arbitration, my lord, will decide as to whether, my lord, we have already given a section 21 notice. My lord, we have already initiated the process. My learned friends are...
Then you could have filed in section 9.
Well, section 9 will decide, my lord, as to whether, my lord, there's any sum due payable, whether they can attach or not. But, my lord, presently, what they're doing is, my lord, they are trying to adjust my claims, my lord, in respect of wagons supplied for, my lord, their claims in respect of, my lord.
Correct.
My lord, they cannot do that. In law, they cannot
If
do
you given the section 21 notice and they are not appointed and they issued the notice, you
Well,
can take
that
the
is-
course of the
my lord, that is a
arbitration.
subject matter of a different contract. My lord, this will not be subject matter of that arbitration. No. My lord, this is, my lord, a claim on account of, my lord, siding payments due. My lord, so far as this is concerned, my lord, as to whether any payment is due or not, my lord, will be decided in arbitration.
Correct.
But, my lord, here what they're trying to do is, my lord, the purported dues, they're trying to adjust from another contract which is not the subject matter of arbitration. My lord, the wagon contracts are not subject matter of arbitration. That is, my lord, the difficulty. That is, my lord, why I had to trouble you.
Party sir approach several time making so or tell him, but the party is not trusting, delaying the make. Under this, it is requested to adjust the above amount of existing pending dues. It is open,
Yes.
not in the same contract.
Different contract. That is why otherwise I would not have troubled you, lords.
Yes.
Now, my lord, my learned friends have, my lord, already paid some of the bills after I filed the writ petition. But, my lord, the other bills, my lord, pending contracts, my lord, everything is, my lord, subject to it. Well, all that I'm praying is, my lord, your lordship will, my lord, kindly, my lord, stay the operation of, my lord, this, my lord, letter. My lord, that is all that I trouble your lordship with. And, my lord, Raman Foundry has been considered, Kamaluddin Ansari has been considered. Lately, my lord, by Gangotri Enterprises. Just allow me to show this one judgment. Well, there are so many, my lord, judgments on this. I don't want to trouble your lordship. Well, please just... এটা হলো 2016 11 SCC
2011 SCC
2016 11 SCC
2011 SCC
2016 page 720. Well, if your lordship will please have a look straight away to, my lord, paragraph 36.
Yes.
My lord, this is, my lord, what was the, my lord, ratio of Raman Foundry. Justice Bhagwati was speaking for the bench in Raman Foundry, examined the issue in great detail. The learned judge, in his distinctive style of writing, after examining the entire case law on the subject, held that the expression sum due occurring in clause 18. Well, that was contractual setup. Clause 18 would mean a sum for which there is an existing obligation to pay in present time, or in other words, which is presently payable and due, and therefore recovery of only such sums can be made the subject matter of clause 18. Well, that was the Raman Foundry decision. Then, my lord, please see paragraph 37. Their lordships in Raman Iron Foundry case approved the view taken by Justice Chagla in Iron and Hardware India. Then, that portion is said. The same view has also been taken consistently by different high courts. If your lordship sees, just after that, there's a portion in courts. This is quoting from Bombay. In my opinion, it would not be true to say that a person who commits a breach of the contract incurs a pecuniary liability, nor would it be true to say that the other party to the contract who complains of the breach has any amount due to him from the other party. As already stated, the only right which he has is the right to go to court of law and recover damages. Now, damages are compensation which a court of law gives to a party for the injury which he has sustained. But, and this is most important to note, he does not get damages or compensation by reason of any existing obligation on the part of the person who has committed the breach. He gets compensation as a result of the fiat of court. Therefore, no pecuniary liability arises till the court has determined that the party complaining of the breach is entitled to damages. I'll not read the rest of it. Then please come to paragraph 39. Now, similar clause, my lord, was there in this case. Now, coming to the facts of the case at hand, we find that the wordings in clause 62 of the contract in question, with which we are concerned, is identical to that of clause 18 in Raman Foundry case. Clause 62 of the GCC provides for determination of contract owing to default of contractor. Relevant portion of clause 62 reads as under: the amounts thus to be forfeited or recovered may be deducted from any monies then due or which at any time thereafter may become due to the contractor by the railways under this or any other contract or otherwise. Well, this was the clause, and the court said that no, it has to be a liquidated debt and decide. So, my lord, what we are dealing with in Raman Foundry, in Kamaluddin Ansari, in Gangotri is a question of contractual setup. For there must be a clause. There is no such clause in the present contract. Equitable set-off cannot be done because it must arise out of the same transaction. So, my lord, neither contractual nor equitable set-off. Then, my lord, the question is on what basis have they written this letter, my lord, claiming to, my lord, adjust, my lord, their purported dues on account of maintenance and inspection charges from my bills for, my lord, wagon supply.
Yes.
Now, my lord, don't have any, my lord, here now bills have been currently paid, but my lord, apprehension continues to subsist. And my lord, your lordships have held that, my lord, I can approach your lordships even on the basis of, my lord, an apprehended injury. That's a quiet time at injunction cases, my lord. I have the judgments, but if your lordship, I don't think it's required.
Yes.
Well, that is all. My lord, I'm just paying an injunction on this, my lord, 3rd July 2026, my lord, communication. At, my lord, page 164. Well, they should not give effect to the portion after, my lord, the table.
Yes. Yes.
I'll kindly come to the page 164, my lord.
Yes.
Well, that is dated 3rd July 2026, my lord. Well, kindly come to the chart portion.
Yes.
1, serial number, name of the party, nature of charge.
Correct.
Well, kindly come nature of charge. What is the nature of charge? Maintenance and inspection.
Correct.
Then, my lord, the period 2017, 2018 to 2021, 2022.
Correct.
And my lord, amount 1 crore 18 lakhs 34,000 and odd, my lord.
Yes.
So, my lord, the main amount 1 crore 18 lakhs, that is in respect of maintenance and inspection charges, that is for the year 2017-18 to 21-22.
Correct.
Then, my lord, kindly come to the next OHE maintenance charges. My lord, that is overhead equipment maintenance.
What?
Overhead equipment maintenance. Because, my lord, they are, my lord, the engine, railway engine, or they are entering there, my lord, for carrying the wagon, or, my lord, their goods, etc., my lord.
Yes.
And, my lord, that is for the period 25th October 2022 to 24th October 2025. That amount is small, my lord, 14 lakhs or not.
OHE overhead?
OHE, my lord, that is overhead equipments maintenance charges.
Yes.
My lord, next interest and maintenance.
Yes.
Second is OHE maintenance charges. So my lord, the main amount is 1 crore 18 lakhs, that is in respect of maintenance and inspection.
Correct.
Then your lordship kindly come to the page 58, my lord.
Yes.
Page 58.
Yes.
Your lordship kindly come at the top Eastern Railway. Your lordship got it, the middle.
Yes.
Then my lord, the private siding agreement. This is my lord very vital. This is private siding agreement, and that agreement was executed on 25th day of September 2019. Then your lordship kindly come to the one clause of this private sided agreement, that is clause 8. Just now, my learned senior friend, that has been shown, my lord.
Yes, maintenance.
Page 68, my lord.
Yes.
That is maintenance and other charges.
Yes.
For the portion of siding within railway land. For the portion of siding within one, the applicant shall also pay the railway administration towards the ordinary maintenance of the said siding within railway boundary, colored red on the said plan. That is permanent way, subgrade work, etc. at such rates as may be fixed by the administration from time to time. Such charges shall be paid in the advance within 7 days after every 31 days of March. Such yearly payments shall be included all items up to the last date of respective financial year, provided that the entire cost of recoupment of blast, renewal, replacement of strengthening of the permanent way, etc. shall be deemed to be special repair, and the applicants agrees to pay on demand the full expenditure incurred by or through the railway administration on this account. For this purpose, the railway administration would prepare an estimate based on actual expenditure, which would include the departmental charges as per the extent rule. So, my lord, in the private siding agreement, they are agreed to pay the maintenance charges. That is the main charge. And my lord, the another, that is OH charge, that is overhead equipment charge. My lord, that was installed later on. Kindly come to the page 140, my lord.
Yes.
They have admitted their own. My lord, that is the letter dated 24/11/2025 at the top.
Yes.
And my lord, that agreement was executed in the year of 2019.
Yes.
Then my lord, kindly come to the first paragraph, my lord. That was later written by the petitioner to the railway, my lord. We acknowledge receipt of your letter addressed to the senior divisional commercial manager dated such and such, and are surprised by its contents, particularly the demand of payment towards the maintenance and inspection charges for the OHE installed at our private siding on the premises that is being treated as cargo terminal. So, my lord, after the execution of the agreement, that overhead equipment was installed, and according to the railway freight marketing circular, my lord, if the OHE is installed, my lord, they are also bound to pay because if maintenance is not there, the overhead traction line or everything, then my lord, the factory shed cannot be operated. So, my lord, that admittedly on the agreement also the maintenance charge they are bound to pay. And my lord, thereafter, my lord, the OHE was installed. And my lord, kindly see. My lord, kindly see that one meeting was held. My lord, then my lord, kindly prior to that, my lord, one meeting was held in between the petitioner's representative and the DRM at the DRM office of the high officials of the railway regarding this demand. And my lord, they have admitted the demand, and they, my lord, promised to pay the demand within 2 installments.
Where is the minutes?
My lord, the minutes was not there, but my lord, they have.
They have paid. Where is
Yes.
the minutes?
They have, my lord, agreed.
Where
That
is
is
the
my
minutes?
install. No, my lord.
If they have
Minutes.
minutes, and they have.
Yes, that is not with me. That is.
No, it is there, then I will fix tomorrow, bring the minutes if they are agreed to that.
No, my lord, no, on that day,
Calcutta
my lord, only my lord, oral discussion was held. And my lord, orally, they have promised to pay that within the 2 installment. And my lord, kindly come, the page 165, my lord.
No, but you're referring the page 140.
Yes, my lord, 140. My lord,
sorry.
only to show that line that the OHE was installed.
But you kindly come to the 140 last paragraph.
Yes.
Read the last paragraph.
Furthermore, we had never request to OHE installation at our private siding at the same was provided by the railway on its own approach. And we were also assured that all costs towards this will be borne by the railway. Therefore, we failed to understand that the new demand notice for maintenance charges being raised on us. Then, my lord, kindly for a moment, kindly compare the page 164 once again.
Yes.
So, my lord, there is the 2 part of the bill. One is maintenance according to the clause 8 of the private siding agreement that is admitted, and they are disputing regarding the OHE maintenance. My lord, because why? Because my lord, this is that was installed later on after execution of the agreement.
Correct.
That amount is small.
Correct.
So, my lord, they are bound to pay.
Correct. They are bound
Yes.
to pay. But how you can adjust from the existing bill? Where
Yes.
there is a contact,
Yes,
show me
yes,
there
my
is
lord,
a contact and-
kindly consider one thing. That was pending since 2017-18.
Correct.
Admittedly, that is pending.
Correct.
So, my lord, this is the revenue earning, my lord, sector of the railway.
Correct.
Otherwise, how the government will move, my lord?
Correct.
My lord, kindly consider that. And my lord, kindly consider the last annexure, page 165.
Yes.
Page 1, I am not facing the entire, my lord. That was written on 11th of July 2026.
Yes.
That is the representation of the petitioner to the General Manager, Eastern Railway.
Yes.
That was written on 11th of July 2026. Then your lordship kindly come. The page 166, last paragraph.
Okay.
In view, my lord, page 166, last paragraph. In view of the aforesaid, we demand justice for your good self and request your, my lord, my copy is not at all legible, my lord, to
Not
take any coercive steps or make any adjustment from our other bills pending the aforementioned dispute
resolution of the
through
aforementioned
mutual consultation or through arbitration.
Correct.
My lord, mechanism provided under clause 34 of the private siding agreement. My lord, I have just now shown the private siding agreement, and my lord, kindly see there is also, my lord, at page 84. Page 84, there is also, my lord, page 87, my lord, sorry, page 87,
Yes.
clause 34,
Yes.
that there is an private arbitration clause is there.
Correct.
And they also demanded for that. And my lord, kindly consider one judgment, my lord. In this matter also, my learned senior friend was also appeared. That is also in respect of private siding matter. My lord, that is a judgment order dated 5/4/2022. My lord, I am placing, my lord, from the first paragraph. The writ petitioner are aggrieved by a demand raised by the railway for use of railway siding. There are 2 categories of such siding. One is assisted siding and the other is private siding. A demand for about rupees 8,58,30,000 odd has been raised on the petitioner by the railway. Mr. Saha, learned senior counsel for the petitioner, argues that the petitioner has been using the siding for a substantial period of time since 1994 and has been paying maintenance charges and interest. The impugned demand is based on a new policy decision which is not binding on his client. It is also submitted that the petitioner are willing to enter into a written agreement or contract with the railway for the aforesaid siding. The learned counsel for the railway states that there has been a contract between the parties in respect of the siding, which are also contained an arbitration clause. The court is court is of the view that the matter falls in the realm of the private contract between the railways and the petitioner. The demand raised by the railways cannot be gone into the decide by the court, since to involves disputed question of facts requiring a trial by evidence. For inter alia, the reason stated herein above, the writ petition cannot be entertained, reserving the right of the petitioner to approach civil or other forum. The writ petitioner is disposed of without any orders.
Yes.
So, my lord, in this contract, there is also private siding agreement. Whatever may be the demand railway raised, my lord, that is on the basis of that agreement, my lord.
Yes.
Private siding agreement. And my lord, there is also an arbitration clause. They have also, my lord, page 166, last paragraph, my lord, they have also raised this arbitration clause. And my lord, the meeting was also held. Thereafter, my lord, they have filed this writ petition. So,
I'll take just 1 minute. My lord, overhead equipment maintenance charges, that has been exempted. My learned friend should have showed that, page 141. 141. Look, that has been exempted clearly. If your lordship sees page 141, third last paragraph, accordingly. Accordingly, the provision of levy of overhead equipment maintenance cost in respect of BESCO Limited, private siding Baripur is not applicable and is to be exempted. So, my lord, that goes. And my lord, in that, my lord, demand letter, your lordship sees they are claiming for it. Although they've exempted it, clearly. That's number one.
But Mr. Shah, in the representation, you also requested for the arbitration.
Yes, and my lord, I have also gone to arbitration. My lord, what is the subject matter?
Why the writ court can
No,
entertain?
my lord, what my learned friend has relied on judgment, I also will rely on the same judgment. What is my lord story? As to whether any amount is due or payable or not, will have to be decided in arbitration.
Correct.
Now, my lord, what they are trying to do, they are trying to appropriate their, my lord, dues without any adjudication as to whether the due is payable or not. My lord, from my lord, bills in a different contract. Now, my lord, Kamaluddin Ansari has said even the arbitrator cannot direct, my lord, adjustment of one, my lord, bill under one contract, my lord, from another bill of another contract. My lord, please just see, my lord.
Probably section 83 of the Railway Act, there is a provision, my lord. If there is any railway dues, that can be adjusted from the other things.
Let my learned friend show it.
My lord, just now, my lord, that act is not with me. But my lord, that arbitration clause, my lord, everything I have submitted.
No, arbitration clause is there, but the problem is that your notice for demand is not with regard to the pending bill of the present.
Yes, my lord, but admittedly that maintenance charge you have to pay.
Notice of demand is with regard to the open contract, whatever the pending bills. That means whatever 2-3 contracts are there. So if the 2-3 contracts are there, and it can be realized whether the arbitrator can decide that issue.
That is exactly the point.
Then, my lord, for a moment, my lord, kindly take it at 2 p.m. or my lord, tomorrow I shall show that provision.
Paragraph 10 only, my lord. Your lord,
I shall show that provision.
That is exactly what is answered. Well, let's please say only paragraph 10. Clear answer to, my lord, your lordship's query and what my learned friend is arguing. While, I'm sorry.
Yes.
While construing the scope of section 41B of the Arbitration Act, my lord, this was the old act.
Old act.
The court has therefore power under 41B read with second schedule to issue interim injunction, but such interim injunction can only be for the purpose and in relation to the arbitration proceedings. The arbitration proceeding in the present case were for determination of the mutual claims of the appellant and the respondent arising out of the contract contained in the acceptance of tender dated such and such. The question whether any amounts were payable by the appellant to the respondent under other contracts was not the subject matter of arbitration proceedings. The court obviously could not therefore make an interim order, which though ostensibly in the form of an order of interim injunction in substance, amounted to a direction to the appellant to pay the amounts due to the respondent under other contracts. My lord, that is, my lord, my problem. Well, even if I go to arbitration, the arbitrator cannot direct as to whether they can appropriate, my lord, these dues from other contracts or not. That would be beyond, my lord, the jurisdiction of the tribunal.
Yes, where is the contract? Where is the term of contract that the amount
Yes,
to be
yes.
realized
My lord,
from?
that provision is there, my lord. Kindly take it at 2 p.m. my lord. I shall show.
Where is the provision?
My lord,
Section 83 of the Railways Act.
And my lord, according to the railway finance code is there, my lord.
Well,
My
let
lord,
my learned
kindly,
friends know
kindly,
what they're
no, no,
trying
no,
to
no, my
learn.
lord,
I'll-
kindly, that copy is not with me. Actually, what happened, my lord, at the morning I have received the brief.
Okay, no problem, no problem.
Yes, my lord,
You-
according to me, I have prepared myself. My lord, that copy of the finance code,
Come tomorrow with
yes,
that, what is?
yes, that,
But-
I
but-
know, my lord,
I
that.
don't think tomorrow
no,
anything we will
No,
realize.
no. I,
Come tomorrow with this point.
Yes, yes.
Is there any agreement
well,
for?
I will only request my learned friends to, my lord, let my advocate and record know, my lord, what is
Yes,
that
if
they rely,
you
so that I
please,
can.
please give the mail to the other.
Yes, yes,
Get your-
I shall,
like what you
definitely.
said.
And counsel for the respective parties have argued the matter at length with regard to grant of interim order. Learned counsel for the respondents place for time to place the record whether there is any agreement between the petitioner and whether there is any contact between the parties that the railway authority can realize the due of the alleged due from the petitioner to the other contacts, if any, pending before the authorities.
May I keep the affidavit on service?
Let the matter appear tomorrow under the same heading at the top.
And
Affidavit
my
on
lord, I
service.
am also relying, this, that is also, my lord, identical matter.
Yes, I will. That's why I'm asking.
Yes, yes. Grateful.
Grateful. I don't know.
Non-compliance of an order passed by your lordship's court. This is
Good.
the sum and substance.
I'm extremely sorry, my lord. Tomorrow morning, my lord, tomorrow morning I will have some difficulty. My lord, may it be on Monday then.
Then
I'll tell
inform Monday.
My lord, I'm grateful. my lord. I'm grateful.
Monday.
Inform the other side.
Yes, I will.
I have already done this for his behalf. Three parties.
Yes.
Well, kindly come to page 215.
Would not incline to intend to marry it at such belated in the event of the interest for extension of the term of.
Paragraph 5.
Yes.
What happened, my lord? Your lordship is aware of these line of matters where rate has not been fixed. That's why lordship's court passed. No tender should be issued. On the contrary, one contract was concluded.
Monday.
One tender was concluded. Thereafter, my lord, it started a phase. We say, why I have been excluded? I am also in the same footing. You consider me, my credentials. If you think I am not matching, then exclude me. I approach your lordship's court. There, my lord, relief was not granted on that date because of already the execution has been effected. Paragraph 5 says, in the event the authority intends to an extension in terms of the present bidder, then the case of the petitioner may be considered. I am asking, my lord, when you are considering the extension, I consider my standard.
Yes.
Nothing done.
Yes.
I have not been called. In the next page, my lord, I have given a representation to them, communicating the order of Justice Sinha, and requested them, whenever you consider extension, you kindly call me. Period expired on May
May 25.
27.
27, it is going to expire.
No. May 2026.
27 May expire করে গেছে
That I'm saying. Expired on May.
formal extension দেয়নি
Now what remains?
No. Earlier, so if you going to give extension again, because in view of lordship's court's order, no new tender can be.
Okay. You tell that, okay, that has not been complied. No, in future it should be.
That is the order of your lordship's court. I cannot go beyond that. So even that they are not. So at this I should be considered before extension. That's the order.
Yes.
Late by Mr. Srijit Chakraborty.
Huh?
Late before code number 20.
ওই তো
Yes. Yes, Mr. Chakraborty.
কি বলছেন
এইটা কনসিডার করে তাই কনসিডার করে
there is no scope there is no scope
No scope.
very
No, whether you
tactfully prepared writ petition
whether you are going to a fresh tender or you are going to extend.
if you are extended, no problem.
That's why if you are going to extend, going to fresh.
Even if I'm going to extend, he should not get an opportunity.
Why?
But kindly sees what is the aspect of the matter. Just give me 2 minute breathing time, Milord. Milord, the technical bid tender was issued on 11th May 2023. Technical bid rejected on 11th November 2023. He challenged the rejection. Justice Sinha did not interfere. Justice Sinha says, yes, page 215. Justice Sinha was of the view that the court is not inclined to enter into the merit of the case of the petitioner. In the event the authority intends to extend the term of the present bidder, then the case of the petitioner may be considered along with subsisting bidder, provided the petitioner possesses the requisite qualification. Has not made the existing bidder a party.
There is no bid.
Now, may I just clear it? There is an existing contractor who is going to do the work. He failed to qualify from 23, he is continuing. The tender period expired on 2026. His case is, as per Justice Sinha's order, he gets another opportunity so that his case is considered. He failed to qualify the tender, can you consider? This is a roundabout way he wants to enter into the process, which in my humble submission is not permissible. If you have failed to qualify, you have failed to qualify for the bid. You cannot enhance your qualification and later on will be considered. In any event, my instruction is that we are going for a fresh tender. That's the instruction, Lord. I knew.
Done. My lord knows very well.
So I can't first tender.
Yes, you cannot.
Yeah, I cannot go. I am the employer. I cannot go for a first tender. Say, I don't know many things. I don't know many things. I am the employer. I cannot go for a first tender. I have to accommodate Mr. Basu. This is something absurd I am hearing, Lord, with greatest respect. I can't go for a tender. I am the employer. You want to work under me. Whatever. I want to go for a tender.
Yes, I can.
I want to go for a tender for the interregnum. The person who was continuing, he has been given an extension for 1 or 2 months. Maybe it expired on May. Kindly sees, Lord, the instruction. Kindly see. No, that is why I got the instruction overnight, because otherwise I would have suffered an interim order. I knew this is the thing.
25.
On court 25. Because I know the pulse of the court, and in these direct tenders, they will continue forever. Till eternity will come, they will only supply. No one else will come. This is the ploy.
Yes.
Nothing. I've said that. I record that.
My lord may record. My lord keeps the instruction, can you record that?
They are going to issue the.
Dekhen, ki bola dekhen.
The
Sir,
petitioner has filed the present.
required information, data regarding preparation of new tender will be available soon.
Soon money.
No, they are dead dite pari na kiya.
By this court. Dated 13th June 2025, W.A. 2699 of 2024.
আমি জানি না, instruction দিয়েছে দিয়ে দিল। ESI state এর part তো, state এর part তো। ESI state এর part তাহলে আমাদেরকে ব্রিফ দিয়েছে কেন? না তাহলে আমার
And counsel for the petition submit that
state দাঁড়াতে পারে।
the existing
আবার বিপদে পড়ে যাবে, অনেক ঝামেলা।
on 11th of May, 28th of May 2026.
Lord, only one. May I take a lordship leave, Lord? I'm grateful to Lord.
8th of May 2026. And the petition came to know that the authorities are going to extend the contract calling for a fresh tender. And as such, in terms of the order dated 13 June 2025, the petition is also be entitled to consider his case for extension of the contract, if any, made by the respondents instead of calling for a fresh tender. Learned counsel for the respondent authorities has handed over the instruction dated 22nd of July 2026, where it is mentioned that on the earlier tender of 2023, the petition was disqualified. Now the existing tender was also expired on 28th of May 2026. The administration has started procedure for calling for a fresh tender through the GEM. Considering the full stop. It is a specific case of the respondent authorities that the respondent authorities are going to start a fresh tender And for the time being, only they will allow the present contractor to continue the said contract till the present contract.
MPO respondent number 3 to
when the
MPO.
process is started is completed.
My lord, may keep the instruction on record, my lord.
Considering the above, this court finds
MPO
that
ta
it is a specific case of the respondent that the respondents are going to
MPO ta ki?
issue the press tender,
Member comes over
notice for participating of the competitive bidders to participate in tender, in which the petition will also be entitled to participate if he is otherwise qualified. Considering the above, this court did not find to pass any further order in the present
My lord.
litigation. Accordingly, petition is disposed of. The written instruction dated 22nd of July 2026 we kept with the record.
My lord.
In the meantime, what is the 1 year or 2 years?
Within 1 and 2 months. Yes.
Lord, that time limit or 1 or 2 months, my lord may record. No, I have, it doesn't say that it is 1 or 2 months. My lord may record, my lord, as early as possible. Because otherwise to float the tender, it may take some time, my lord. My lord can records within a reasonable time.
For the time being.
Huh.
For the time being.
And we'll float the tender within a reasonable time.
That's all. Then
Because
why is muted?
it might take some time, so it takes.
Okay, thank you.
But I have told him that you have to come with instructions. Otherwise, you will be in trouble.
After the petitioner, my lord. My lord, I'm telling your lordship the nutshell in the, my lord, the.
Where is the affidavit?
My lord, this is the affidavit of service.
Who are the respondents? How many
Lord.
respondents?
27. My lord, 27, my lord.
Huh?
27, my lord.
How many petitioners?
My lord, petitioners, my lord, 27, my lord. Sorry.
How so many petitioners?
My lord, I'm just telling your lordship the facts. My lord, all the petitioners were, my lord, appointed, my lord, pursuant to the order of this honorable court as, my lord, assistant teacher in the primary school.
Correct.
My lord, thereafter, my lord, in 2025, my lord, they, my lord, were appointed as untrained candidate because it was, my lord, related to, my lord, recruitment process of 2009. My lord, at that time, my lord, the untrained was allowed to, my lord,
continue.
My lord, now, my lord, the mandate of the, my lord, the central government and the, my lord, the RT Act, Right to, my lord, Free and Children's Compulsory Education Act, my lord, every teacher has to, my lord, undergo the training. My lord, as per the, my lord, rules, my lord, from the date of joining, within 2 years, I have to complete the training course. My lord, the training course, my lord, said, my lord, known as DLED, my lord, Diploma in Elementary Education. My lord, the petitioners, my lord, as soon as my lord got the appointment, pursuant to order of this honorable court, joined in the my lord DLED course with taking no objection from the my lord the concerned school where my lord they are working as assistant teacher. My lord, the course is for 2 years. My lord, the sessions for the course is 25-27 session, 2025 to 2000. My lord, the petitioner has to, my lord, completed the course, my lord, by 27 within 2 years. They will not even get a, my lord, the another chance or another year. Otherwise, they will lose their job. Simply, my lord, they will lose their job. My lord, they are, my lord, this is the, my lord, position. But what happened, my lord, after this, my lord?
So you have been appointed and you have taken no objection from the school for going for the training for the 2 years.
Yes, this is the regular course. My lord.
So with the 2 years, what is your position in the school? You have to remain as a teacher.
No, I'm just telling your lordship. My lord, as soon as we, my lord, joined in the, my lord, this training course,
correct,
my lord, school has given us no objection to join,
correct,
because my lord, school has released us because it is a regular course.
Correct. That's what I'm telling.
Yes, this is a regular course.
Whether you got the study leave or you have left the post.
No, not left the post.
So
we are getting the
study leave.
Yes, we are for the purpose of this 2 years course. School, my lord, has released us. Not only school, my lord, the consent.
Release is 2 types. Release, either you resign or you have been awarded, you have been given the study leave for the 2 years.
By the order of this honorable court. My lord, your lordship, kindly, my lord, come to my lord, page 62. My lord, this is my lord, the order for release by the sub-inspector of school. My lord, your lordship, kindly, sorry, my lord, I'm sorry, my lord, 56, no objection.
Court order পড়ে your lordship kindly come to page 49 the order of the honorable court once your lordship kindly come
49.
49 it starts from the 49 its relevant page is 53 I'm reading paragraph 8. The Commissioner of School Education West Bengal, in consultation with the West Bengal Board of Primary Education and all concerned district primary school councils, are forthwith publish on their respective website a consolidated list of eligible untrained teachers along with recognized institutions, including government-sponsored, government-aided, and government-recognized self-finance institution offering the DLED course. Admission shall be allowed with preference to availability within the teacher's home district and if not possible in nearby districts so as to ensure minimal hardship. The entire admission process, including the relaxation of the academic eligibility condition, must be completed within 12 weeks from the date of communication of this order. The Commissioner of School Education shall also file a compliance affidavit before this honorable court within 14 days. Now, the next paragraph, the relaxation direction contained here in the issued only for those in-service primary teachers appointed pursuant to the recruitment process initiated in 2009, whether appointed earlier or pursuant to later court directions and shall not be treated as precedent for future recruitment within the following pursuant to this they join. Thereafter kindly come to page.
Content therein issued only the in-service teachers appointed pursuant to the recruitment process, whether appointment. Yes.
Then your lordship kindly come to page 56. They were also entrusted the duty of the election. This SIR they are
As a teacher.
Yes.
As a teacher.
As a teacher.
And you are getting the salary.
Yes.
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 So now what is the problem?
Yes, the problem lies. Your lordship kindly before that I will show your lordship the since fallen from your lordship the no objection page 62. Your lordship kindly comes once page 62.
Yes, certificate issued a request from the purpose state of is requested to obtain release order.
Nature of appointment regular. Your lordship kindly mark nature of appointment regular pursuant to recruitment 2009 order of Honorable High Court Calcutta status in service primary teacher.
Correct.
What your lordship?
Correct.
The council has no objection
Correct.
to his or admission pursuant to DLED course 25-27 as per notification of the West Bengal Board of Primary Education compliance with the order of the Honorable High Court Calcutta. This certificate issued as his request the person state above he is also requested to obtain release order for the purpose of 2 years DLS course from the respective sub-inspector of school. This is a order from the appointing authority. Thereafter the immediate officer of this the
they got
teacher,
no objection.
Everything. Then the predicament is now we have completed the first year course. Correct. By this time.
Correct.
The examination is scheduled to be held not yet notified but scheduled to be held in the mid of August. In the meantime what happened your lordship kindly come to page 85 the impugned order. This is the is troubling us. Your lordship kindly come to page 85. May I read your lordship? In pursuance of the instructions received from the competent authority regarding implementation of Annapurna Yojana and for the purpose of collection, verification and field level verification of family data under the said scheme, the following person who has already been appointed as booth level officer, I have shown your lordship that they were appointed as BLO, is also engaged at his her assigned booth area for verification and validation of the family data for Annapurna Yojana within Swarupnagar development block with immediate effect and until further order. Because of this this entrustment, I have to go I have to attend regular the colleges, the classes, and as well as I have to face the examination. I have to appear in the examination very within a few days it will be notified and I have to appear. This is the position, I cannot maintain two things, this duty of Annapurna Yojana. The rule says
how many entered teachers were there and how many teachers have been released for completing the delete course?
Untrained teacher. They are in the district of North 24 Parganas. Now they are undergoing 300 and 400. 300 to 400, exact.
How many teachers have been assigned the duty?
Malad, I can tell you, Lordship, Malad, those who have come to me, Malad, I can, Malad. Otherwise, Malad, in the different, many teachers were, Malad, there are so many teachers, Malad, those who are not even, Malad, doing these, Malad, sessions, Malad, they were not assigned this job. They are left out. But this is the predicament. Malad, I tell you, Malad, being an officer of the court, Malad, I tell you, Lordship, Malad, section 27 of the RT Act, Malad says, Malad, that the teacher is, Malad, obliged to, Malad, do this, the census and as well as the election duty. Malad, I cannot, Malad, say no. Malad, I have to accept being a teacher. Malad, I am no quarrel with this. But the peculiar situation is now, Malad, this is the Annapurna Yojana is not as per the Malad, this Central Act or anything. Malad, the Central Act specifies that other than academic, no one cannot be engaged in other except Malad, the census and election duty. These two. Even Malad, today Malad, also some of the petitioners were Malad giving the Malad this
So your classes is going on still, or you are in study leave?
Malad, classes are going on. Classes are going on because it's a 2 years course. 2 years course.
2 years course.
First year and second year.
So these are first year.
First year is going on. This Malad, August, mid of the August, the first year examination will be there. Malad, this examination throughout the state of West Bengal, the one examination. But this is the situation, Malad. I come before your Lordship, Malad, to give us protection. Some
The department called me to take some time for this matter, my lord.
How you
Past
can-
inquiry, my lord.
Correct. See, you can assign the duty, but see the circumstances. You have released the persons to complete, and that is the 2 years is the main. And the 2 years, if this year they will go for the enumeration on whatever the duty,
Yes, my lord.
and they will not able to attend the exam. So what purpose would be served? Their 1 year will be wasted.
My lord.
Post the persons who are already conducting the training, undergoing training.
Yes, my lord. For that reason, they want some time to
So when they have to join duty,
Malad, already there, Malad, I do not know, Malad, Malad, within 2-3 days, Malad, the training is also, Malad, going on.
that their attendance will also be short. Then what will happen?
And Malad, another, Malad, I just disturbing your Lordship, Malad, another predicament.
Monday, my lord, I shall
Take instruction?
Yes, my lord.
Because see, these are the peculiar circumstances
Yes, yes.
in terms of the order passed by the High Court.
Yes.
They have been released. They are continuing as the primary school the assistant teacher. Correct. Assistant teacher.
Malad, assistant teacher in the primary school.
In the primary school. And they have to complete their 2 years delayed training. And they have been released. And they are pursuing their training. And August is the exam. And the training is as a regular student, not with regard to the correspondence or sitting
No,
or
ma'am.
private.
Regular.
If it is a regular student and the exam is there, so how it is possible?
Yes, ma'am.
Correct. And you are released from the school, then how you can pass this order for giving the duty of the what Annapurna Yojana census?
Yes, my lord.
But I have also filed the deficit court fees, my lord.
Is that to all?
Yes, I have filed.
Petition has filed affidavit of service and the deficit court fee. That's a record. The petition argued the matter of the net counsel for the state press for take instruction from the authorities. Why the petitioners who are pursuing the training of 2 years of DLED, DE?
Malad, D full stop, EL full stop, ED. Diploma in elementary.
DLED course for 2 years. 2 years, and the examination is as a regular student, and examination is to be conducted in the month of August 2028, 2026. 6. क्या बोला? It is to conduct if the petitioners have been given the duty of census of duty for implementation of the Annapurna Yojana, the study of the petitioners will be hampered and not be in a position to appear in the examination, which is likely to be conducted on month of August 2026. Let the instruction be placed before this court on 28th of July 2026. This is the matter on 28th within 10 matters. Next.
Grateful, my lord. Deeply obliged.
Eight, my lord. Mr. Rajdeep Muzumdar, my lord, is appearing, my lord, for the petitioner.
Yes.
Mr. Rajdeep Muzumdar, my lord, is appearing for the petitioner, my lord, item number 8. But he has only.
Lordship, I am appearing for the state in
Just
this
one minute.
matter.
I'm just requesting that if this matter could be taken up at 1 o'clock, my lord. My only request.
The two matters are there, sir.
Oh, my lord, if it could be then taken up at 2 o'clock, I can only request, my lord.
Other matter is also there.
My lord, it was
What
actually
is the matter?
very short matter, my lord. We are a, my lord, brand, my lord, we are a company before your lordship, my lord, which has a brand which is renowned for serving biryani. Now, my lord, they have got operations, my lord, all across the city as well as, my lord, certain places in the world. Now, your lordship, the account in question, my lord, is our business account. Now, a sum of rupees 5,000 odd was paid by.
An account is business account on what? All account?
No, only this one particular account, my lord.
Imagine.
No, this particular account, lordship will be shocked, my lord. One customer, my lord, for the purchase of biryani pays 5,000 rupees, which, my lord, turns out to be that particular account from which 5,000 rupees was paid, turns out to be, my lord, one of tract of cyber crime. Now, the entire current account of this, my lord, Arslan, my lord, has been
And
frozen.
you also in the cyber crime. What you will purchase?
But now, but the customer comes and pays money to us, we are now, my lord, the entire account has been frozen. This is the short, long and short. I'm covered by your lordship's judgment.
Lordship, I'm appearing for the State Bank of India respondent number 2 and 3. Lordship, this freeze has been marked because the instruction came from the Karnataka police, Madiwala police station.
They will not return back.
Yeah. So, Lordship, we are obliged to do that, and the petitioner being a private entity, suo motu, we cannot unfreeze that account.
What is the disputed amount?
It's 5,116 rupees.
Keep the
Let the lien be marked on that, your Lordship, and
lien.
we are okay with that. We're fine with that, your Lordship. Let the lien be marked and
When you receive the information, have you disclosed that?
I have, my lord, yes, my lord. I have annexed it, my lord.
Where is that?
My lord, page number 27. If your lordship may kindly takes up. My lord, page 29, 28. I'm so sorry, my lord.
page number 28, 29th of April.
9th of April.
This was informed to us, my lord, on the 20th of June.
Now, where is the police report?
Page number 32, your lordship.
Page?
Page number 32.
My lord, I am covered. Like, if I can just place this, my lord, I'm covered by your lordship's judgment, my lord. Download notice under section 106 BNSS, and then bottom portion, my lord, put on hold. Disputed amount is 5,116
rupees.
5,116.
Yes, 5,116.
That's all.
Yes. Yes. That was a payment made by one of the customers, my lord, for purchase of biryani.
No, need not to purchase the biryani from the Arsala. Then you give the account of the purchase.
No, we are scared to buy biryani from them.
And when I'm covered by your lordship's judgment also. I'm giving that judgment.
Yes, I am disposing of.
Your lordship, just a lien be marked on that disputed amount, and
That will be kept in lien, and he may allow.
Lordship.
And if the investigating agencies.
My lord, this is your lordship's judgment, my lord. So I'm covered by that. First and the second judgment, my lord. Your lordship's judgment.
The petitioner has filed the present application praying for a direction upon the correspondent bank for defreezing the account of the petitioner maintained by the petitioner to defreezing the account of the petitioner. Counsel for the petitioner submitted the petition. These are current account or?
Yes, my lord. SBI current account.
Petitioner is maintaining the current account with the respondent bank. But all of a sudden, when it was freezed, my lord,
we found out on the 20th of June 2026. 20th of June 2026.
2026, the petitioner came to know that the bank, the account of the petitioner has been freezed by the bank and not allowing to operate the same. Accordingly, the petitioner has inquired the same from the bank, and the bank has informed the petitioner that the bank has received a complaint from Karnataka, Bangalore city. From whom?
Madiwala police station.
Calcutta, Bangalore city, Madiwala police station with regard to freezing the account of the petitioner, informing that there is a disputed amount of rupees 5,116 in the account of the petitioner. And counsel appearing for the bank submit that as per the instruction received from the investigating agency, the bank has freezed the said account. And counsel for the petitioner submit that the petitioner is maintaining the current account in the said bank for the purpose of business, and due to the freezing of the account of the petitioner, the petitioner is facing difficulty to run the business. He further submit that the only disputed amount is rupees 5,116, but the bank has freezed the total account of the petitioner. Total account of it. He further submit that if the disputed amount is kept in lien, the petitioner will not be prejudiced, so that the petitioner can operate the bank account with respect of the further amount lying in the account. The petitioner has relied upon the judgment in the case of Zenith Technologies Private Limited and others versus Reserve Bank of India and others, passed in WPA number 8453 of 2025, dated 6 May 2026. 2026. Which judgment did you have to verify? Two judgments of my lord. Another judgment passed in the case of Sanjay Gupta versus State of West Bengal and others, reported in 2025 SCC Online Calcutta. SCC Online Calcutta. And the judgment in the case of Karthik Yogeshwar Chatur versus Union of India and others, reported in 2025 HSC Online Bombay 4778. 4778. And the judgment passed by the Kerala, passed in the case of Headstar Global Private Limited versus State of Kerala, reported in 2025 SCC Online Kerala 3546. By referring to said judgments, the Land Council for the petition submit that all the courts, including this court, has held that if the investigating officer intending to freeze the account of the petitioner for the purpose of investigation, a written order from the magistrate is required under section 106 and 107 of the BNS 2023. He further submit that in the present case, the bank has freezed the account only on the basis of the written complaint received from the Karnataka police with regard to the freezing of the account of the disputed amount of rupees 5116. HON'BLE Land Council for the respective parties peruse the materials on record. It is admitted and the bank has freezed the account of the petitioner on receipt of the complaint from the Karnataka Bangalore City Madiwala police station with regard to the transaction of rupees 5,116 in the account of the petitioner. So the disputed amount is rupees 5,116. But on receipt of the said account, said information, said complaint, the bank has freezed the total account of the petitioner. Admittedly, the account of the petitioner is current account. Current account, and the petitioner is running the business. Current account. Admittedly, there is no order obtained by the investigating agency with regard to the freezing of the account of the petitioner. The judgment denied by the petitioner in the judgments mentioned about denied by the petitioner is squarely applicable in the present case, as there is no order from the magistrate with regard to the freezer of the account of the petitioner. Considering the above, this court find that considering the above, the bank is directed to allow the petitioner directed to defreeze the account of the petitioner by keeping the disputed amount of rupees 5,116 in lien, and and to allow the petitioner to operate the bank account. W feels disposed.
Only one more prayer, my lord. State of West Bengal may be expunged as a party. They are not a necessary party in this proceeding. But if it could be expunged, my lord, because Mr. Mozumdar was appearing, that is why, my lord. I am being led by him. That is, I am only beseeching, my lord.
Lordship, I am appearing for the state.
It is not a necessary. I have made it by mistake. I am expunging them as a party, my lord.
There is no problem, nothing. Yes,
Dip,
next.
like your lordship. Affidavit of service. Done.
This is my application, my lord. I appear for the petition, my lord.
Yes. Page 140.
Lord, I'm led by Mr. Kishore Dotto. He is on his legs, my lord. He is coming. May I start the matter, my lord?
Yes.
Lord, the issue involved in this writ petitions, my lord, we are praying for the release of the security deposit, which was deposited pursuant to an tender notice, my lord. If my lord kindly comes to page 44 for once, 44.
What is the prayer?
Yes, prayer is at page, my lord. Starts from page 38, my lord. The prayer B is still subsisting, my lord. We have prayed for setting aside of the letter or the order of 25th of December 2025, which is the impugned order, my lord, which is at page 62 of the writ petition. Prayer.
Because as to by the impugned order.
Yes.
Page 62.
Yes. Lord.
What is the order? 62?
Yes. The competent authority has imposed a penalty for rupees 1,73 lakhs and odd amount for 5 weeks delay in completion of the part B with respect to a tender and for the recovery of the diesel escalation for the period of so and so to so and so of rupees so and so, which comes to total rupees of 3 crores and odd amount, my lord.
177 and 173.
Yes.
3 crore 50 lakhs.
Yes.
Then.
Now, my lord.
Then penalty recovery, the bill amount 163, the amount deposited by 1 crore 80 lakh, 87.
Yes.
Now 187 is due.
Due. They are trying to recover that amount from us, my lord. We have completed their work, my lord. We have completed their work pursuant to a tender notice of 2011. We are entitled for the money. Now they say that they needs that amount of money which needs to be recovered from us.
From
now,
the same
lord,
contract.
Yes.
From the same contract.
From the same contract, same tender.
Okay.
Lord, kindly comes to page 44 for once, my lord. This is the work order. Page 44. Lord, this tender has two parts, my lord. First,
44.
Yes. The subject says that work order for the work of hiring of so and so for so and so patch and removal of OB with respect to certain area, my lord.
Yes.
So, my lord, the tender was divided into two parts, part A and part B. Part A was for the upper portion of the soil, which we need to remove the OB vis-a-vis the coal. And my lord, with respect to part B, we only need to remove the coal area, and the OB portion needs to be removed by the ECL department only. So, my lord, this is the work order. The third paragraph says that the scope of work envisages part A, excavation and removal of the OB of so and so portion, and 2 says extraction and transportation of coal. With respect to part B, removal of hard OB.
Removal of hard OB.
OB.
What is the OB?
Overburden, my lord.
Overburden.
The soil extracted area before the
Removal of
coal
hard
comes,
OB
my lord.
of 1110L. What is the 10 LCM?
Yes.
What is the LCM?
But the quantum maybe of the OB.
Overburden.
Yes.
Yes.
Now, my lord, pursuant to this work order, pursuant to this work order, my lord, there is a time limit. In the second paragraph, it says the completion of the period for work will be 4 years for part A and 2 years and 6 months for part B, which will commence simultaneously, and the date of commence will be reckoned on the expiry of 10 days from the date of issuance of the letter of acceptance on handing over the site of work, whichever is later, my lord. In this case, my lord, we were handed over with the work order. Thereafter, since there was some
The work order was sent, the workplace was handed over.
yes, 18th of January 2011, the letter of acceptance was issued.
No, work order was issued on 2nd June.
Yes.
2011.
Yes. So, my lord, thereafter we started with the work, my lord. Now, my lord, in the meantime, we have faced several hindrances with respect to the people who are working, who are engaged in that area, my lord. Now, with respect to the part A and part B, in the tender process, there is a clause under 5.1, which says that if the authority deems it fit, they can transfer all the machineries, excavators and everything pursuant to their directions. We have shifted all the machineries from part A to part B. Now, my lord, for which there was some delay in the processing of the part A work, for which we sought for the extension, and my lord, the extension was granted, which is at page 49. The first extension, my lord. Yes. Without reserving any right for imposing any penalty or LD, my lord, they have issued the first extension, which is at page 49, my lord. The second paragraph is important. It says the competent authority has been pleased to grant you provisional extension for the time of 3 months from the scheduled time of completion, that is with effect from so and so to so and so.
3 months, yes.
Now, my lord, this second extension comes in the very next page, 49A.
So without any LD?
Yes.
In part B.
With respect to part B, my lord.
Is a part B?
Yes. It has been mentioned in the subject, my lord.
Yes.
Provisional time extension for part B.
Correct.
Now, my lord, very next page, 49A. The first extension was granted to us without imposing any LD. Now, my lord, for the first time in the second extension, they are reserving their right, which is at the second last paragraph. This says that thus it is proposed to give the agency further time of extension from so and so to so and so, reserving the company's right to impose waive the penalty at the time of final extension of time as per the contract agreement.
Yes.
Now, my lord, for the first time in the second extension, they are reserving their right.
So this is also part B?
Yes, with respect to part B only. In the subject, it has been mentioned the same areas, same portion of work, and this is the second extension.
Part B complete
Yes.
Now, my lord, pursuant to this extension, my lord, we have completed our entire work on 28th of February 2014, my lord, which is the prescribed time limit by which this extension was granted, my lord. The extension was granted till 31st of March 2024, 2014.
Correct.
My lord, we have completed our work within 28th of February 2014. So within this time, we have completed our work.
28.
Yes.
28 February?
Yes.
In part B.
With respect to part B, my lord.
Yes. 2014.
Yes.
Yes. Then?
Now, my lord, after completion of this work, my lord, we have for the first time sought for foreclosure of the part A work, because they have asked us to shift our machineries from part A to part B, and within the extended time, we have completed our work. Now, with respect to part A, we could not complete our work because of their directions only, my lord, for which we have sought for foreclosure of the entire tender process with respect to part A vis-a-vis part B, which is at page 50. Lord, I'm led by Mr. Dutt.
Your Lordship has been apprised of, my lord, the execution of the work in part B. Now, my lord, after part B was executed within the extended period, my lord, we request for, my lord, foreclosure of the work, my lord, at part A. This year, Lordship would find, my lord, we have done it, my lord, on 18th of October 2014 at page 50.
Yes.
My lord, may I place, my lord, the third paragraph?
Yes.
Wages, we have started paying partially as recommended by the High Power Committee But the trade unions are still forcing us to pay exactly as recommended by the High Power Committee by agitating and stalling the work. Under the prevailing condition, we are not in a position to continue the work, as financially we are not in a position to pay as per the High Power Committee. Then Miller 2 is non-payment of diesel escalation as per bulk rate. I'll not trouble your lordship with the bulk rate. Then Miller, thereafter, we have not been getting payment of bulk rate on bulk rate basis as are taking oil from the oil companies with a so and so. So this is again Miller on bulk rate. Now kindly take note of the penultimate paragraph. You are therefore requested to kindly foreclose the above said work without imposing penalty. Also release our bank guarantee and withheld amount immediately. So this was the prayer. This is accepted. This your lordship would find Miller in the next page, that is page 51. But on 15th of May 2015, we are informed, this is to inform you that ECL Board of Directors in its 278th meeting held on so and so has approved the foreclosure of the contract of the above referred work in accordance with the 80th and 83rd CMD meet, along with final extension of time up to 2014 for Part B with imposition of penalty as per NIT condition. This is where Miller we are aggrieved. Then if your lordship, my lord may kindly take me lord, the next page, which is page number 52, my lord, the subject your lordship would find, but this is an interdepartmental communication. Subject is minutes of this 278th meeting of the Board of Directors held on so and so. But then, my lord, they are reproducing, my lord, the contents or the resolution of the meeting. If your lordship may kindly take, my lord, page number 53, towards the bottom, your lordship would find, my lord, agenda number 278.3 Z2. Towards the bottom, my lord, about foreclosure of the contract for the work of hiring, etc., under such and such. My lord, the decision is at page 54, III, at the top, 54th top. In view of the above, after detailed deliberation, board accorded approval for A, foreclosure of the contract on as is where is basis without imposing any penalty in accordance with the decision of the 80th and 83rd CMD's meet. B is final extension of time up to 28/2/2014 with imposition of penalty as per terms and conditions of the agreement for Part B of the job. The penalty would be assessed and to be recovered by the area authority at the time of payment of their final dues. Now, my lord, this is, my lord, the long and short of my case. Then, my lord, my final bill has been placed before them. Kindly note down the date, my lord. It is 25th of June 2020, 25th June 2015. And finally, my lord, the impugned order is at page 62.
Yes. When you raise the bill?
25th of June 2015.
Where is that? You have it
My lord, my lord, the bill is not there, but the reference your lordship would find were at page 61. But at page 61, please take, my lord, the third paragraph. Sir, we are totally unknown on the ongoing activities with our final bill till date. Sir, we have completed our entire awarded job on so and so, and after obtaining all the board approvals, we have submitted our final bill on so and so, but we have not received any payment. Then the last paragraph is, sir, you are requested to release our payment so and so.
Yes.
Now, my lord, the impugned order is, my lord, 25th of December 2015, which my lord would find, my lord, at page 62.
Correct. So they have Part A, Part B.
Yes.
Both.
Yes. The total final bill.
Total fine.
The competent authority has imposed a penalty of rupees 1,73 lakhs for 5 weeks delay in completion of Part B of NIT number so and so, such and such, and further recovery of diesel escalation for the period from 15/10/2013 226 to 2014 for rupees 1 crore 77 lakhs. Total recoverable amount is rupees 3.50 crore. Now this is where my grievance lies, and I am before the court. Now before taking your lordship through other things, there is a report of a committee which your lordship would find from page 58. This is very important.
$58.
58, my lord.
Yes.
This is the respondents committee.
Yes.
Well, at the top, your lordship find committee report on assessment of penalty based on in situ measurement against A&E Industries.
Yes.
Para 1 is first spell of extension made. I don't trouble your lordship. 1, 2, 3, and 3 I skip over. Now please take para 4. Against the required daily OB removal, the agency could execute only so and so on an average, thereby incurring a shortfall of 1479 cubic meters daily, or 1479 into 92, that is 1,36,068 cubic meters during the first spell of extension for reasons mentioned below. Now, what are the reasons? A, during the extended period, agency could not deploy the required number of machines in Part B, as they were asked by the management to deploy more machines in Part A by diverting from Part B to achieve the targeted coal production of the project. Now, this direction was given by them, and we are added to that, accepted by them. However, loss of production of OB in Part B due to this cannot be quantified, as no specific record in this respect is available. Shortage, then B. The second ground is shortage of supply. B similar, I don't trouble your lordship. D is very important. Hindrance caused by villagers, reference page so and so, as is recorded in the hindrance register. Therefore, one of the grounds is, or the two basic grounds relevant for my case is that we were directed to shift our machinery. And number two, what is very important is because there was hindrance accepted, recorded in a register signed by both parties. Then para 5. Because of the above hindrance, the agency lost so and so 12 days of operation. Then 6. The agency was granted the second spell of extension from so and so, reserving the right of the companies to impose waive penalty. This time, instead of completing the work within 12 days, that is so and so, which they lost during the first spell of extension, the agency could complete the work by 26/2/15, thereby delaying to complete the project by 31 extra days. The extra period of 31 days, that is so and so, attracts penal charges at the rate of 0.5% per week, as is mentioned in clause 6.2.1 of the general terms that reads as follows. But I have the clause with me, but since it is quoted here, let me read from here. In the event of extension granted being LD, the company will be entitled without prejudice to any other right or remedy available in that behalf to recover from the contractor as agreed damages equivalent to 0.5% of the contract value of the works for each week or part of the week, subject to ceiling of 10% of the contract price. Thus, because of the delay committed by 4 weeks and part of 1 week which amounts to 5 weeks, a penalty amounting to so and so is the formula will have to be levied on A&E for Part B of the contract. As per para 1D of the additional terms and conditions, if the contract is to be extended beyond the stipulated period of completion, the work due to fault on the part of the contractor, escalation on prices should be allowed. Further, if not provided otherwise in the accepted contract. Accordingly, the diesel escalation of rupees 1.77 crores paid to the agency on Part B from 1510 to 26/2 is to be recovered. Thus, the total penalty is such and such. On the diesel aspect, where I'll address your lordship later on. The first aspect is where on the delay. They are invoking clause 6.2.1 of the terms and conditions.
Yes.
No, you can
6.2.1 of the GST.
Yes. Now, please have a look at this clause 6.2.1, which my lord will find at page. But kindly take me the reply. Milord, page 43 of the reply. Kindly take my affidavit in reply. It's what, do we need to stitch it, Milord? Oh,
Page?
well, it's at page, it's not that thin, Milord, page 43, I think, Milord.
Reply is only this one.
No, well, I was referring to affidavit in reply, Milord.
Upon by Tamal Roy.
No, that is also,
There are two affidavit. One is the second May.
but I think that these are on the recalling applications, subject to correction here.
This is again opposition. Opposition. Yes.
Please have a look to page number 43, where my lord will find 6.2.1.
Yes.
6.2.1 is hedged with certain conditions. But I will be respectfully submitting that the conditions are not satisfied on the face of it. Your lordship need not go into anything else. Whatever is on record will show that. But it starts like this: the company, if satisfied that the works can be completed. So this is the basic criteria. If satisfied that the works can be completed by the contractor within a reasonable time after the specified time of completion, may allow further extension of time at its discretion with or without levy of LD. In the event of extension granted being with LD, the company will be entitled without prejudice to any other right or remedy available in that behalf to recover from the contractor as agreed damages equivalent to 0.5% of the contract value for the work for each week or part of the week, subject to ceiling of 10% of the contract price. Therefore, the basic condition is that if satisfied that the work can be completed. Here, number one is, there is no such satisfaction recorded. Number two, I'll go back to those letters in view of this clause. And number two is, admittedly, the work was not completed and they have allowed foreclosure.
Correct.
So this 6.2.1, in order to be made applicable, requires that there has to be a satisfaction of the respondents that the work can be completed. Say 2% of the work is left, like that. Now, in this background, please come back to that extension letter.
In the event of extension granted with LD,
yes,
the company will be entitled without prejudice to any rights or remedy available on behalf to recover from the contract agreed damage equivalent to the 0.5% of the contract value.
Yes.
But not more than the 10%.
Yes. Yes.
Okay. Then.
Now, what is imposed? I have got two basic submission.
Yes.
First is at the time of further extension, that is at page 49A, my lord will not find that there is any satisfaction that the work can be completed. Please have a look to page number 49A.
Yes.
But I skip over subject to your lordship's permission, first three paragraphs. Then kindly take the fourth paragraph. On not being satisfied with the progress of their job, during the extended period, the agency was repeatedly asked by the project management to improve upon their performance, which they could not. On the other hand, completion of the awarded work under Part B of the work order is also necessary, as the production of the coal depends upon removal of the residue overburden. Thus, it is proposed to give the agency further time extension from so and so, reserving the company's right to impose waive penalty at the time of final time extension, extension of time as per the contract. Therefore, my lord, number one is there has to be a satisfaction that okay, extend it for a certain time, because if I extend it for certain time, they can complete the work. There is, my lord, no such satisfaction. On the other hand, they say that our progress was not up to the mark. Be that as it may, my lord, we are not concerned about that, my lord, because without that satisfaction, my lord, an extension ipso facto, my lord, will not, my lord, attract 6.2.1. Please, my lord, please keep, my lord, 6.2.1 open, my lord. The company is satisfied that the work can be completed. But this is my first respectful submission. That
Right, the work can be completed, the contract within reasonable time after the specified time of completion may allow further actions. So your contention is that the
first condition is not satisfied.
no satisfaction is required. Yes. Yes.
The next part is, my lord,
yes.
The last part of 6.2.1 says what? To recover from the contractor as agreed damages. And what is observed as this penalty?
Equivalent to half percent of the
Yes. Now, please go back to those last two documents, my lord, that I have placed. One is, my lord, 42A. 49A, I'm sorry.
Yes. 49A is the extension.
The 49A penalty made paragraph, kindly have a look.
Hence proposed in provision.
Thus, it is proposed to give the agency further extension from so and so, reserving the company's right to impose waive penalty,
Penalty.
not damages.
Yes.
Now, the impugned order or, my lord, the committee's report, can he comes back to, my lord, the committee's report? Committee's report, my lord, again refers to, my lord, penalty.
Yes, penalty amounting to delay in committing the 4 weeks delay.
Yes. Again penalty.
Penalty.
And the impugned order, page 62, again penalty.
Yes. So if you go by the damage, if you go by the damage, the contract value of the work of each half percent of the contract value of the work for each week or the part of the week subject to the ceiling of 10% of the contract value.
Right.
What was your contract value?
My lord, 232 crores, right? 232 and odd crores. But I am not on that, my lord. I am not on the percentage. What I am respectfully submitting is, my lord, 6.2.1 permits damages. Damages means, my lord, to compensate for the loss suffered. What is being imposed is contrary is penalty. Now, what is penalty? Penalty is a deterrent factor.
Correct.
You know, the lordships have held in number of decisions the difference between penalty and damages. Therefore, 6.2.1 Miller does not contemplate penalty.
Yes.
Penalty is a punishment. It is a deterrent act.
Correct.
In order to enforce or ensure completion or execution of the work. That is penalty.
But in the 6.2.1,
yes,
okay, satisfied, okay, no problem. Then the third, in the event the extension granted being with LD,
yes,
the company will be entitled without prejudice to any right of remedy available on the recover the contract.
Damage is equivalent to half percent. Nowhere your lordship will find, my lord, that they are permitted to impose a penalty.
In the contract, there is no provision of.
At least the clause that they have referred doesn't. Yes. But I need to check, my lord, if there is any penalty clause or not. But they refer to 6.2.1, which, my lord, provides for damages. Correct. Therefore, my lord, my respectful submission is, my lord, 6.2.1 does not permit imposition of penalty.
Yes.
But my third point is, let us presume, my lord, that they are permitted. Number, the law has been settled by your lordships, my lord, is that if the first extension is without LD, subsequent extensions, my lord, cannot be, I'm sorry, it's the other way around. If the first extension is without LD, your lordship has found over here, subsequent extension cannot be without LD. With LD, I'm so sorry.
Right?
Yes, please have a look at this judgment in Wellspun. Unless where the contract permits, my lord, it's not permissible. My lord. This is what the Supreme Court has held in 2022, Volume 2 Supreme Court Cases 382. Please take note only one paragraph, paragraph 40. This brings us to the waiver. It may be noted that ONGC waived liquidated damages twice. This was a case where twice extensions. Ours is a 2 extension case. It may be noted that ONGC waived liquidated damages twice before giving extension with pre-estimated damages.
Yes.
The approach of the arbitral tribunal was to hold that once liquidated damages were waived in the first extension, subsequent extension could not be coupled with liquidated damages unless a clear intention flowed from the contract. While this court recognizes the autonomy of the party to engage in contractual obligation, such obligation may be contracted in clear terms. From the above discussion, it is clear that the promisee ONGC waived the liquidated damages initially, and the same cannot be imposed unless the imposition was clearly accepted by the parties. In this case, the interpretation of the arbitral tribunal could not be faulted as being perverse for the reasons stated above. So, my lord, for clarity, my lord, once again, my lord, please take my lord, page number 49.
Page
49, the first extension.
Yes.
Second paragraph, the competent authority is pleased to grant extension for 3 months, so and so, so and so. All other terms and conditions, so and so. You are requested to get the balance work subject to this provisional extension is subject to final approval of the competent. Therefore, no right reserved in the first extension. Not reserving any extension, my lord, Supreme Court, my lord, interprets this to be a waiver of this clause. But these are all without.
That's why the Supreme Court said, if, can you see?
Yes.
It is not a just waive the liquidated damage twice before giving extension with the sentence. The approach the arbiter was to hold that once liquidated damages were waived in the first extension,
right,
subsequent action could not be coupled with liquidated damage unless a clear intention flowed from the contract. That's why there is a content in the contract.
Yes, therefore, the contract must provide that if it is waived in the first extension, it may be imposed in the second extension. Yes. So the contract clause must be, my lord, formulated in such manner that first few extensions may be without LD, but that does not mean that the subsequent extensions cannot be without LD.
Okay.
Now, this submission of mine is without prejudice to my previous contention that damages and penalty are two different things. 6.2.1 does not contemplate penalty.
Yes.
Well, my learned friends have raised a point of maintainability, my lord, on the issue. On the ground, my lord, as we all say, that this arises out of contract pure and simple, not a statutory contract.
Yes.
Therefore, the writ codes should not interfere. Or, my lord, rights cannot be enforced, my lord, through the writ court. Now, the Supreme Court, my lord, is now taking, my lord, a different view. Your lordship has gone through this judgment period of Subodh Singh Rathore, which, my lord, went up from our court. Well, here, my lord, the learned single judge as well as the division bench was pleased to hold that no writ petition was maintainable. But when it goes to the Supreme Court, this is a case of, my lord, cancellation of a contract.
Yes.
Please take, my lord, paragraph number 60. 60, 61 and 64.
Yes.
Thus, the demarcation between a private law element and public law element in the context of contractual disputes, if any, may be assessed by ascertaining whether the dispute or the controversy pertains to the consensual aspect of the contract or tender in question or not. Judicial review is permissible to prevent arbitrariness of public authorities and to ensure that they do not exceed or abuse their powers in contractual transactions and require overseeing the administrative power of the public authorities to award or cancel contracts or any of its stipulations. But I am on a stipulation, 6.2.1. Therefore, what can be culled out from the above is that although disputes arising purely out of contracts are not amenable to writ jurisdiction yet, keeping in mind the obligation of the state to act fairly and not arbitrarily or capriciously, it is now well settled that when contractual power is being used for public purpose, it is certainly amenable to judicial review. Now, coming to the facts of the case at hand, the appellant has challenged the cancellation of the tender at the instance of the respondent on the ground of being manifestly arbitrary and influenced by extraneous consideration. Then we're skipping over paragraph 63. Please take minute paragraph number 64. Thus, the present dispute, even if related to a tender, cannot be termed to be as a pure contractual dispute, as the dispute involves a public law element. Although there is no discharge of a public function by the respondents towards the appellant, yet there is a right to public law action vested in him against the respondent in terms of Article 14. This is because the exercise of executive power by it in the contractual domain, that is cancelling the tender, carries a corresponding public duty to act in a reasonable and rational manner. Thus, we find that the writ petition filed by this one is maintainable, so and so. Then, my lord, the Honorable Supreme Court, my lord, once again ventures to decide what is the meaning of the expression arbitrariness in state actions. But only, my lord, on that, please take note paragraph 67, 68 and 69. I will not read in its entirety. Now, please take note of paragraph 67 at page 509, the last 3 lines. But the sentence starting with where a mode. Where a mode is prescribed for doing an act and there is no impediment in following that procedure, the performance of the act otherwise, penalty and damage, and in a manner which does not disclose any discernible principle, which is reasonable, may itself attract the vice of arbitrariness. But I will not disturb your lordship with the rest. Now, para 68, control of administrative discretion is an important concern in the development of rule of law according to Wade. So and so, the rule of law has 4 meanings. One of them is that government should be conducted within the framework of recognized rules and principles which restrict discretionary power. And where the para 69, the last 3 lines. Dishonesty in discharge of duty vitiates action without anything more, and action is bad even without proof of motive of dishonesty if the authority is found to have acted contrary to reasons. Now, why I say this word, number 1, you have asked me to move my machinery from one place to another place. You have recorded in your own hindrance register that hindrances were faced. You have granted me extension, and most importantly, you have allowed foreclosure of the contract. Now, thereafter, my lord, what good reason could be with the authorities to, my lord,
impose this penalty on me. Irrespective of my point that penalty and damages are two different things. But this takes care of the first aspect. The second aspect of the matter is the diesel escalation. Now, please, Your Lordship, may kindly come back to the impugned order at page 62. Where this has got two aspects.
Yes. Diesel escalation for the
Yes, the second line or the third line in the middle end, further recovery of diesel escalation for the period such and such. Now, what happened is, here, there were two rates. One rate was the bulk rate, because here, thousands of liters of diesel was required for execution of the work each day. Now, initially, we were benefited by a subsidized rate, which is called a bulk rate, and we were executing the contract. Thereafter, the bulk rate was taken away. These are from of the Indian Oil Corporation. That's a different dispute. Then we switch over to the retail rate. Now, the retail rate also increases from time to time, increase or decrease, whatever it is. There is a clause in the contract which provides that there can be escalation or de-escalation in case there is variation in the price of diesel. This, my lord, will find, from my affidavit in reply. Please have a look to, page number 46.
Yes.
I'm so sorry, page 46 of the rate. I'm so sorry. No. I'm sorry, yes, page 46 of the rate. Please take the second paragraph at page 46. You will be paid escalation stroke de-escalation on the price of diesel only as per additional terms and conditions of the tender document. The base rate for payment of escalation will be 49/2010, diesel price 40.03 liters. Therefore, to calculate the price, they require a base date and a base rate.
Base date?
Base date and a base rate. The base date is 14/9/2010.
Correct.
And the base rate is 40.03 liters, which means that on 14/9/2010, the rate of petrol was 40.03 liters.
Correct.
That was the price as on that date. Now, thereafter, if 40 becomes, say, 41 rupees per liter, then there would be an escalation of the price.
Correct.
And if 40.03 becomes, say, 39 rupees, then there would be a de-escalation. Now, after we switch over from bulk to retail rate got increased from time to time. They had paid that retail rate. Now, without any reason, they are recovering the excess amount or the escalated amount that they have paid without, any finding that there was no escalation in the retail price, but we have paid it or you have charged it from us.
So you mean to say so there is no reason recorded
Yes.
whether this
Yes.
amount, the rate of the diesel has been increased
Yes.
by this period to this period, whatever it may be.
Yes.
So there is no data.
Yes. On this aspect, please have a look at paragraph 9 of the affidavit in opposition. Only one paragraph. It's paragraph 9 starts at page 6. It's a lengthy paragraph. If your lordship may kindly take it, page number 7. Opposition there.
Yes.
Where this the paragraph starting with in this context. It is important to point out that while raising the contentions regarding disentitlement of the answering respondents, in imposing of penalty or in recovering the charges for diesel escalation, the petitioner takes shelter of an order passed by Honorable Justice I.P. Mukherjee, passed in so and so, the said order dated so and so, is presently sub judice in an appeal preferred by the answering respondents being RBW number, etc. before this honorable court. Hence, at this stage, there is no scope of passing another order on the same aspect without resolving the core issue which is under consideration in the said appeal. Well, the first thing is, my lord, those appeals are all over today. The second is, which is more important.
Yes.
The subject matter of the other writ petition or the appeal has got no connection with what I am praying over here. There, the dispute was that, my lord, the bulk rate, oh no, I'm sorry, the base rate from which date it would be applied was, my lord, was the dispute.
Correct.
As well as the formula. According to me, the formula was not a matter, but be that as it may, that was a dispute over there, completely alien to, my lord, what we are litigating over here. Therefore, what I respectfully submit is, on the second point, that what has been given to me is being recovered without, my lord, any finding that something has been wrongly given to me, or I have, my lord, misled them in getting that escalated price, retail price. My lord, I repeat, my lord, it is the retail price escalation.
Yes. In the affidavit also, they are not given the
No.
details.
Subject to correction, they have not given, but they have said a lot of things in respect of, my lord, the first issue, which
They have
if my lord,
calculated the amount.
Yes.
Page 62.
yes,
Page
that is the, yes, that is the escalated part.
Page 62, they are
Yes.
telling that with regard to the escalation period October to 13, October 2013 to February 14, 1 crore 77.
Right.
Including service tax, so and so, so and so. But what is, how it has been calculated, that is not given.
Nothing.
What was the rate, what was the quantum, and the existing price at that point of. Okay.
And my lord, in the page 62 also, your lordship would find between just above the table over there, the matter of diesel escalation for HSD bulk price is sub judice. I am not on bulk price. I am on retail price.
Yes.
Therefore, my lord, my prayers are, kindly, my lord, have a look to page number 38.
Setting aside.
Setting aside 2512. And, my lord, prayer C for all practical purposes is over, my lord. I'll not trouble.
So bank guarantee not released.
No, it's those have expired.
Not invoked.
No, no more, my lord, surviving. Prayer B and D.
The bill is to be. Yeah. That's all. Yes, Mr. Dasgupta.
But, so far as the judgments that are cited, I have to come back on that. But since my learned senior friend, my learned senior colleague has.
Just AC come first.
May I have your. But since my learned senior colleague has pointed out from my affidavit in opposition, the point that I have taken that the issue is sub judice, that kindly takes me the paragraph 25 of the writ petition. 25 of the writ petition. I didn't bring this, in fact, paragraph 24 of the writ petition. I did not bring this issue in the writ petition. Paragraph 24 of the writ petition kindly read, if Lordship kindly permits me to read, the Response Authority vide impugn memorandum had also directed the petitioner to submit a fresh bank guarantee in lieu of recovery of excess payment for diesel escalation at bulk price. It is stated in this connection that the Response Authority has no occasion or power to call for the said bank guarantee in view of the fact that claim of Response Authority towards recovery of excess payment of HSD bulk rate has already been rejected by this Honorable Court. Vide, order dated 22nd September 2015, passed and such. In that said writ petition, the petitioner had challenged the action of the authority in as much as of recovering the alleged excess amount for the running amount bill of the petitioner towards bulk rate. Vide Atansach, the Honorable Justice Atansach was pleased interior to direct the respondent authority to release the bank guarantee of the petitioner lying with the respondent in accordance with the contract. So they not only read on that, they say my right that to recover the excess payment on bulk rate has been already negated by this honorable court in that order. Therefore, I cannot make the same attempt in respect of other part B. So that is the context in which I said that there was already an appeal preferred from this order. Appeal was partially allowed. Then the petitioner herein filed a review petition against that order, and the review petition was dismissed. That is the reason why I said that matter was sub judice. It is not me who brought that subject matter in this petition.
That's correct.
So my right to recover excess payment, which according to my understanding I have made in their favor, that remains. Because they say I don't have that right because of the court order.
May I clarify this, my lord? This is a issue which was arose in the year of 2016. When we have filed the writ petitions, thereafter, my lord, the appeal got tested. Now in the
they say I don't have right because of the order of court.
Now the question is that now you come to the clause.
Yes, 62.
Yes. 62 is the impugn order.
Impugn order.
Correct. So we are first we are deciding the diesel issue.
Yes, diesel issue.
Now come to the 62. The further recovery of the diesel escalation from October to February is 1 crore. So what is the calculation?
That I will show from the, because they have also disclosed the NIT. And
then you come to that and we come to the page 46.
46.
62 read with 46. 46
Yes.
second paragraph.
Milord.
You will be paid escalation or de-escalation on the price of diesel only as per the additional terms and conditions of the tender. The base date of the payment of the escalation is 14 September 2010. Diesel rate is 40 rupees 3 paisa.
Yes.
Correct. So 4th September. Now you have taken the from October.
Milord.
You have taken from October 2013 because that was the disputed date.
That was a period beyond their contract.
Beyond their contract to 14. So how you come to the 144, 177?
This calculation Milord, is based on the Lordship would find the order of the order. The particularly quoted this provision under which I can do it. Clause 1.1. Although I couldn't find it from here, but the honorable appeal court had referred to that particular clause which gives the mechanism. That's why I did.
Correct. That's right.
So there is a mechanism. I'll bring that up.
With regard that's so how because if it is the what is the rate of October to February? What was the rate of diesel? It is a retail price.
Yes.
Cannot be a bulk price.
No.
If it is go by the retail price, so then you have to see what is the rate of the diesel in between this period and what is the quantum of the diesel you have supplied or he has purchased and you paid the bill.
But formula is that the days in excess into the price into the work that is left to be done.
Correct.
So this is the formula.
Correct.
Now the variation, price variation
With
has to
regard
be
the diesel. So
Yes.
how you ascertain the quantum? Unless and until there is a logbook of consumption of the diesel.
the component of the diesel shall be 22 expressed as percentage total value. Price of the diesel per liter for the period to which the escalation relates.
Correct.
That's the formula given in the contract.
Correct.
So if I go by that formula, then the market rate of the diesel as on that date, I'll take that and multiply it with the work done and with diesel used ultimately.
Correct.
That's the mechanism so for the when we come to the calculation.
That is absent here.
The Lordship wants the calculation. Lordship wants the calculation. I can.
Don't want, but see, once you make.
I understand. That is what is troubling you, Lordship. That is the calculation is absent.
Once you're making the claim, you should come with the proper calculation.
The final outcome of the calculation is there. Lordship wants the basis.
Basis.
But I'll bring the basis. I will bring the basis.
Tomorrow, the authority will say, no, it is not 2 crores.
No,
So
I will
how
bring
is-
the basis. Lordship will give
what
me.
will be the
Lord-
basis?
If that is what is troubling Lordship, Milord, I will instruct
What
my.
is the formula prescribed under the contract?
Milord, that is the formula, Milord, which is clause 1.1. But problem is that the document
Where
is
is
not
that?
probably. I have not disclosed it. Either they have disclosed this, but this is part of the order of the
Not
appeal court.
disclose.
Yes, it is their document,
is-
they are charging.
I will,
It's not for their benefit, how they
I can hand over the order of appeal court which records this formula.
Lord, this is again deepest of
Appeal
respect,
at
Lord,
their
this is with
request.
respect to bulk price.
No, no,
Again,
the escalation,
reiterating,
this
Lord.
does not, bulk price was subject matter of the writ petition, but the
We
mechanism
are,
of
today we are on
formula
the
of calculation.
retail price,
Now
Lord.
you come to the 46. You have to harping upon the page 46 of the contract.
Yes.
Correct. The escalation and de-escalation is recorded. So yeah, if it is the retail price, that is not the bulk price.
I understand.
Correct.
Yes.
So retail price, then the retail price. So then you have to ascertain what was the rate between October to February.
But it is no one's case
Where
that
is-
the
where is the
calculation will
calculation?
be, it is no one's
Before
case that
issuing the notice, before issuance of this impugn notice dated 25th of December 15, you might have been calculated.
I have calculated. I have given the final outcome. I have not given the, I have not disclosed the calculation. Once the calculation, I'll bring the calculation.
Could have
Kindly,
been.
kindly give me
That
7 days time. I'll bring the
This is a
calculation.
document of 2015, Lord. Now they are saying that they will bring
it
those
will be in the
documents.
file, not
No.
new one.
Not a new one,
It is
exactly.
the file.
Calculation was there back then.
Even then,
I can
Lord, with
calculate
respect
now.
to the first portion of the impugn notice, Lord, the point and the clause which they are trying to rely upon, that is not subsisting today, Lord, with
That's in the
respect to
file.
LD.
Kindly see a page 62.
Yes.
There is a file number.
Yes,
And the letter is the 420 is the dispatch number.
yes,
So file number has to be there.
yes.
In the file, there will be a calculation and that is to be approved by the competent authority.
If that file doesn't have the calculation, then I don't have any case. But if I have if that file does not have the calculation, then I don't have any case.
No, that's why I'm
So
talking.
I will bring that document.
That's it.
Lord. There must be that.
Your engineer has to give the calculation. See, with regard to the diesel escalation and diesel consumption, what is the matter that I am telling to you, as far as my knowledge goes,
Lord, we will be bound by that.
as far as so the consumption of the diesel is to be maintained in the logbook.
Yes.
So what is the quantity, whether it is 1,000 liter, 10,000 liter, the quantity is to be entered into the logbook. If you are not maintaining the logbook, then you have to take the average of the consumption of the engine.
Yes.
Consumption of the machine. What is the average? What is the average? If it is a 7 liter per hour or it is a 10 liter per hour.
Yes.
And
What was the
does
amount?
engine work? Then it is to be calculated into
You multiply.
multiplier into the what is the rate
Yes.
application
Prevailing
of
rate,
that.
and
Then it has to come. This is, you see that.
I
And with
will.
regard to the first
portion.
first portion, the legal point was which the Mr. Datto has raised, that how you can come to that. The first escalation, first you are not given the escalation. Now come to
far as the first part-
49A.
Yes.
49A.
The second extension order, Lord.
Yes, second 49A. That is the second extension.
In page 49, the first extension, without there being reserving any
49
right of.
that is
Yes.
not dispute.
It's their argument that since in the first time I did not reserve my right, second, while doing it, extending for the second time, I cannot make that right.
That is what has
That
been
is
held
what-
by the Honorable
No,
Supreme
right.
Court.
Now,
Right,
the Supreme
but
Court, if there is a contract, there is a condition in the contract.
Supreme Court has said that unless the contract provides, so I can't claim it.
That's why.
That's what the Honorable Supreme Court has said.
Yes.
But the Honorable Supreme Court with deepest of record has not held that if I don't preserve my right at the first instance, in the same chain of event, I can't preserve it later on. That's not the
That is
proposition.
one.
Lord.
If that's so, whether it is the damage of 6.2.1, you invoke the 6.2.1, whether it is a damage or escalation,
Yes,
liquidation.
the clause, I have read the clause, the language term, the damage is not there in that, but if the same
My
same
affidavit in
provision,
reply,
Kindly
page
come
they have
43.
disclosed in the reply.
Page 43,
Yes,
page 43 of the reply.
it's not there. I've seen, Lord, I've seen it's not there, but I am saying it is not there in that portion of the contract.
That's what the other
But
contract, see, what is might be there will be a liquidated damage, LD will be there. Before the clause of arbitration, might be there.
The LD provision is there in all tender.
That's what I'm telling, there might be.
So
So
that-
what is the condition?
I'll also take instruction on that.
What is the condition?
I'll also take instruction on that.
These 2 years you have to consider that.
Very good.
Your contract provide the LD, if it LD provides, what is the condition in the LD?
Under what circumstances I can impose the interest?
Again, my lord, the difference between damages and penalty, my lord.
That's
They are
if
yes.
no,
That's
if
a
it-
legal argument. That's a.
If it's provide the LD, then we has to see.
Yes.
If not provide the LD,
Yes.
then the damages they cannot.
Let them show in the contract.
Damages they cannot directly.
Yes.
Then they have to issue the notice under
Yes,
the
yes.
Contract Act.
That will be
So
disputed.
then it's it's my civil dispute. I'll be recovering money. That will be anyway. I'll come back with the instruction on the calculation and on this authorities' right to claim them under the contract.
Learned Counsel for the petition has concluded his argument. The list of learned counsel for the respondent has argued the matter at length, but he pressed for time to take instruction with regard to the calculation of escalation calculation with regard to the diesel calculation of diesel escalation. Diesel escalation as provided in as mentioned in the interim notice dated 25th of December 2015, and also to see whether any clause under the contract with regard to the liquidation damage is available or not.
Lord, with regard to the penalty, my lord.
Liquidation damage, it will come, then we'll see to that.
Very well.
Is available in the contract or not. Let the matter appear when.
But I will require 7 days time at least to get that.
Let the matter appear. They go 12:39. 12:39.
Wonderful.
14th August at 12 noon.
Very well, my lord.
14th August.
Yes, sir.
And I'm immensely grateful for the accommodation. But this is the order passed by your lordship, my lord. One of such orders, my lord, already passed by your lordship in other matters, my lord.
What is the matter?
My lord, is that adjudicating authority has issued a notice under 8.1, my lord. We have assessed that notice on the ground of quorum non-judice, my lord, since there is no judicial member present. But the notice your lordship will have, my lord, at page 169, my lord, in second volume.
169.
I'm deeply obliged, my lord. Page 169, my lord.
C5.
169, my lord.
Yes.
And my lord, the property, I'm sorry, my lord, my apologies. My lord, the property involved, your lordship will have, my lord, at page 101, my lord. 101, my lord. It will be in the first paper book, my lord. My apologies, my lord. It's only one immovable property, my lord. Your lordship may record my undertaking, my lord. I will not create any third party interest. I will file that undertaking by way of an affidavit, my lord, which was directed in other matters as well. 101, my lord.
Yes.
List, my lord, schedule property, schedule 1. Towards the left, your lordship will have Sakambari Ispat, my lord, this immovable property. This is the subject matter, my lord.
Sakambari also in the.
And this is the only asset, my lord. So we will not create any third party interest, my lord. And in your lordship's order, my lord, para 8 and 9, my lord, if I may just request your lordship, my lord. In your lordship's earlier order, my lord. My lord, my lord, 8 and 9, my lord. 8 was the, my lord, status quo, which I am just requesting for. And 9 is the undertaking, my lord. We will also file, my lord, similar undertaking, subject to my lord's approval, my lord.
এটা কাজ করে নি শোকজ নোটিস না সেম অর্ডার করবে
Show cause notice 169, my lord. No, date ta bole do. I'm sorry, my lord. Show cause notice, my lord, 27th of March 2026.
Who has issued? Chair. Same person. Same person.
No,
No,
my lord.
different,
Different person,
different person,
Different, absolutely different.
but the legal position, Mala, they are agitating the same issue.
No, this is single member.
Yes.
Single member.
Single.
Same, only the company.
Why issuing the notice?
Well, some things cannot be
ठीक है बाकी सब हो गया
Malad, we will be again coming to your lordship, Malad. Time and again.
Most of it. Most of it.
Lordship has passed a similar one.
Yes, next.
After service time.
I appear for the respondent bank, Malad.
Yes.
Malad, possession has already been taken.
No, but I'm
Yes,
informed
Malad.
that it's in the
Malad.
process. It's
No,
not been
no,
taken.
your lordship, these are the
They are in the
documents.
process of
Possession has already been taken. Your lordship,
served
kindly
them a
have a look.
notice.
Lordship, kindly have a look, your lordship.
The persons of the bank are still
Malad,
standing at the property
No,
right
your
now.
lordship,
As I
possession has already been taken. Your lordship can record my submission, your lordship. The police officers were there. Malad, they are challenging the possession without making the state as a party. In spite of knowing that Malad, the state is the authority who are going to assist Malad for taking the possession. Order has to be passed upon the state, not on the bank as a whole, your lordship. And possession has already been taken. Your lordship can record this. And they have preferred, and Malad, this is different from the order which was earlier passed by your lordship, because in this matter they have already filed an application. That point of time, Malad, they prayed for a stay in order to file that application. Here they have already filed. Malad, the date was on 21st. It was not taken up. Malad, it will be taken up in due course. In the event, Malad, the succeed possession will be restored back.
Yes, possession taken.
The possession hasn't been taken.
Malad, taken.
It's
Malad, taken.
symbolic.
No, your lordship, physical possession has been taken.
Physical possession also not taken, but I'm told my instructions are.
Malad, has been taken. Last show it at I have,
Even if it's,
yes,
even
Malad,
if it's
realize
taken,
it.
let them, but they cannot.
What can now the
Now, Malad, they will not deal with the property at all. If they think that they've taken.
Malad, their application is pending, Malad, it could be decided there.
I'm saying so, the same order, Malad, there's nothing beyond that. And
I'm just saying what they. Yes.
I'm saying, Malad, they have not taken possession.
Malad, made me recorded that possession has been taken.
Lordship, last order.
Lordship. This order, your lordship will see there are, yes, your lordship will see there are certain differences which are there in paragraph number 3, 6 and 9. Your lordship will see. Malad, this is the order that they are challenging. Now, Malad, in paragraph number 6, they said that till the filing of the application, there should be a, they prayed for a stay, your lordship. In this case, they have already filed an application. The notice was served upon them on 15th.
No, on 20th.
Lordship, in the averment, it is on 15th, your lordship. Now, Malad, in paragraph number 9, your lordship will see that they have made this submission. In that matter, other than the schedule C property, the rest of the properties, Malad, could be taken possession. Malad, this is a connivance with the borrower, your lordship, just in order to stall the recovery of the bank. And we are taking possession by the order passed by the recovery officer. And order was passed long back, your lordship.
Where is the order?
Well, order is at page number 106.
Good.
Lordship, operative part, your lordship will find page number 108. The conclusion part, your lordship, the order, it is written. Lordship, I have handed over the photographs. Malad, the receiver was present. Possession has already been taken, Malad, and seal and stamp has also been given there. Inventory list prepared.
Yes.
Malad. The first part, you're also looking into the order, Malad. That is 21st of May 26 is I am not a party there. I am below the tenant.
Who are you?
I am the tenant in the property. So your lordship knows under section 17 now I have to go and prefer, Malad, whether I am a tenant before or after, the court will decide that. I have done that. Possession not taken as yet. They are standing outside the property. They have not taken, they could not take possession as yet. Whatever my learned friend want to say, Milord might say. But she points out differences in the order. Kindly have a look at the difference, if any. Looks to paragraph 3, the first difference that she points out. There is no difference in the in the third paragraph. The petitioners are not aware of the proceeding and not the party of the proceeding initiated by the recovery officer. Same here. The petitioner submitted that in terms of the order of the recovery officer dated May 21, 2026, the receiver had issued notice on June 13, 2026 that the receiver shall take possession of the property on such at 11 a.m. Kindly looks to me what our facts in our case is. The paragraph to work on. She says, below, we had come to know about 15, wrong submission. Kindly have a look at paragraph 13.
Page 9.
At page 9.
Yes.
My learned friend has seen only one date. All on a sudden, on 20th of July 2026, the petitioner had found a notice dated 15th of July. So the notice was 15th, pasted on 20th by the receiver. So it's not that bad. I come to know on the 15th. And looks to my bona fide, my lord, I have filed an application before the DRT because I know what it is. And my learned friend very fairly says that on 21st, the date was fixed, but the court didn't take up.
Yes, there was a resolution, madam.
Yes.
For which it was not
For
taken.
which I should not be penalized.
But once they've already drafted.
Yes, my lord.
Yeah, I'm saying so. But similar thing your lordship did there.
The
Similar thing.
The petitioner has filed the present writ application challenging the order filed by the recovery officer dated 21st of May 2026
আমি চাইলে এগুলো পাঠিয়ে দিচ্ছি
in
ছবিগুলো আরে পজিশন নেওয়া হয়ে গেছে নেওয়া হয়ে গেছে যে পেস্ট করে দিয়েছে ইনভেন্টরি লিস্ট এটা আমার ইনস্ট্রাকশন মানে আমি জানি ওই যেটা আমার ইনস্ট্রাকশন
The receiver is directed to take actual physical possession of the property described in Schedule A, B, and C of the petition within 30 days from the date of the above. And counsel for the petition submitted, the petitioner is not aware of the proceeding initiated as of the proceeding in which the recovery officer has passed the interim order. If further submitted, the
May I have my lord's kindly, my lord.
if further submitted, the petitioner is only a tenant and has knowledge with regard to the proceeding pending concern before the DRT against the owner of the property. He further submitted that the petitioner came to, he further submitted only on 20th of July 2026. A notice was pasted at the door of the premises of the petitioner on 20th, क्या मतलब बोला date? And from the said notice, the petitioner came to know about the same, about the order passed by the recovery officer and for taking possession of the premises by the receiver 23rd of July 2020. Accordingly, the petitioner has made an application before the debt recovery tribunal. Yes. Debt recovery.
That's being IA number 152 of 2020.
IA number
152 of 2026.
152 of 2026. 152 of 2026. And the matter was listed on 21st of July 2026, but due to the resolution of the bar, the matter could not be taken up. He further submitted that the DRT has not taken up the matter. According, the petitioner has filed the presented application for interim relief, as today is the date for taking possession of the premises. And per contal, an advocate appearing for the bank submits that the notice was issued on 15th of July 2026, the petitioner has not taken any steps. Subsequently, the petitioner has filed an application before the DRT and was fixed on 21st of July 2026, but the petitioner has not moved the said application. If has not moved the said application, and instead of moving the said application before the DRT has filed the presented application. She further submit that the date was fixed for taking possession by the receiver on 23rd of July 2026, that is today, and accordingly, the receiver has taken possession of the premises in question. She has also handed over some photographs showing that showing that some police personnel along with some other persons are in front of the premises, and the premises here is premises showing that the shutter of this shutter is the Maruti, it is your.
Yes, that's my workshop. They're outside my gate right now.
The workshop, the shutter of the workshop is shut down. Is closed. Is closed. Full stop. Then counsel for the petitioner denied the submission made by the counsel for the petition with regard to taken possession by the receiver. Had the learned counsel for the respective parties peruse the matters on had the learned counsel for the respective parties. Full stop. The recovery officer has passed the order on 25th of May 2026. The receiver has issued the notice for taking possession on 15th of July 2026 and pasted the same at the premises on 20th July 2026. When the petitioner came to know about the taking physical possession of the premises in terms of the order passed by the recovery officer, the petitioner had already approached the DRT by filing appropriate application, and the matter was fixed on 21st of July 2026, but the matter could not be taken up. According, petitioner has filed the present application for relief by restraining the receiver for taking possession. But now the petitioner, not the contention of the respondents that the possession has also already been taken. But the petition is denied with regard to taking possession by the receiver. That disputed question cannot be decided in the present date application at this stage. Accordingly, the writ petition is disposed of by requesting the learned presiding officer of the death recovery tribunal. Which court?
The recovery officer, my lord.
The recovery officer.
DRT1.
Recovery tribunal of
DRT1, Kolkata.
DRT1, Kolkata, DRT1 to immediate to take up the application filed by the petitioner as early as possible, preferably by 30th of July 2020.
But if possession is not taken till now, then they'll be restrained from taking.
Then it will be difficult. They will be taken. That's why you recorded. Not taken.
Only, my lord, subject to the outcome. My lord. The possession taken will be subject. If they are saying that.
The recovery officer shall decide with regard to the possession of the tenant in question. Hearing of the application filed with the petitioner.
Not extremely urgent motion, otherwise I would not travel your lordships. Not, I am a member of a panchayat. My name has been deleted from the SIR list. I preferred an appeal. Now we are under 11G. They have filed an application for removal of my name from the elected membership. Now I have filed a petition so that the tribunal decides. Not I lose my membership. Not I am only seeking a direction.
When the date is fixed for hearing of the
Not the date দিয়েছে কবে ওখানে কবে appealate date there is no given fixed for no removal. Tomorrow
কালকে তো আছে তো কালকে তো
the tribunal to consider a fresh कागज দিয়ে দেবো
जो आएगा जो SIR मैटर होगा उसमें इंक्लूड कर देना.
Item 20, yesterday I mentioned this matter. Your lordship fixed it today. It is an extremely urgent matter. I will lose my job on 26th. That's why your lordship fixed the matter today. SIR matter, 20, only 20. Let it be at 2 p.m. I will serve notice to the other.
Other matters fixed. Okay, come, we'll see. If the 2 p.m. matter will not be taken, I will call that.
Item number 26.
15 and 17. Your lordship, on the last two occasions, I directed the matter, seeing the urgency to come within the first 10. Unfortunately, it has not come.
No, what is happening? You don't. I have given the 10 today. So today, out of 10, 8 is taken, 2 is not taken. The next 10 has come first.
That is the difficulty is that the bank has frozen, not frozen, they have taken lien without the amount being specified and without notices being given at all. The amount not specified in the agreement, not.
Which bank?
Bank of Baroda.
They will not appear.
Now, that's the reason why your lordship.
Bank of Baroda never appears before this court.
Your lordships, now they have taken lien without amount being quantified. without the amount being given in the notice, the amount not being there in the agreement.
What is the number?
But 14, 15 and 17.
But item number 26 is same, my lord, within 10 matters your lordship asked earlier directed.
But now I cannot operate my account. It's a travel agent. No,
Let come at 2 if if your matter not taken.
I'm grateful.
But item number 26 is same, my lord, within 10 matters earlier direction was there.
Let us see. Come at 2. Come at
Lordship, lordship,
Item number
I'm grateful.
16 also. Item number 16 also it is directed for the top 10 matters on the 6th of July, your lordship. Kindly take it matter the companies.
Start.
Yes, your lordship.
Give the file. Give the file. The petitioner has mentioned the matter for hearing. When the matter is called, the petitioner has left the court. The writ petition is dismissed. Mr. Bihani,
Mr. Bihani was appearing for the respondent, that is Pollution Control Board.
he has no role to play in the matter. He is telling that.
Now, what I'll request your lordship, I'll I'll ascertain, my learned friends have tried to ascertain who has been allotted. কি বলেছে, কখন বলেছে? এখনো? আজকে বলেছে? They have come to learn today that they have not yet assigned these matters to anyone. I shall try to make an endeavor, serve the state once again a notice, requesting the GP to allot the brief to someone, showing the service previously. The interim order is still today.
Though the matter is specifically fixed today at 2 p.m. for hearing, but none appears on behalf of the state. Accordingly, Land Counsel for the petitions directed to again inform the next date of hearing to the London Foreign Pleader. Pleader.
No.
According case is adjourned, let the matter appear on 18 September at 2 p.m. Interim order is extended till 18 September 22. 18 September 2 p.m.
Yes. Your perception. Your perception.
Yes, next.
But
Very
item
wrong.
20, my other side is here, but I mean.
Let I did call it.
I'm grateful to your lordship.
Yes, next.
My lord, I beg to
Both
appear
the
on.
matters are accurate also. Both the matters same.
I beg to appear.
Who is for the petitioner?
I am for the petitioner, my lord.
Yes.
Lordship, in this matter, Lordship, Debulia Light, referring for the stage, you link to court number nine, whatever court paper for purpose.
What is the urgency?
My lord, the petitioner, the senior citizen, my lord,
Ah.
they have been driven out from their self-acquired property by the, they have been driven out from their self-acquired property by the private respondent, who is the daughter-in-law of the petitioner, my lord.
So what is your prayer?
My lord, I only want to get into access into the property, my lord, which is the self-acquired property, my lord.
Self-acquired property, go to the civil court. What the writ court will do?
There is a bar of the civil code, my lord. The
What bar?
Section 27 of the Senior Citizen Act, bar the
Senior Citizen Act.
My lord,
Who are you?
I am the senior.
You are the senior citizen.
My lord.
So you made an application before the authority
I have made the application, my lord. That has been,
under section 5.
my lord, but I am not seeking any maintenance, my lord.
So
I
what
am.
you want?
I want only to enjoy my property, my lord.
Who is in the property?
The daughter-in-law, the private respondent, is the in occupation of the
How
property.
who is in occupation of the property?
My lord, she was residing in the first floor, my lord. I have only one son and one daughter, my lord. My son was a cancer patient, my lord. In December 2023, my lord, my son has expired, my lord.
Correct.
After the death of my son, my lord, I have been thrown out of the house, my lord, by the daughter-in-law, my lord.
Then?
My lord, then, my lord, I approached the tribunal.
Yes, you approached the tribunal.
I have approached the tribunal, my
What
lord.
has happened to the time before the tribunal?
Tribunal have called for the police report, my lord. That has been annexed at page number 140 and 41, my lord. Thereafter, tribunal had
100?
140 and 141, my lord. The police report, my lord.
So then what has happened after the police report?
My lord, the
What the SDO has passed an order?
The tribunal have erroneously passed an order that I am seeking eviction of the daughter-in-law from the premises, my lord. When, my lord, there was no such prayer before the tribunal, my lord. I am neither seeking maintenance nor seeking eviction of the daughter-in-law, my lord.
What you are asking for?
I am asking that I have the space in the at the first floor, my lord. One room, my lord. She is residing in another room, my lord. I want to just reside in my room, my lord. Be proper accommodation, kitchen, bathroom, and etc., my lord. And
correct. So you're out of possession. You're out of
it's
possession.
my self-property.
So where are you residing now?
Now I am residing in my family relative's house.
So you go to the civil court.
Civil court have no jurisdiction, my lord. There are the judgment passed by this honorable court, my lord. The Rashekar month. Yes. I'm sorry. I'm sorry.
Maintenance আছে? Senior citizen maintenance?
My lord. These are the judgment that I am relying upon, my lord. And kindly come to the section 27 of the
What the court, where is that? Where is the civil court cannot pass an order? Civil suit is not maintained.
My lord. If you come, my lord, the judgment Ram Prasad Vashak, the para number 9, my lord. However, the right of the senior citizen to exclusively reside in his own house must be viewed from the prism of the Article 21 of the Constitution of India. To compel a senior citizen to approach either a civil court, the jurisdiction of which is anyway barred under the Section 27 of the 2007 Act, my lord, or take recourse to a special institute like the 2007.
So who is appearing for the other side? Who is for the private respondent?
I'm for the private.
Your son or daughter?
I'm daughter-in-law.
Daughter
Son has expired, my lord.
You're the daughter-in-law. So against whom you have filed the
I am against the daughter-in-law, my lord.
Yes. Why
Yes.
not allowing to reside?
My affidavit.
My lord,
is kept with it.
there are two floors. One has been occupied by them.
Hmm.
Subsequently,
one is occupied by
petitioners.
Hmm.
After the demise of my husband,
Hmm.
that is the private respondent, they have transferred the property in the name of their daughter.
Who transferred the property?
Petition number 2.
No, this is
How
incorrect.
many petitioners are here?
Only 2 petitioners.
Where are the petitioners?
Petitioner are the father-in-law and the mother-in-law of the private respondent, my lord.
Hmm.
The property consisted of, I explain, my lord.
So what about the son?
Son has expired.
Son expired.
Son expired.
Only one
What
son.
about the daughter?
Daughter only, one married daughter, my lord. She residing in their matrimonial house, my lord.
So in the total house, who is residing?
The total house, the ground floor has been gifted to daughter-in-law after purchase of flat in Madhyam Gram by the daughter-in-law, my lord. The daughter-in-law have purchased separate accommodation.
Give aside the purchase.
My lord.
The property is the 2-storied building.
My lord.
Correct?
The ground floor has been gifted to the daughter, my lord. And
who has gifted?
The petitioner, my lord.
Petitioner gifted.
My lord, the rest of the property belong to the petitioner.
Correct.
The rest in the first G+1, first floor, my lord, the private respondent, that is daughter-in-law, is residing in the whole, my lord. I am left out of the house.
Which floor you are gifted?
Ground floor only.
So how you are in the first floor?
I'm a married.
Vacate, when you vacate, tell me.
No, sir. No.
Tell me, I will otherwise call the police now. When you will vacate the first floor?
Married daughter-in-law.
Maybe.
My husband has been
Ground
expired.
floor is with you?
Now,
ground floor is with you or not?
No, my lord.
Ground
Ground
floor
floor
is not with you.
is with their daughter. Their daughter.
Ground floor is with you or not?
No, my lord.
Which property has been gifted to you?
I have not been gifted any property. They have gifted the property of ground floor to their daughter. I'm a daughter-in-law.
How you are telling that the daughter is out residing separately?
Daughter is residing separately, my lord. Daughter-in-law is in the possession.
Now,
who is in first floor?
First floor, daughter-in-law, the private respondent.
Yes, I have been.
Ground floor has been gifted to my.
Who is residing?
They are in the gifted. They are.
Who is residing in the ground floor?
No one is residing, my lord. That is.
You reside in the ground floor.
This is a gifted property, my lord.
Maybe.
My lord, this is a gifted property, my lord.
My lord,
To whom they is gifted, my lord, they are residing, my lord. To whom?
You told
I am
that
explaining.
your daughter is residing separately. Now you are telling that
My lord, I am
daughter has
explaining,
been-
my lord. Daughter, the marriage was conducted, take place in 1988, my lord.
This
My
would
lord,
find that the writ
it-
application is to dispose of only after exchange of the affidavit. Let the affidavit in opposition be filed by 1 week. Reply if in there to 1 week thereafter. List the matter on
Lordship, kindly give me
17th August 2026. Next.
kindly give
Under the
me
same heading, my lord, I am out of position.
Lordship, kindly give me fortnight.
No.
My lord, under the same heading, my lord.
Come with the clean hand.
I am given with the clean hand.
You have given the one for the daughter and daughter-in-law residing. You wanted the daughter-in-law to be vacated.
Yes, my lord.
I am not seeking
When the court is asking that where is the daughter-in-law residing
my
separate.
lord, I am little
Yes.
bit not.
Who is the item number 10?
I am not seeking eviction, my lord. I want to reside in the premises, my lord.
Who is in item number 10?
May it please the Lordship, Lord, I am appearing for the petition in the matter. Very short relief I am claiming that we have made. I'll quickly.
Answering respondent.
I'll indicate the facts in 2 minutes. My prayer first I'll indicate. We are praying for, we have made a representation let this representation be considered by the authorities. That's our prayer. Now, what is the matter? I'll quickly indicate. My lord, the petitioner's goods, my lord, the petitioner's goods, my lord, were shipped by a shipping line from the Kolkata port to, my lord, Iraq port. Now, this was done on 10th of January, my lord. This was to be completed usually in 10-12 days. It did not happen. It cannot take more than, my lord, 20-25 days to reach that port. In the meantime, my lord, the Iraq war started. My lord, here the contractual arrangement was recorded in the bill of lading. In the bill of lading, it is recorded, these are the terms on which you will charge me. And that's the contract between the parties. So, my lord, we paid in accordance with that, but that's recorded in the bill of lading. In fact, there were negotiations with regard to some charges which may come because of the war. That also we agreed to. All of a sudden, my lord, mid-voyage, they say that we will now proceed and give you delivery orders because my goods have now reached, my lord, 161 containers plus I think 176 in total. They have reached the port of Iraq, in Iraq, my lord. They are not giving delivery orders. It is their container, they're the shipping lines. My lord, my goods are kept in their containers. They are saying we will give you delivery order if you pay per container 800 USD as war surcharge. We say you can't charge that. Negotiations, my lord, were happening. We said you can't charge this. Whatever is captured in the
Charging the war charge.
My lord, the shipping line. Now, my lord, the shipping line is charging this. We say that you can't because 800 USD on what basis? If today, my lord, the goods are stranded just next to the port. Someone else's good is stranded 12 nautical miles far from the port. Someone else is in 200 nautical miles. For everyone is the same rate. Or what is the difference? What is the basis? They don't give that. Instead, they give an offer. Very well, instead of 800, you give us 475. Then they change it to 600. No basis. This we have challenged. We said you can't do this. We write to the DG shipping. Now, that is guided by volume 2 if your lordship takes up. I'll quickly indicate page 173. There is a circular issued, page 173 of volume 2, my lord.
Yes.
Circular number 14, my lord.
Yes.
Paragraph 3, kindly see the subject of this circular. It is issued on 9th of March 2026, my lord, top right hand corner. Top right hand corner. And the subject is advisory to shipping lines, carriers, agents regarding transparency in transaction costs and avoidance of predatory, non-transparent and opportunistic pricing in EXIM trade. My lord, kindly take a paragraph 3. The Directorate General of Shipping has received representations from various stakeholders in the EXIM trade regarding levy of multiple ancillary charges by shipping lines, carriers and their agents. This agent is what we are up against, my lord. These charges are perceived to be non-transparent and opportunistic in nature, resulting in escalation of transaction costs in the logistics chain and appearing to take an undue advantage of the prevailing geopolitical tension and war-like situation. Then the next paragraph is in continuation of Circular 1 that this is being issued. Paragraph 5, second line, section 317 of the Act, the Merchant Shipping Act 2025. Over the page, the most important paragraph is paragraph 6, my lord. In view of the above, and in interest of promoting transparency, fairness, and predictability of the EXIM logistics ecosystem, all shipping lines, carriers, and their agents, where it covers everyone, all shipping lines, are hereby advised to 1. Refrain from predatory, non-transparent, and opportunistic pricing practices, including levy of exorbitant charges, thereby taking undue advantage of prevailing geopolitical issue. Number 2, adhere to fair trade practices and avoid the levy of charges that may give rise to disputes within the EXIM trade. Number 3, ensure that all applicable charges are communicated clearly and upfront to exporters, importers, and other stakeholders. Paragraph 7, the Directorate expects that all stakeholders in the maritime logistics chain will cooperate in maintaining transparency and fairness in commercial practices in the larger interest of facilitating trade, reducing logistics costs, and improving ease of doing business in India. But over the page is the next circular, page 175. This is circular number 15, my lord. Only one paragraph, paragraph 4, because paragraph 2 and 3 is relates to paragraph 3 is that second line, it relates to circular number 14.
Yes.
Hence, paragraph 4, further to this order, competent authority has decided to appoint single point of contact as the nodal officer. That address is given, my lord. The address is given that whatever is your grievance, you address to him. Now, I must pause here for a moment. DG Shipping Bombay has a territorial office in Calcutta, my lord. That is respondent number 2. We have added them as a respondent here for, my lord, the jurisdiction. Now, my lord, over the page 176 is a trade circular issued by Kolkata Port Trust. Subject is, my lord, waiver or remission of charges for export of containers bound for Middle East destinations. I'm not, my lord, kindly see serial 1 there. Export containers cargo bound for ports beyond the Strait of Hormuz, especially UAE, Qatar, Bahrain, Jordan, Kuwait, Iran, Iraq, and Saudi Arabia. So Iraq is covered in this. Now, today, my representation is at page 197, Milord, is the first representation. Page 197, annexure P4.
Yes.
Milord, this is dated 11th of May 2026, Milord.
Yes.
I have encapsulated the entire facts here. I mean, I'll not trouble your lordship. At the end, Milord, what we have requested for, I'll only indicate, Milord, the broad parameters. Milord, kindly take up page 198. The headings, Milord. Particulars of the complaint given, and particulars is Roman 2, Milord. Roman 2. The history of the facts given. Your lordship will kindly take up page 200. The heading is at page 200, Milord. Coercive tactics and extortion being committed by the carrier for which urgent relief is requested. And there we have stated, Milord, in Roman 2, under Roman 2, the demand of 800 USD for each container as a precondition for release of goods is an act of coercion. Milord, the next page, page 201, the grounds for which the purported demand of USD 800 per container are predatory, arbitrary, illegal, opportunistic, and non in terms of the circular, Milord. Milord, then at page, Milord, 204, Milord, Roman 5. Application of government notification. The first, Milord, is DGS Circular 14. Milord, over the page, Roman 2. Yes. At page 205, Milord, the first line, DGS Circular 15, and Roman 3 is the KOPD Circular, Milord. And thereafter, Milord, urgency and continuing prejudice, and the relief kindly take up at page 206, Milord. Relief, we have claimed threefold relief, Milord. First, we say that you suspend the license of MSC agency, third line, Milord, under the relief. Yes. Third line. You suspend the license of MSC Agency India Private Limited to act as a carrier or shipping line agent in India. And pending the comprehensive investigation into our complaint, and thereafter, if it is successful in the investigation, if it is held against this agent of the shipping line, then cancel and rescind the license. That's number 1. Number 2, we say, Milord, that they should have an interim relief. Your lordship will find in the middle of the paragraph. Meanwhile, we pray for an interim relief from your office to release our cargo held in ransom and without demanding any financial surcharge. And we also pray, Milord, that they should issue a particular notification by which this is done, that they have to release it immediately. And the next page is, Milord, similar reliefs which we have prayed for.
Yes.
Milord, kindly take up page 208. This is the first representation, Milord. The second representation we give on 13th of July. It's at page 208, Milord.
Yes.
We reiterate. So I'll not trouble your lordship with this. We reiterate the same facts. It's a first reminder. That's how the subject reads. Humble first reminder and urgent entreaty to act upon the written representation. So second, essentially, Milord, the first reminder or the second representation.
Yes.
This has not been considered. The rest of it, Milord, I'll not trouble your lordship. All that I'm praying for, the press, if your lordship takes up, Milord, the volume 1, page 24.
Yes.
First is, Milord, a mandamus we have prayed for to take cognizance of the complaints of May 11 and July 13. That's the first prayer, Milord. Second prayer we say, Milord, to rescind the license, to suspend and thereafter rescind the license. First prayer we say, in the meantime, you suspend the license. Second, rescind the license. Third, we say, Milord, a direction to release the cargo immediately. And D is, Milord, a certiorari that we have prayed for, and consequential relief that we have prayed for. So today I'm only praying if this can be relegated back to the authorities to consider.
Yes.
That's all I'm praying for, Milord. Let them kindly keep all the points open to be agitated before the authorities.
Yes.
And also give effect to the circular, Milord. That line I'll pray for, that they should give effect to their own circular.
Yes. Here for the Union of India. The Union of India, first one was nothing to do.
Union of India?
Page 2 of the
Union of India, we had to make them a party, Milord, because it's the Secretary of the Ministry of Courts.
Respondent number 3 and 4 are at Mumbai. And your lordship kindly produce, my lord, page 23,
Hmm.
paragraph 36.
Hmm.
I am on jurisdiction, my lord. It should be moved before the, my lord, other Bombay High Court.
I'll indicate that answer, my lord. Respondent number
Yes, sir.
2.
Paragraph 23.
Page 23, paragraph 36. The records relating to the case are lying with the respondent number 3 at its office.
So which port your ship has been?
My lord, it's Bombay. My lord, the difference is Haldia. I'm sorry, Haldia port. Haldia port, but DG Shipping's office, my lord, is in Bombay. It has a Kolkata office. That's respondent number 2. Your lordship will kindly take up in the cause title.
Field office.
The field office.
Correct.
And your lordship.
So they always have
Where the
jurisdiction.
demand was made.
Your
My
lordship.
lord, demand is made in the sea. My lord, when the goods are and demand, my lord, the notice is received by us in our office. It's in Calcutta. My lord, the
Where is
notice.
your ship now?
Ship is in Iraq, my lord. Ship is in Iraq, but the authority, the shipping line, the Calcutta agent is, my lord, respondent number 4.
Who is demanding?
My lord, the shipping line is demanding. That's respondent
Where
number
is the
4.
Respondent number 4. Where
Four.
is the office?
Calcutta, my lord. It has a registered office. My lord, kindly give me a moment. It's in Maharashtra, Bombay.
Bombay.
My lord, Calcutta office is respondent number 2.
Oh, that is the field office.
My lord, today I can't seek, I'll indicate, my lord. I can't seek any remedy against respondent number 4 and 5 directly in the writ.
Correct.
They're private entities, my lord.
Correct.
My only prayer is against respondent number 2.
Correct.
Respondent number 2 be directed to, my lord, consider these representations. It's the Calcutta office.
But how this could? Where is the
But Calcutta office, my lord. My lord, R2, your lordship will kindly take up my pleading in paragraph 2 and act minutes, sir, act minutes.
Where is
My
the
lord, kindly take up the third line in paragraph 2, my lord.
Yes.
The respondent number 2, Mercantile Maritime Department, Kolkata, is a field office functioning under the administrative control of the DG Shipping, and it exercises statutory powers under the Merchant Shipping Act.
You are requesting for consideration of your representation by the DG,
No, my
not
lord.
by this office.
My lord, I'll indicate. Today, my lord, I am requesting the DG Shipping to consider this. DG
Correct.
Shipping, my lord, has an office in Calcutta. They can do it through the Calcutta office. I'll indicate why. My lord, Trade Circular number 15 is, my lord, the circular which names an authority, a person. Your lordship will kindly take up that document once. Your lordship will kindly take up page 175, my lord. Page 175. And I'll indicate why Calcutta, my lord.
Yes.
Lordship will kindly note, my lord, page 175 says paragraph 4.
Yes.
Single point of contact is this person. So by the circular, they have indicated this is the single point of contact.
Correct.
Now, if this is the single point of contact, they can give, my lord, effect to this circular through any of their offices. Their office in Calcutta is all that I'm praying for. I'm not praying for a direction on the Bombay office. Only on respondent number 2.
The respondent number 2, how only the office is there, but the DG Shipping is.
The DG Shipping can
authority is not here.
Today the field office means, my lord, they can always be directed through the field office to, my lord, take cognizance of this, my lord, only because of this, my lord. And also, my lord, may I also indicate this? I'll try and, my lord.
But to satisfy how the cause of action arose, you made a representation. The DG Shipping office is there. Your ship is in Iraq. Demand is made from Maharashtra. How?
Lord, I'll indicate 2 points, my lord. I'll indicate 2 points.
Can adjudicate your issue here.
Lordship. It's not, my lord, I'm not praying for adjudication. I'm only praying for representation.
Maybe
I'll indicate.
representation also the entertainment of the writ petition.
Indicate. I'll
Entertainment of the writ petition means you have a cause of action. That's why the court has entertained. Where is the cause of action?
My lord, the effect which we are facing.
Your demand has been made to the Iraq ship.
Lordship.
And the
My lord,
demand
I'll
is made by the
2 points.
Maharashtra.
2 points, my lord. Demand is not made from Maharashtra, my lord.
Yes.
Demand, no, my lord. Demand
Shipping liner is from Maharashtra.
Shipping line agents is in Maharashtra.
Correct.
My lord, today, all that I'm facing, because today it went, the port is Haldia port, my lord. It went from this jurisdiction, the goods traveled from this jurisdiction to Iraq. Number 1. The bill of lading is addressed here, my lord. Whatever they are claiming is on the bill of lading. So, my lord, my effect is felt in the office which is registered within the jurisdiction of this honorable court. That's the petitioner's office. But the bill of lading which is affected is issued from Haldia. So, my lord, Haldia office, my lord, it is the jurisdiction of this honorable court over the bill of lading. So, whatever illegalities is being perpetrated is, my lord, through the change in the bill of lading that they are seeking through this illegality.
Sir, your vessel, which port your vessel left?
My lord, Haldia. From Haldia, my lord.
From Haldia.
My lord.
it was.
And Lord, kindly take up page 30, the bill of lading. It is very clear, my lord. Page 30, my lord. Your lordship will kindly take up page 30, volume 1.
Yes.
Your lordship will kindly note the shipper is Rashmi Metallics, Shakespeare, Shawnee, Calcutta. That's the registered office. Your lordship will kindly see the bill of lading. The at the bottom, my lord, issued at Calcutta. At the bottom left-hand corner, my lord. 30th December 2025, Kolkata. This is my grievance, my lord. But you are trying to seek to change this. This is the contract between the parties.
No, the bill of lading is issued, your ship has left now.
My lord.
So what?
But my lord, whatever they are affecting, they're seeking to affect is on the bill of lading. And all that I'm praying for is, my lord, and direction on the DG shipping, the Calcutta field office, because through the, my lord, I'll indicate what the field office is. The field office effectively, my lord, is an office which regulates the circulars, because today, if there's a circular, my lord, the all of Eastern region is guided by this field office in Calcutta. I'm only seeking, that is why we have made them a party, my lord. Respondent number 2.
But how? I don't
One, my lord, I'm only praying that if, my lord, a direction is given on the respondent number 2 to, my lord, adhere to the circulars and consider the representation. If they are, my lord, not satisfied, they will transfer it. They can't, but they have to decide this, because today, my lord, if there's a nodal officer directed to, my lord, decide all these issues through a circular, being circular number 15, then, my lord, any office of DG shipping will have jurisdiction to enforce that circular.
I don't think so.
My lord, we have also indicated, my lord, your lordship will kindly take up paragraph 36.
Yes.
At page 23, my lord.
Yes.
The records are lying within jurisdiction. The respondent number 2, third line, my lord. Respondent number 2 is the field office of the respondent number 3 within the jurisdiction of this honorable court, and also has the same responsibility for implementing the circular issue. This is my case, my lord.
Implementing, but you
all that
are
I'm praying is
implementing, but your case is that they are not implementing the circular. That's why you made a representation to the authority. The authority is that is the authority of the DG shipping. DG shipping office at Mumbai. He has to consider, and the respondent number 2 has no authority to consider.
Lord, may I pray for this? Because today, my lord, with every passing day, my lord, we are facing a financial burden.
What?
My lord, today may I pray for this? If, my lord, it is an office within the jurisdiction of this honorable court, which is respondent number 2, my lord. My lord, if, my lord, there are two ways out in my very humble submission, my lord. One, if your lordship, my lord, permits, directs them, my lord, to consider this representation, or, my lord, if your lordship is pleased to direct us that if we make a representation within 7 days before the Calcutta office, that should be disposed of within the next 7 days. Kindly grant that liberty and, my lord, disposes.
Even kindly see the representation.
I've seen that, Lord. I've seen that. I've seen that. That is why I can't make any submission on that point. May I pray for this indulgence, my lord? If this can be rooted in this manner, my lord, if your lordship, my lord, grants us the leave to, my lord, approach the Calcutta office, my lord, to approach the Calcutta office, my lord, within 2 days. And, my lord, a direction that if we approach the Calcutta office within 2 days, let them take a decision within the next, my lord. I'm beseeching your lordship. Otherwise, my lord, that is why, my lord, we have said, my lord, that the respondent number 2 is has an office within the jurisdiction. That is why the pleading in paragraph 36. Because, my lord, paragraph 36 is only on this premise. That today, my lord, if they do not consider this, there is a field office. The field office has the responsibility of implementing the same things which, my lord, the head office has in Bombay. But I'm being led by my learned senior, my lord. May I have my lord's kind leave?
Yes, Mr.
After what I've heard, my lord, I don't know how to improve, my lord, my case. On the question of jurisdiction, my lord, it's always an issue, my lord, but one of the, my lord, authorities, my lord, are here.
Of the authority, but the request now, what is your prayer for consideration of the representation? That representation is made to the DG shipping Mumbai, and the demand made by the shipping liner that is at Maharashtra. Your ship is at Iraq.
Goods are at Iraq. Malad has heard already on the merits of the matter. Malad, this DG shipping says no. Malad, extraordinary predatory charges will have to be issued. That's exactly, Malad, what the shipping company does.
Correct.
Malad, we wanted a implementation of, Malad, the DG shipping, Malad, circulars.
So, but how
themselves
can pass order in this present date application?
Malad, only because of respondent number 2, Malad, consider it. Otherwise, Malad, we'll have to, Malad.
Yes, but there is no prayer on that. There is no prayer. It could have been, if there is a direction upon the respondent number 2, this court could have been taken to, but there is no such.
No, we made it.
And the representation is not to the respondent number 2, respondent number
It is not, my lord, it is not.
1. You don't take a petition, whatever it is.
My lord, then,
As.
because urgency is, my lord, because it's lying there and my lord,
I appreciate.
Demerits, my lord, is going up every day.
This court has.
Yes, of course, my lord, I can't, my lord, when, my lord, the court has no jurisdiction, my lord, maybe have, my lord, one day, my lord, just to come back, my lord, if tomorrow, my lord, it will just, my lord, see, my lord, what can be, my lord. Let's just.
Though the petition, counsel for the petition has argued the matter at length in the list of and counsel for the respondent has raised the point, respondent number 1, raised the point of jurisdiction. According counsel for the petition, praise for time. Please adjourn, let the matter appear tomorrow under the same heading. Come tomorrow?
Yes, I just want to talk, my lord, have a, my lord, meeting, my lord, with them and.
Yes.
I'm grateful.
DP.
My lord, I am for the petitioner, my lord. Your lordship, remember, my lord, it is that kidney transplant matter, my lord. On the last occasion, your lordship directed the authorities to come up with a police verification report. My lord, I have been given a copy of.
Who are you? Who is the
I am
donor?
the recipient.
Who is the donor?
My lord, donor is a friend of, not a near relative.
Then the same thing, you have to produce the report.
Yes, my lord.
But I
Report has
have
been
filed.
filed on the last.
What report?
My lord, of the
Where the interaction was made by the authentication committee with the donor and the recipient and whether video recording was conducted.
Yes, my lord.
Where is that?
That is in page number 4, my lord, annexure B, where the local police station already verification.
Not police were.
Authority, my lord. I will come. My lord, page number 9, my lord. Annexure D. My lord, point number 9, interview report, my lord. Hearing is video recorded.
Where is that?
First point.
Nature, the police verification report, interview. Hearing is video recorded in the compact disc attached. Where is the compact disc?
My lord,
During
that
the
they have
inquiry,
not
the donor stated
given me yet, my lord.
that
They are on the way, my lord.
that they came to know each other and often goes to this matter at the house. But there is a gross difference between the address and residence. Address. Donor is a drug addict. See report 10.
No drug.
Only see the 10.
Whether there is any in the drug period.
Donor is in the proper state of health, no mentally challenged. Okay. Okay. Then hence is the case is not. Why do you not recommended?
My lord, only for the point number 9, my lord.
Where is the reason?
My lord, at first page, my lord, paragraph number 5. The verification committee in their report opined that during interview, the donor stated that the recipient is neighbor of his maternal uncle. Thus, they came to know each other and he often goes to his maternal uncle's house. But there is a gross difference between the address of the recipient provided by the legal guardian of the recipient and donor and his legal guardian also. Donor cannot remember proper route direction of the above said address, my lord.
No, lord, I tell your lordship.
And as per, my lord, may I submit? And as per the section 9 of the Act, my lord, restrictions, 9 subclause 1, my lord, save as otherwise provided in subsection 3. My lord, here is the CD and pen drive. ঠিক আছে তাই আছে এগুলো এরকমই যাবে হ্যাঁ CD pen drive. My lord, subsection 1 of the section 9, my lord. Save as otherwise provided in subsection 3, no human organ or tissue or both removed from the body of a donor before his death shall be transplanted into a recipient unless the donor is a near relative of the recipient. That is the one. That's the reason, my lord.
Not that.
My lord, subsection 3. My lord, may I read?
No, that is correct. See, only the linkage is to be proved. You are telling that your friend was coming and going on all these things, but you are not having the idea of the route of the recipient. Donor is not having the idea of the route of the address of the recipient. How you can say
related, my lord, I am telling you.
Relation is I am not in relation. Okay, unrelated also.
No. How? No, the route I am telling your lordship. My lord, my father's friend is the donor's maternal uncle. In Bengali, that is Mama, my lord. In the donor's paternal uncle's neighbor, my lord, we in our childhood days we visited. That's a family connection. From where, my lord, it came to everywhere to the relatives and everywhere that this person.
There might be some photographs.
No, my lord, there is no.
There might be some photographs between the family members.
My lord,
If
we
your
are
mama,
not
mommy, and
family
chacha,
members, my
chachi.
lord. My lord, in our locality, my lord, everybody in Murshidabad and Malda, my lord, in locality, my lord, we are not family relatives or nobody. My lord, in the neighborhood.
I am not telling the family relative. I am telling, okay, you're unrelated with each other.
Yes,
But you are has love and affection, have knowledge of each other, knowing each other. Correct. And you are intending to donate your whatever the parts to the recipient. But as per the act, if you are not related, you are the unrelated, the linkage is to be proved. Linkage is to be proved either through the report or through anything or through the photographs or through any mode. Correct. So the first paragraph, it's okay. You have relative and coming and going and all these things, it's okay. But the second line, the last line, though you are going to the house of the donor, recipient, and there is a relation, but you are not knowing the address of the donor, recipient.
That subject to correction.
Can it is believable?
My lord, I have not said, my lord, that I frequently visit that is.
Okay, then I will see the CD.
Yes, my lord. Yes. And
Then
my lord, this point has been dealt by your lordship.
That's why I dealt with that. I taken into consideration the affidavit, and that point was not raised with regard to the related and all these things. Now they are related. Now they have passed the order, reason order with regard to after the interaction. This is the problem. And whatever the monetary transaction, what is the
No,
report?
my lord, there is no, my lord.
Verification report.
My lord, kindly comes to the page number 11, my lord, of the report, my lord. Paragraph number 9, my lord. There is no old photograph of donor and recipient, my lord. So the relationship between the donor and recipient does not
You
exist.
satisfy this code? No problem. You satisfy this code? Any inch of the document that you linkage. That's all.
My lord, only one thing I am understanding, my lord, what is falling from your lordship and what is going. My lord, only thing, my lord, since he is not a relative, even, my lord, if I am no linkage, my lord, someone voluntarily, when there is an affidavit that I will voluntarily, there is no linkage. For the first time I came to know voluntarily, that is permission under the act, my lord. With subject to correction, what falls from your lordship. 9(3), if your lordship. Even if there is no linkage, my lord.
Then come to the rule 23.
Yes, my lord. Rule 23. Yes, my lord.
Rule 23.
My lord, subclause 2, my lord. The authorization committee shall expedite the decision-making process and use its discretion judiciously and pragmatically in all such cases where the patient requires transplantation on urgent basis.
Correct.
My lord, subject to correction, the act does not say that for non-relative there has to be any linkage. That is why, my lord, this act has been formulated, my lord, to rule out whether there is any financial transaction or not. That, my lord, there has been 2 police verification report which says there is no financial transaction, there is no middleman. 2 police verification report, twice, my lord, this has come out. My lord, the concept of linkage is nowhere in the act.
No, there is I am dealing with the matter that I have kept it for CAV. Kept for CAV, Supreme Court has already framed the guidelines with regard to the linkage. I have kept the CAV. That's why I'm asking the question. Because Madras High Court has dealt it will, but the Supreme Court has held no, it is the link. Okay, unrelated. So it is the court has to see or the authority has to see. Okay, you cannot, but some of the linkage, how the linkage is to be proved. And what you stated, that is not. What is your affidavit?
Well, that is
what the affidavit you stated before the magistrate. What you have stated? How you are related?
No.
Where is your affidavit?
87.
87. What you stated in the affidavit?
Well wisher.
Well, wisher. The statement which you have given before the authentication committee, that is not here. That is not corroborative. What the statement you have made before the authentication committee, that is not here.
That I
The
cannot.
mama, mommy, and going to house and coming.
That I cannot improve, my lord. That what statement? I can only say what is before me, my lord. I cannot improve whatever is.
What can be done? If you, are you
My
not joining?
My lord, only one thing, my lord. Since I am aware of the Madras High Court judgment and Supreme Court judgment, whether laid down, my lord, I will come. Your lordship, give me 2 days time. I will go through the Supreme Court judgment and apprise your lordship about it.
The counsel for the state has filed report along with the compact disc and the CD. Let the same be kept with the record. Then counsel for the petition prays for time to take instruction. Accordingly, case adjourned. Let the matter appear on 30th July under the same heading. Next.
My lord, only thing it will retain its position.
Same heading, yes. Yes, who is 12?
I'm the petitioner in person, my lord.
Yes. What is the
This
matter?
a leave for appearing in person because on the last occasion I've engaged somebody. And also there is a NOC attached. Kindly.
Who has given the NOC? Advocate?
Yes, yes.
Yes. What is the matter?
The matter relates to the matter is against the University of Burdwan. I'll just go through in gist.
Yes.
Yes.
You are the petitioner in person.
I'm the petitioner in person.
Okay.
I've
What is your name?
Shurajit Lahiri.
Yes. Who are you?
I'm
How you file this writ petition?
yes, yes.
How you file the writ petition?
I'm a candidate. I was a candidate of the. I mean, I am a law graduate, and I was studying in under the University of Burdwan in George School of Law. When it is the George School of Law is affiliated to the University of Burdwan. After taking admission in the George School of Law in 2022, the college, the constituent college under the university, had started several unethical acts. Thereafter, I raised my voice, objectionable voices, first through verbally. Thereafter, they did not listen.
What is unethical?
So first, it related to I applied for a scholarship. Then it was in the NSP, National Scholarship Portal. The National Scholarship Portal, while I was trying to apply, then I was unable to proceed with there because they gave me a message in between that your college has not uploaded the required KYC details. Then I contacted my college through WhatsApp and over phone. They said it can't be done due to some internal reasons or which they do not want to disclose to me. Then I approached the UGC for this. I wrote to the UGC. There is a grievance redressal committee of the UGC. And I got a response from them that they directed the University of Burdwan to look into the matter as early as possible. But the university did not take any action. Thereafter, I also put my representation.
What was your grievance?
My lord, may I submit? I appear on behalf of the University of the Burdwan. The facts is something different. The petitioner was pursuing his LLB course at the George College. He was at the time of the last semester, appearing in the last semester examination. The college was refused to issue his admit card or not allowing him to appear in the examination.
Why?
Because he has not cleared his dues. At that moment, on the very day when just before the examination, the date of the examinations, he came before this honorable court and filed the instant writ petition. The honorable court was pleased to give a direction to the university. The students is allowed to participate in the examination, but his result will not be published. Now he's asking for the mark sheets. We are not, as there is a direction by this honorable court, we are not issuing his mark sheet. Therefore, my lord, now we have no objection. He cleared his dues.
Let me.
Now, the only thing is that we don't have any objections because he cleared his dues. Though I am not representing the college authorities, but I have interactions with the principal of the college. The college has also no objection. relating to the issuance of his mark sheets. Now the subject matter is over, my lord. The only thing is
No, my lord, let me correct it. little
other
bit.
thing
Let
is
me
not
improve it.
irrelevant.
Kindly,
Not-
kindly come to my prayer portion of the
Want your result or not?
Yeah, that is there, my lord. Kindly.
I am asking you want your
Yes,
result.
yes,
or
my
not?
lord.
So
Yes.
what further you want?
Yes, my lord. Kindly come to the prayer portion.
If he has
Tell me.
another objection, then I have to take the
Tell
instruction.
tell me.
Kindly
Yes.
come to the prayer portion.
Yes.
Yeah.
Confirm.
Prayer number 4.
Huh?
Prayer number 4 on page 18.
Writ in the nature of mandamus to respond to conduct an inspection inquiry in virtue of section 47 of Bardwan University. Submit a report before the Honorable dealing with the reason and responsibility of non-submission of KYC data to the NSP.
Yes, my lord. Now
Whose KYC data?
the George School of Law. Why they have not submitted?
What?
I have made a
How you
representation.
are affected?
I did not get the scholarship, my lord, and I did not get my scholarship.
You challenge with regard to your scholarship. Why? But this is a public interest litigation. If you want to go to the court number 1 and file a public interest litigation. This is not the court here. It is not your public grievance here. Personal grievance here.
I was affected. I was affected.
If you were affected, where is the order? By which order you are affected?
Yes, my
Which
lord.
order?
Yes, my lord. Kindly come to Annexure 3, my lord, at page 23.
Page 23.
Yes, my lord.
Yes.
There is the on-screen screenshot of the from the NSP portal. This was captured, and it's clearly writing that George School of Law, West Bengal Institute
is not
KYC is not completed. Please ask your institute nodal officer NSP to complete KYC. Unless and until this was done, I was unable to proceed with the application. This was my first grievance, my lord. Thereafter, I made my representation to the honorable to the VC of the university and to the other registrars and all. And even I made a representation to the inspector of colleges to inquire into the matter. When I met him personally after filing my representation, he assured me in the first instance that though he will do it, but later on, due to some unforeseen reasons, the inspection procedure was stopped. And I filed RTIs thereafter. In the first
Then let they file the report whether the KYC is completed or not.
Definitely, my lord. No, for that I need to service the George School of Law. For today, my lord, kindly pass on. I have initially served them through email, but in the last order, Justice Chanda has
Kindly finish the last order.
Yes.
had directed me
Got a
to.
copy of the writ
Yeah,
application.
I'll do it, my lord. But kindly today
It's a
pass.
news story.
No, it's not a news story. It's written, everything written. Kindly, my lord, pass an order to direct the university to hand over my original mark sheet. Otherwise, my enrollment procedure is pending.
Where is the prayer? Where is the prayer?
No, it is you kindly come to the last order, my lord.
Order. That's why since beginning I'm asking what is the grievances. You want the KYC, the college KYC is to be updated. So your case is not that you may be allowed to participate. You have participated. It is not the case that the mark sheet will be because the respondent or the learner advocate appearing for the respondent fairly submitted. Yes, you have appeared. Now you have cleared the fees. They are ready to declare the result.
He has
and give
already
the mark.
cleared the fees.
Declare the result. They give the marks.
We have no
But you
objection now.
you are wanted the writ petition to disposed of. Then I will directly file the affidavit in opposition. And you are not complied with the order dated 25th of May 2025 by serving the copy of the writ petition to the college authority.
That I'm seeking leave from your lordship. I'll to file serve the notice, and I'll come back.
1 year has been passed.
No, I
May
could not.
2025 the order
I could
was
not, due
passed.
to some personal reasons, I could not do some financial constraints were there. I could not pursue this, and I was also not aware, because in the last order, my lord, you'll see that my lord has directed.
He only wants to creating the trouble before your
So
lordship.
difficulty, the petitioner could not serve the copy of the writ application to the college authority. According petition director to serve the copy of the writ application along with the annexes to the college authority within a week from date. The respondents are directed to file their affidavit in opposition within 3 weeks. Reply if any there to be filed within 2 weeks thereafter. List the matter in the command monthly September 2026.
My lord, kindly grant the order, my lord, to release the original certificate, my lord.
Learned counsel for the respondent submit that the petition has already cleared the dues and his result has also been declared. Accordingly, college authority is directed to release the mark sheet of the petitioner if no other.
My lord, university you should be directed because
University is directed to release the mark sheet of the petitioner if no dues are pending against the petitioner.
grateful, your lordship.
But this is not his case. So what he has submitted before your lordship, he is creating a new story.
That is there. That is
Yes, sir. He's always creating that.
that is there.
Yes.
Yes, call the list.
My lord, in this matter, I
May
want to
I
submit the
pray
instruction.
for in-camera proceedings, my lord?
My lord,
Which
I am
one?
submitting
13.
the report.
This matter involves a child. A child is involved, my lord. I'm praying for in-camera.
My lord, I am
This is the
submitting in the copy of the
The
report.
grievance of the petitioners are that the petitioners are the adoptive parents. Now, my lord, what has happened is on 2023, the private respondents gave birth to a child. But due to financial constraints, they handed over the child, newborn child, to the petitioners. From 2023 to 2026, they brought him up.
my lord, may it be taken up on Tuesday, my lord, at the top of the list, so that
136.
my lord, 136.
Where is your other side?
My lord, we couldn't give notice because morning, your lordship was troubled with so much matters, my lord.
Let us see.
Lordship will take it up on Tuesday, my lord.
I will see that. I will do that. No problem.
So item 139 extension of interim order, Your Lordship.
Which one?
Item 139. Your Lordship, Mr. Chaudhary is also here.
My lord, I am led by Mr. Choksey to this matter, my lord. My lord, on the last occasion, I forgot mention this matter because of the.
Should kindly see, Your Lordship, the last line, Your Lordship. We want, Your Lordship, I don't have any problem tomorrow. It's okay. Lordship, till that time, Your Lordship, they should not.
We have the affidavit ready, my lord, indicating in a sketch as desired by our lordship that it's a case of mistaken identity so far as the petitioner is concerned. On the sketch, my lord, because the tender value is also 14 lakhs, theirs is a different one. It's a case of mistaken identity.
So this is identical. So I'll show.
So, my lord, if lordship wants, I can show it now, or lordship keeps it tomorrow to be mentioned. I'll
Yes, sir.
come and show it to your lordship.
But till then, Your Lordship, only.
Let the matter appear tomorrow. Let the matter appear tomorrow. The interim order is extended till tomorrow. Tomorrow has to be mentioned.
Item number.
Interim order may continue. I'm grateful.
Item 20, my lord.
Yes, what is the item 20, Mr. Bari?
Petitioner's passport, renewal of passport has been withheld. He is in service of shipping, merchant navy of a UK based company. The requirement was his passport should be valid till 6 months. That will expire. That's why.
When it is going to expire?
Going to expire.
When you applied for?
This year, they have given a deadline by 26th. I have to renew
26th of?
26th of this month. On Monday.
Item number 20.
20
ना कल 5 मीटर के अंदर कर दो. Within 5 meter kal kar.
Within 5 meter tomorrow. Very well, my lord. Very well.
Yes. Now the original side.
Item 14, 15, 17, I had mentioned before your lordship.
Yes.
Unfortunately, one of your lordship. After the 2 clear matters collapsed.
But what will be done? Every 10 minutes is to be given some one matter.
The only thing is that there's a DN on the account which they have created, they indicated to your lordship, the Bank of Baroda.
Come tomorrow, come tomorrow.
But the lordship keeps it within.
Yes.
There was a specific direction that.
We'll see that tomorrow. Come tomorrow. We'll see that there. Cause it. Let me settle the cause it. It will be tomorrow at least. That's the plan.
Otherwise, if I may mention tomorrow morning.
No. It will be see the causes today. Because our other matters which is I have kept. So I have to adjust all this. Which matter? Yes, sir. Please wait.
Is that a change or
Madam, may I have your lordships kindly to mention.
Very urgent case. It relates to judicial service of Consumer Affairs Department. 23, the Honorable Supreme Court in the Bhaskar Limaye case, Mahindra Bhaskar Limaye case has been struck down the recruitment rules. Last year in Ganesh Kumar case, considering the fact
Pick the time frame.
The president are continuing and repairing soon, they will new service rules. New service rule has I made a representation which has not been considered.
Who are you?
Notice to hand over the judge by 31st of.
Who are you?
Member of the State Commission bench 3. I have been notice to hand over the charge by 31st. I approach Honorable before the Honorable Supreme Court. Appropriate court for an appropriate direction. Give me lottery, please to fix this.
When what is the date of the superannuation?
15th.
15th of August.
This month.
15th of July. 15 is over.
July has been granted leave, but I have been asked.
When you are going to superannuate.
31st July, I have to hand for the charge. This will cause interruption in consumer justice. My lord, may I hand over the Supreme Court order?
Yes, what is your instruction? Approach the Judicial High Court. You approach this, you file the writ petition. Have you served?
I have already served.
Tuesday, देखो.
Monday, let it be fixed.
Tuesday.
Tuesday.
But may I have your lordships kindly to mention item number 194 of your lordship's list for extension of interim order is going to expire today. But we are here, but unlikely, my lord, it may be taken up.
194.
But I'm sorry, my lord.
Who is for the other side?
My lord, I've given notice, my lord.
Excuse me.
I've given the notice to all.
Lordship, I
You are
appear,
appearing.
Lordship, I appear for the other side. Lordship, we were suffering from an interim order since 3 years, your Lordship. If the interim order was passed in 23, Lordship, some precedents may be given. The matter is fixed for hearing, your Lordship.
Please say if anybody is suffering with any interim order, come on Saturday, I will take.
Lordship, if any precedents may be given, your Lordship.
Item number
194.
194. Though the matter is listed as to be mentioned as item number 194, but due to paucity of time, the matter could not be taken up for hearing. Then counsel for the plaintiff to mention the matter for extension of interim order. Then counsel for the correspondent bank raised objection and submit that due to the interim order of the bank is suffering badly and prays for early hearing of the instant application. Consider the submission made by the counsel for the parties. Interim order is extended. The date is extended till 26 August 2026 or until further order.
26
whichever is earlier. Let the matter appear on 26 August at 3 p.m.
Kindly, may I have your lordship's leave, my lord, to mention this is a wax pool matter. The 10th appeal that
And I am leading a mallet. If your lordship can give 1 day.
We are for the respondent.
10th appeal, mallet.
We are for the respondent, my lord.
Mr. Banerjee is looking very relaxed, mallet. So, mallet, in this situation, if your lordship can fix the day, mallet.
I don't think that's the criteria, my lord. It's my lord's court, my lord, which has to be relaxed. I think my lord's court is extremely hard.
I know, but mallet, we are just requesting if your lordship can take it up.
So what had happened was your lordship had fixed it on 11th or 13th May. Well, the court didn't sit because your lordship was in circuit, perhaps. After that, we didn't bother the court, my lord, after the vacation. So that's why at your lordship's convenience.
तो लिस्ट में नहीं है ना?
Yes, yes, mallet. Just list.
Would it be?
एक काम करो
No.
To be mentioned में को तो देना reflect.
Wait.
Let it
Very
fix to
grateful.
mention, fix the date.
Very grateful, mallet. Very grateful.
Tomorrow to be mentioned, my lord.
Tomorrow to be mentioned, then I will fix the date.
Very well, very
grateful.
well.
Very grateful, mallet. Very grateful.
My lord, my lord.
This is an application connected to a suit, my lord. It has been disposed of, my lord. I have handed up the copy of the order, my lord.
137.
187.
187.
1000.
I will tell my court officer to have to give a cup of coffee to you for withdrawal of
My lord, I am appealing for the respondent in this matter, my lord, the defendant.
Yes.
My lord, both the parties have arrived at a settlement.
141.
87.
187. Application.
This is an application, my application. I am withdrawing because the suit has been.
So the matter is listed as item number 187, but the land counsel for the petitioner or plaintiff. Petitioner or plaintiff. Plaintiff mention the matter and submit that the main suit has already been disposed of by way of a compromise decree. Accordingly, nothing remains in the present interlocutory application. She prays for withdrawal of the present application. In view of the submission made by the counsel for the plaintiff, GA number 8 of 2025 within bracket Dhandolat Holding Limited versus Jeevan Lal 1929 Limited in CS number 254 of 2021 is dismissed. Interim, if any, first intermediary, if any, stand vacated.
My lord, I seek my lord's time leave to mention another matter. My lord, item 188. My lord, the interim order is expiring today. My lord, 188, my lord.
Who is for the other side?
My lord, we have given notice duly served.
But we are appealing for one of the defendants, defendant number 13 and 14. My lord, if
This is
any
that matter wherein there are several defendants. My lord.
several defendants, in one of the cases, my lord has already vacated the interim order. Others are pending any date. But in the month of
Yes,
September,
that one.
My lord, that one. The
month of September also, my lord.
So the matter is listed as item number 188, but the learned counsel for the plaintiff mention the matter and submit the interim order still today and paid for extension of interim order. Learned counsel for the learned counsel for the respondents, defendants pays for
But
fixing.
there are many different.
That's one now, defend number 13 and 14. Praise for fixing a specific date and time for hearing of the matter. In view of the submission made by the counsel for the parties, give the date. Interim order is extended till 24th of August 2026 or until further order whichever is, let the matter appear on 24th of August at 3 p.m. 3:45 p.m. Next.
345. Obliged, my lord.
Item number 18. Yes.
Instruction.
Item number 18 record. Land counsel for the petitioner submits has handed over a written instruction dated 20th July 2028-6, wherein the petitioner has informed the learned advocate on record of the petitioner that the petitioner is not intending to proceed with the matter. Inform the learned advocate. The petitioner has informed the learned advocate on record of the petitioner that the current account maintained with the bank, Bandhan Bank, has been made operational and nothing remains in the present application and he plans to withdraw the present application. In view of the submission made by the counsel for the petitioner and the communication dated 20th July 2026, WPA number 334 of 2026 is dismissed as withdrawn. Interim order if any stand vacated. Communication be kept with the record. Next.
Item number 1.
Yes.
Lordship, I am appearing for the defendant bank.
Who is for the petitioner? Plaintiff? Yes.
Lordship, the plaintiff had preferred one SLP. The SLP has been dismissed.
Dismissed. That's why the court has now the matter is remanded here. Findings of tentative and the subject matter final outcome of the suit. So what is the stage of the suit?
Lordship, there's a division bench order of this honorable court which says the claim has to be amended. If Lordship comes to the second last page of the order, the direction is given how the plaint has to be amended.
Dispose of the amendment of the amendment application, the appeal and the cross objection ordering. Amendment in the body of the plaint are allowed just for the purpose of bringing on review subsequent events subject to the observation of the judgment. Claim B1 deleted. So then you have to amend the plaint.
Lordship, the amendments has to be carried out.
Carried out.
Has to be carried out by the plaintiff. The one additional amendment is the defendant bank, which was Bank of Rajasthan. Now it has been merged with ICICI Bank. Lordship, the fresh writ of summons have to be issued.
The plaint achegi. Only one bank.
Only yes, Lordship.
And you are not carried out the amendment.
Have that instruction. This order is also long back, so with regard to melody.
The matter is listed as to be mentioned on receipt of the order passed by the Honorable Supreme Court. Supreme Court dated 17 June 2026, wherein the Honorable Supreme Court has dismissed the SLP, but has clarified that the findings of the findings are tentative in nature and subject to the final outcome of the suit. Full stop. The counsel for the defendant has handed over the copy of the order passed by the Honorable Division Bench dated 26th of April 2018, wherein the Honorable Division Bench has disposed of the amendment application and the appeal by following order, 8 of Corridor. Following. Then a counsel for the plaintiff prays for time to take appropriate steps in terms of the order passed by the appellate court dated 26th of April 2018. The non-counsel for the defendant bank further submit that though the plaintiff has filed the suit against the Bank of Rajasthan Limited, but now the Bank of Rajasthan has merged with ICICI Bank. Accordingly, the counsel for the defendant is directed to communicate the correct name and address of the respondent bank to the counsel for the advocate on record of the plaintiff within a week. On receipt of the said communication, the defendant bank, the plaintiff is directed to correct the cost title of the defendant bank. The defendant in within a week thereafter. This is the matter on 18th of August 2020.
Lordship of liberty to issue fresh writ of summons.
Let that come first. First they'll carry out, then I will pass it.
Time for the plaintiff petitioner.
Yeah.
Opposing, my lord. Today is the date for your lordship filing the written notes of arguments.
Yes.
My lord, my written notes of arguments is also ready, but only thing is that, my lord, the compilation of judgments, my lord, may I, my lord, file it during the course of the day?
Yes.
The compilation of judgments.
Ours is ready, your lordship, with compilation of.
Written notes of argument filed by the parties be kept with the record. CAV.
I'm grateful.
Next.
Item number 3, my lord, I'm appearing on behalf of the plaintiff, my lord.
My lord, I'm appearing for the defendant.
Led by Mr. Rohit Banerjee, my lord, is appearing online.
Yes.
My lord, this is, my lord was pleased to appoint Mr. Special referee.
Yes, it got filed.
No, my lord, it is done, my lord. Only one sitting is required, my lord. I am only praying for a short extension, my lord, for.
Though the matter is fixed today for filing report by the special referee, but the learned counsel for the party submit that further one sitting is required to decide the issue by the special referee. Accordingly, she prays for extension of time to file report by the special referee. In view of the submission made by the counsel for the plaintiff, time to file report by the special referee is extended till 25th of August 2020.
Shorter time may be given, my lord. It will
be done.
It will be done, my lord, by 12th
5th of August is the next sitting, my lord, and hopefully it will be done.
August, no? Then 13th August.
Much obliged.
Much obliged.
Under the same heading. Yes, next.
Item number 4 and 5.
Lord, I appear for the petitioner as
Four and
Mr. Thakur. And
let it come on Monday, Tuesday.
But the only problem is that the bank is taking further steps.
Okay.
Restrain the bank from taking any further steps.
Tuesday I will.
Let's say we wait for the lordship's order. Auction is in the month of August.
Okay. Tuesday.
That will abide by the lordship's order.
Because, my lord, after service of the writ petition,
He's telling that.
No, my lord, Tuesday we've written to them also. We'll come back on Tuesday, my lord.
Tuesday.
Obliged.
Next.
Item number 6.
Yes.
I made a promise to finish, not 45 minutes maximum is what I need, not what I'm doing is
But 20 minutes short.
I'll try and make it shorter.
No problem.
Let me do, Badmashi. I will make Mr. Abhi Mitra Mlad in that case distinguish some of the cases. No, in his turn, when his turn comes. So Mlad, two very short points before I go to the judgments. Won't take long. The rules. Now, there was, in addition to Mr. Mukherjee's submission that he has ceased to be a trustee, but Mr. Anirban made a submission that he has been removed pursuant to the rules, in accordance with the rules. Now, this seems to be a pleading from a statement from the bar. There is no specific pleading to that effect, but he relied on two rules. So his submission was that he has been removed, but under Rule 5I and 5G, which your Lordship will find at page. CA 16, GA1, page 60. Yeah, got it. But if your Lordship comes to page 59, where Rule 5 starts.
Page 9.
Page 59, 5-9.
Yes.
Rule 5. A member shall cease to be a member of the society if and G, which is on the next page,
Yes.
become disqualified by an order of court for any reason. 5I. He acts prejudicially to the interest of the society and a resolution is passed by the society against him by 2/3 majority. So he relied on these two rules. Now, as far as that is concerned, I showed you that there is no order of disqualification under 5G.
Yes.
5I, your Lordship will find, even according to the resolution that they are relying on. But firstly, like I said, it only records what the APO has said, but it does not say that he, because he has acted prejudicially to the interest of the society, it doesn't say removed at all. On the contrary, it says seized by virtue of the High Court order. So these two can't apply.
Yes.
Now, your Lordship will find this rule relates to membership. And trusteeship, which is not Rule 47 at page 69. A trustee shall vacate office for the reasons for which a member of the society shall cease. So he linked 47 with Rule 5, G and I.
Rule 47.
Yes, ma'am.
A trustee shall vacate his office for the reason which is the member of society says yes.
So that's why he says for removal of trustee, the same rule 5G and 5I will apply. I've showed your Lordship not 5G and 5I don't apply, and your Lordship can make a noting that this submission not is also not the case made out. And of course, the additional factor, which I pointed out not yesterday, that even after these orders, he has been attending. So that takes care of one argument.
Yes.
Now, the other argument, which Mr. Mukherjee made, not very strongly, and he cited a judgment on it. So I'm dealing with that. Now, he says that, look, even if the order of Justice Munshi is set aside by the division bench, the resolution remains. It will remain unless it is set aside by an order of court. So you have to file a suit.
You're not challenging the resolution.
I'm not challenging the resolution. So that Mr. Mitra will also not, I suppose, deal with it because he's the one concerned.
But not here the answer is very simple. I've showed your lordship, there is no renewal. As far as the resolution is concerned, what do they say? Seized by virtue of is recorded as a, it's merely taken on record and confirmed, nothing more. So there is no at all. Well, like I records a state of affairs which is non-existent. So if there is no resolution at all, or sedation, whatever you call it, the question of challenge does not arise. That's my simple answer here. There was no need to challenge it because there is no resolution pursuant to, there is no court order and there is no cessation pursuant to court order.
Yes.
Number two, there is no independent removal.
Yes.
Number three, I've showed your lordship, the division bench says that APL and no one else had, and all these people had no authority. And the probate court itself did not have the right, lack of subject matter jurisdiction. Now, in this regard, my learned friend took his argument one step further. So he said, no suit has been filed, and today the suit will be barred by limitation. That was the next limb of his. So then, he has relied on two judgments. On COVID limitation, I'll just deal with that in a second. But firstly, the COVID limitation, if it's taken into account, time had not finished. It's still not gone. But forgetting that, like I said, there is no limitation. There is no question of challenging it. That's the simple answer. But the person affected, Mr. Lodha, I think Mr. Abri Mitra is representing him, he'll deal with it. But a judgment was cited not on this account of two judgments. Not that I'll distinguish.
The judgment.
But first one cited by Mr. Mukherjee on this. That was 2005 1 SCC 754. So his argument was setting aside by the division bench doesn't change things. You need a independent order. And that judgment specific provision that says when you are disqualified on a particular date, file a nomination, there should be no disqualification on that date. So what happens is, therefore, nomination paper was rejected. Now, let's say that disqualification which the gentleman faced because of not a conviction or something, if that was stayed, what is the effect? So naturally the court said that in view of the specific provision of the Representation of People Act, it can't date back. It cannot. But let me show your lordship a few paragraphs here. But if your lordship would come straight away, but to question 1, which is at page 771, para 28 is the question. The lordship has got para, I'm sorry.
Yes, question number 1.
Under clause of subsection 1, section 4, the court is called on to decide whether on the date of election a returned candidate was qualified or was disqualified to be chosen to fill a seat under the constitution of the RPA. If the answer be in the affirmative, the High Court is mandated to declare that the election of the returned candidate is void. The focal point by reference to which the question of disqualification shall be determined is the date of election. That's the specific provision in the Act. Now, please come to para 30. Now, the statute is being set out under subclause 1 of clause D of subsection 1 of section 100. The proper acceptance of nomination is bound for declaring the election. Acceptance of any nomination for declaring the election void. Then good qualified or not qualified, who is disqualified for being chosen to fill a seat has to be determined by reference to the date fixed for scrutiny of the nomination. This is the focal point. Decision by the returning officer has to be taken on the facts as they exist because the act says it's that day. Returning officer cannot postpone his decision, now can make it conditional upon what subsequent to that date. Under section 100, the court has to test the correctness of the decision taken by the returning officer on the facts whether any nomination is improperly accepted by reference to the date of scrutiny of the nomination as decided under 36(2). So, if on that he was disqualified, the fact that the disqualification goes away 5 days later or 5 years later will be irrelevant. That's what this says, Then, if I were read on all election petitions and tried by a court of law proceeding which are held by the legislature in can be proceeding in election petition, we called or termed as continuation of election proceedings. The High Court trying an election petition is not hearing on against the decision of the returning officer or the declaration of result of a candidate. Then the lordship goes to the next para. With respect to the learned judge who decided in Manindal's case, the fallacy with the judgment suffers is presumably an assumption as if the election proceedings are a continuation of the election proceedings. But another fallacy with the judgment in HON'BLE suffers is that if a High Court has to form an opinion on the disqualification of candidate at the time of pronouncing judgment in the election petition, that is not correct. Undoubtedly, the High Court is forming an opinion on the date of the judgment in the election petition, but the petition has to be formed by reference to the date of scrutiny. Based not on such facts as can be fictionally existed on the date back dictated by some subsequent event, but based on the facts as they actually existed then. So this is interpretation based on the act. That does not apply in our case. The correctness or otherwise of such decisions by the returning officer cannot be determined. Of the judgment. So subsequent events, including setting aside, will not matter. That's what this is saying. Then, if your lordship turns the page, considers the law, and please see the findings at para 37. The factors are relevant. Firstly, the sentence of death was passed in judicial proceedings, and the judgment of trial court became a continuation of these proceedings. But they are distinguishing that earlier case on something else. The court will, sorry. Proceeding, the court was not powerless to take note of subsequent events. The sentence of death was passed based on an event which ceased to exist during the pendency of the such subsequent event, failing which a grave injustice would have been done to the accused. Secondly, the court interpreted 3 which speaks of person under sentence of imprisonment for life as meaning a person under an operative executable sentence of imprisonment for life. A sentence once imposed but later set aside is not executable and therefore ceases to be relevant for the purpose of section 103. Thirdly, the focal point was the date of conviction when the court is called upon to pronounce judgment. Fourthly, it's pertinent to note that the well-established proposition of the court pressed into service was that, but in Kumar Sharma, a court seized a proceeding must take note of subsequent events to the inception of the proceeding, which position the court held to be applicable to civil as well as criminal proceeding with appropriate modification. Then let's see the next lines. The emphasis on the events happening subsequent to the inception of that proceeding. In the cases at hand, the principle laid out in Dilip Kumar Sharma will have no application in which the validity of nomination is to be tested by deciding qualification or disqualification of the candidate as on the date of the scrutiny and not by reference to any subsequent event. So this is saying that in other criminal matters and in civil matters, in fact, you can look at the subsequent events, but not in a election situation. So this helps me, then your lordship can also see but para 38 actually says the same thing. And then your lordship comes to 41. Disqualified subsection. Under 36(2)(a) shall be liable to such decision of the returning officer cannot be held to be illegal or illegal set aside or altered so as to go out of 8(3), so consequent upon a decision of subsequent date in criminal appeal. This is sees that you will find the last 3 lines of the bottom. This case is considered and then one at the bottom. However, still the Constitution bench has made a significant observation, which is very relevant for our purpose. The Constitution bench observed. It's quoted on the next page. Retrospectively. So, not other than the case under 3, it actually operates retrospectively, which is exactly what I've been arguing. Takes effect retrospectively and wipes out the sentence awarded by the lower court. The lordship will remember I cited 2 judgments saying wiped out as erased as if not there, dates back. This implies that the stigma attached to the conviction and order of sentence are complete. But that does not mean that the fact of conviction and sentence by the law court is obliterated. Sentence is set aside by an appellate court. In our case, it has been set aside by the appellate court. The conviction and sentence stand from the decision of the such as of the reputation that are determinative of the disqualification provided therefore.
Yes.
Then not 44 will therefore be judgment of a date subsequent to the date of nomination or election, as the case may be, and having bearing conviction. Specific provision of 8(3) relevant date being the date of nomination. Now, your lordship can also make a note. I showed 2 judgments on this point. 2007-3, but I've showed it to your lordship in some depth earlier. 2007, volume 3 SCC 557, paragraphs 18 to 30. Sorry, 557.
3557.
No, page 557.
557. Yes.
Oh, my lord, I should have said 557. It would have reminded me of a game called Housey. And the other one was 2012, 13 SCC 340.
2012.
Yes. 13 SCC 340. Now, both of these said, not if your lordship wants to make a note of the para 21 for the first judgment. And for the second judgment, para 36, 41, and 42. This is on the point that once clarified, it is as if the earlier judgment did not is erased, does not stand, status is revived, all of that.
Yes.
So, that takes care of Mr. Mukherjee's argument on this point. But there was another judgment which he had cited. 2003 SCC Online Calcutta 224. No, that was in limitation. But I'll deal with that later. I'll leave that for Mr. Mitro. But the other one which he relied on, was 2019. So, yes, 2019. 2019 14 SCC page 1. The showed para 56. Well, here also, the para 8 and 56 were relied upon. What proposition I'll tell your lordship. But here also there was a trust.
Yes.
And the trustee was revoked.
Yes.
The clause itself required a conviction.
Pendency of the criminal proceeding will not be debarred the appellant.
But so not here the specific clause, disqualification clause actually required conviction. I'll show that to your lordship. And the disqualification on the term according to the because there was no conviction. No. Actually, now give the para na to commentary na di. But if your lordship comes to, but I'll skip the irrelevant facts. But please come to para 8.
Yes.
The learned single bench also did not find merit in the argument that the appellant incurred disability on account of cases against him in terms of clause 6 of the Waqf deed. So they were pending.
Yes.
The learned single so not this is the situation that and your lordship will see the clause which is set out in para 8. But at the bottom, the clauses.
They have relied upon this because you have taken the point of the criminal cases.
No, that's not the ground for. But that's not the ground for. But please remember. But look at the clause here. He is dishonest, addicted to alcohol, gambling, or has been convicted of some crimes involving moderate or turpitude. So conviction is required in this case.
Correct.
In our case, it's not. In our case, conviction is not. In our case, the ground for removal is acting against the interest of the trust. Your lordship will remember the.
Correct. Now that's why now
and it's permitted. So
they have cited because you have pointed out with regard to the criminal case.
Very.
Yes.
But are the ground?
Not on the ground.
So, my lord, this is also not applicable. Then, my lord, these two on limitation, right? Now, my learned friend Lord then cited 2 judgments on limitation. But which I am not, according to me, it doesn't apply. But if required, Mr. Mitra will deal with those. But your lordship, if your lordship wants to make a note, I can just give it to your lordship. But 2003 SEC online Calcutta 224, para 30 was relied on.
2003?
SEC online Calcutta 224. Para 30. This was on the point that not the suit would be barred by limitation today. This also was for 22.3. Which leaves me, Lord, one judgment only, which Mr. Mukherjee had cited.
Yes.
Mr. Ray's case, I'll deal with later. No? Where, Lord, in place A, notice was served to him in place B with knowledge. Number 2, Lord, it was found to have been done, Lord, without requisite period of notice and done deliberately to throw him out of the control and charge of the company. This really is what this judgment was about. I'll just show you lordship the judgment. But please come to
Para 30.
But para 7, para 7, please. But not the numbering is strange. But please come to, I think it will be easier if your lordship not comes to the page with para 8 and then turns back one page. Because it's a long page without any para numbers. Please come to para 8 and then not turn to the page for that. There's a quotation at the bottom, that's the order of the NCO, not CLB. Now I'll just read from there. But ultimately, the CLB held as follows in view of a finding that no notice should be deemed to have been served on the petitioner directors for board meetings. Decision taken in these board meetings granting that they have taken.
Because this is SCC online.
My lord, I also have SCC on.
Page.
Not PDF page 10.
PDF page
On top, your lordship will find a printed page 10 next to SCC online
I don't
logo.
think page 10 is there. Page 9 ends. Which
Lord,
one?
Lord, is this Ruby Hospital? I think your lordship.
Ruby, not.
That's the one I'm citing, Lord. Your lordship has something else, not?
What is the citation, Ruby?
2067 SCC 613. Very common. Yeah, yeah. ठीक है देखिए let's deal with the judgment.
Okay, give the citation 2000.
2006 7 SCC.
Page.
Please give me a moment. बोलना यार from the 613.
Yes, para 7.
No, but I was just going to read from there. But there was an order of court saying specifically you must give 21 days notice and it must be given by registered post. Now what they did was this gentleman lived abroad. They would send notices. When he came to India, he would live in place A. They would send notices to place B and those were sent under certificate of posting, not by registered post, and did not comply with the court order saying give 21 clear days notice. This was the factual backdrop.
नहीं है.
Not there. Lord,
We have a copy.
Lord, I'll ask Mr. Mitro to deal with it in that case. Lord, I'll ask Mr. Mitro to deal with it because I want to finish it off today. Oh, found.
Yes, yes.
So please come to para 15. I won't.
Yes.
Para 15, but I showed your lordship order of CLB. Thereafter, the following relief was granted by CLB, which can be summed up as follows. The vacation of office by directors cannot be sustained. But that first para I showed your lordship was earlier not properly given notice. It was directed that in future issue of notices for board meetings should be made by registered post before 21 days to the address of the usual address in USA. And what the lordship will see 4 lines from the bottom of that para, it was further directed. Status quo shall be maintained till the matter is disposed of by the Calcutta High Court. There will be no change in the composition of the board, other than the appellant directors will function as directors in addition to executive directors. And then this order of CLB was set aside that your lordship will get at the bottom of para 16. Now, my lord, what did they do? Now, please come to para 35.
Yes.
In Madhusudan versus Kerala Community, it was found that notice of not less than 21 days service or service by post. And in fact, it was found that the requirement of section 181 complied with under section 53 of the Act. Service of the notice of the board meeting by post and by certificate of posting was not found to be reliable when the relationship between is here. Now, it is no one's case, but in our case, that notice was not sent. All the other trustees, including the ones on their side, have got it. Where cases look, he was in police custody. Therefore, he did not have notice. This is their case.
Correct.
Now, this matter is based on Companies Act. We trust statutory requirement. Case, it says that in other circumstances we can. Now, please come to para 46. But the pleading of the other person, not your lordship can make a note, but the one is pleading is at page 33 of his affidavit, and he says, notice and agenda were issued to me through email at 6:48 a.m., etc. So he not admits receipt. Now, if your lordship comes to para 46,
Yes.
now what do you and they change the entire shareholding of the company? That your lordship will find in 46. CLB has in mind detail discussed with regard to all the resolutions which had already been adopted. Served on the shareholder of the company. Service of notice only respondents. Such validity cannot be said to be valid. Now, here's Newman's case that I have not served. He could not act in terms of it because he is in his custody.
Yes.
Then you will find this would show subtle attempt to show several notices were given to shareholders of the company at their local addresses in India, fully well that both are NRIs. The outstanding feature is that the appellant Dr. Binod Prasad Sinha has been shown as an NRI, but notice to him was sent to an address in Hirapur, Dhanbad. So this is the kind of fraud that was happening, and there's much more than that. And notice was given to the other person at a house which he doesn't stay in when he comes to Calcutta. That's what not the rest of the paragraph is about. And not on that basis, blood he was removed and set aside by the Supreme Court. This is the facts of this case. Now, my lord, coming to the cases cited by Mr. Ray. Please make a noting saying that not there is no question of any fraud over here at all. Society and trust. So these two judgments which he cites are 1994, one SCC page 1 and 2012, 12 SCC 133. These two are on unclean hands. No, I'm not dealing with it, no, I'm just. Now, SCC 422 was cited by him, distinguish between the difference between novelty and irregularity.
Yes.
And this supports the principle that I have not indicated. But I'm not showing your lordship the judgment again, but your lordship will remember I showed your lordship AIR 1969 Supreme Court official trustee versus Sachindra. There was a distinction between not jurisdiction as to subject matter and other kinds of lack of jurisdiction. If it's pecuniary or territorial. Now here, like I've showed your lordship, this is lack of not jurisdiction as to subject matter, and not 69 Supreme Court, which is still good law and followed everywhere, makes it clear that the order is void.
Yes.
And as if it did not exist. That was the language. Now, your lordship will see that if your lordship has got this judgment,
Yes.
But if your lordship comes to para 11. So now what this is considering that in a case of it is if an order is passed without service of notice, but if some paper is not made over, if there is violation of natural justice, then those orders are not bad. See, for example, para 6. So if something is done which is contrary to a mandatory provision of the Act, the effect of that under different statutes. Now, under para 11, if your lordship sees, we may not know much of this because of legal proposition and also because what was pointed out by the Constitution bench in Bhulabhai, that exclusion of jurisdiction of civil court should not be relatively inferred. So we agree with Mr. Mehta that the High Court had in civil court jurisdiction was barred in which is the violation of mandatory provisions contained in 17. Said the response had no jurisdiction to pass the improved order, and by doing it, they committed a jurisdiction.
Yes.
And then in para 13, it goes on to say that not the court should hear the matter properly. Pass an order after not the court accordingly should not mechanically set aside order of dismissal on the ground that the report was not given. So not the mere fact that a report is not given to someone who is being charged with an offense is not a ground to say it is without jurisdiction and it is not a situation at all, Lord. Where it is a case simply, Lord, as I have argued it, a lack of subject matter jurisdiction by the probate court, which is not upheld as such by the probate court and the division bench, and the effect of it.
Yes.
This is not a case of irregularity.
Yes.
And but the fact that there is no subject matter, not jurisdiction is now acknowledged by them, because now instead of going to the probate court, they file not suits everywhere. Including this suit. Then my learned friend got cited AR 55 Madras 430, para 17. Now, this is to do with principles for appointment of a receiver. Now, please remember the grounds on which I'm asking for it. I've already argued it not earlier, but I'll just summarize very quickly. There are two rival camps. One camp is led by and had control of someone who today gives no explanation for stealing. There is admittedly a stalemate. That is the case in their petition and our petition. There is a stalemate today. But therefore, and not just that, it involves public interest, not thousands of students involved. We have asked for appointment of an administrator. Now, principles for appointment of administrator are not exactly pari materia with receiver, which comes within order 40, but not what the court is saying here. The 5 principles, please have a look at. My learned friend cited para 17. We rely on para 17.
Which citation? 97.
But 5 Madras, page 430.
1955.
Village. So there is stalemate. Both parties have filed 144. There is a problem. And but तुम्हारा iPad पे देवे नहीं है 55 Madras sir. No, I'll just hand over my para 17 निकालो. But if your lordship doesn't mind, can I?
Yes, yes.
तुम लोग दिया यार क्या क्या दिया पता नहीं है जज के पास ही नहीं है हाँ
Para 17?
Yes, ma'am. But they relied on this. I'll just read it. This taken one stray line. It's illustrated. 5 principles which can be described as the sadachar of a courts exercising equity jurisdiction in appointing receivers as follows. The appointment of a receiver pending the suit is a matter resting in the discretion of the court. So, no, the lordship has the discretion. This much is admitted. Discretion is not arbitrary or absolute. It is sound and judicial discretion, taking into account all the circumstances of the case, exercised for the purpose of permitting ends of justice and protecting the rights of all parties interested in the controversy and the subject matter, and based upon the facts that there is adequate remedy and accomplishing the desired object of the judicial proceedings. So, Lord, here your Lordship sees it's basically something saying it is necessary to do it, and your Lordship does obviously not going to exercise discretion in an absolutely arbitrary manner. But one assumes that your Lordship will do it happily, but it must be to ensure that the ends of justice are met, which is not protecting the rights of all parties concerned. Now, if an independent receiver is to be appointed, or an administrator, the management can't have nuance, and what the authorities for that are given. Then number 2, court should not appoint a receiver except upon proof by the plaintiff that prima facie there are excellent chance of succeeding in the suit. Now, Lord, in this case, hopefully, Lord, I have persuaded yourself, your Lordship, Lord, that well, at least decent chances. But 3, not only is the show of adverse and conflicting claims to property. Now, well, it is admitted, but he must show some emergency or showed that because I came to court straight away.
Yes.
And truly said that the court will never appoint the receiver. I'm saying prevent future harm, and not just to the society and its not properties, but also not that of the students. Then note 4, an order appointing receiver will not be made that has the effect of depriving the de facto position, since that might cause irreparable wrong. The dispute is to title only. The court very reluctantly disturbs the possession by the receiver, but if the property is exposed to danger and loss, the person in possession of a third or first, the court will interpose its receiver. But this is exactly what we are saying.
Yes. Yes.
And then 5, that the court on application of receiver looks at the conduct of the party who makes the application and refuse to interfere unless his conduct has been free from blame. He must come to court with clean hands and should not have entitled himself to equitable review for virtues, etc., etc. So, these are the principles from their judgment which I am relying on. But on this side, citing 2 other judgments. Not one was not. I cited 2 judgments on the necessity of appointment of a receiver. But one was the case of Lamartine. Your Lordship can make a noting. And the other one. But I'll just give that to your Lordship. But which leaves only one judgment, was South India Artists, which was not a printout from the High Court. My learned it has no reference per se, but the cause title I'll just give your Lordship.
South India Artist.
But Madras High Court judgment by the name of South India Artists Association versus Registrar of Societies. Now, this was an interesting argument made by Mr. HON'BLE. Well, what he said was, but I must say, it's an argument of desperation. I'll tell you, Lordship, why. Because we argued that there is no cessation because of High Court order. There is no High Court order. There is no resolution of removal. So now he goes a 3rd step down the ladder. He says, very well, even if there is no High Court order, the resolution is a contract. So this contract is binding on you. This is the submission made. And he relied on it for this purpose. Now, this is not now digging very deep down. Fact of the matter is not that resolution, if it is to be a contract, is neither signed by HON'BLE, nor did he attend the meeting. Now, how can it be a contract? No, let me just place it. Yeah, now, the principle that he relies on is para 18. In this regard, reliance was placed on the judgment of the Honorable Supreme Court in Siddheshwar Shankari, Shekhar, where it was held that not a person, para 48 is quoted, a person by becoming a member of a cooperative society volunteers to abide by the bylaws. Now, please mark this, that I have no dispute with that proposition. Of course you do.
Yes.
By becoming a shareholder, also you articles.
Yes.
The real object which is to provide for internal management, including assistance, etc. Now, I'll not skip it, then I'm not very well. There is authority for the proposition that bylaws of the cooperative society constitute a contract between the society and its member. So, bylaws, again, no dispute. That is the principle over here. Now, but the authorities are listed. Now, the proposition to then pull this and say that the meeting of the society will also be a contract, does not flow from here. Does not flow from here. Para 19 was to do with the bylaws. Para 18, para 19, have a look at. That's to do with the articles of a company. In Claude Clear Parulkar, the Honorable Supreme Court held Section 36 of the Companies Act makes the memorandum and articles of the company when registered binding not only in the company but also the members, etc.
2020.
Yes, sir, I'm coming there. I'm first showing your lordship the law.
Yes, yes.
The law is to do with the articles, contract, yes. Bylaws, contract, yes. Now, from there to pull it and say that a meeting also becomes a contract. Now, see the language, para 20. Please see, note this, it is based on the above judgments. The above judgments make it clear, bylaws constitute a contract up to here, no difficulty, between the society represented by managing committee. Now, please see the inference from there. Bylaws and contract, the resolution may also have the same character. No, also mark the it doesn't say that the resolution is a contract. Taking it too far.
If the plaintiff had participated in the AGM held on
So,
not resisted,
opposed or objected.
that means a consent.
Consent, yeah, that's different. That's not a consent is an agreement anyway. But that is a different thing. My learned friend is not saying that, look, the resolution is a contract. Now, please remember, if you please see the language. If the plaintiffs had participated in the AGM, HPL had not. Held on 19th and not resisted, opposed or objected. There are letters on record by the wife saying we never got notice of the meeting. Then there will be estoppel. Now, my lord, if it was a contract, then where is the question of estoppel? So the learned judge is clear that it probably was not a contract. So it is estoppel. Because that's why you use the language have the same character. And then estoppel. And when the receipt was admitted and signed, the learned counsel for the plaintiff.
Attendance sheet was signed
Yes.
by the plaintiff and alone
That show resolution was actually approved
by the
members by voting on it. So that takes away all his judgments.
Yes.
One more left. Yes, but on appointment of administrators, not the judgments I had cited. But just, I'm not showing it again. Just make a note. That's all.
Judgment. What is the judgment?
Not Lamartine was 2019 SCC online 1944.
2019 SCC online.
SCC online Calcutta. I'm sorry, brother. 1944. 2007 12 SCC 561. And which one was this? I can't remember.
Yes.
And Millard, yes. We are not distinguishing, is distinguishing. But anything else? Please give me 30 seconds. My seniors will not have to consult them. But please give me one moment. Not that there's only one thing which I'll do. But I'll hand over on the next day. My submissions are finished. I'll hand over a list of proceedings which they have filed. Subsequent to this, a whole list of proceedings where they have attempted to get these kind of orders and where there have been either comments. I'll just make a list of that and give that to your lordship.
Yes.
Oh, right, yes, there's one argument, which I forgot to deal with. And this is the last argument, I forgot. Now, on the point of lack of subject matter jurisdiction, I had said that the division bench and the single bench both make it clear that there was no lack of jurisdiction. Now, Mr. Mukherjee tried to rely on one paragraph to say that no. The High Court, the division bench had said that the probate court had decision at least tentatively to decide the the extent of the state.
Correct.
So therefore, once it says that at the highest this can be an improper exercise of jurisdiction or an incorrect exercise of jurisdiction, but not a lack of jurisdiction. This is the argument he had made. Now, let me just deal with that. Please take note, page 12.
CS 16 GF4.
CS 16 GF4. Just give me the pages there. I have forgotten to pull it up.
Volume 3 and volume 4.
Hey, just pull it out and give it to me. It will take me longer to pull it out from here. One of you give it to me.
Yes.
The para he relied on. No, another one. Yes. But para 104 was relied upon by him at 441.
Yes.
Issue 1. It is well settled that a probate court or letters of administration court cannot finally decide issues of title. It is purely within the domain of a competent civil court to decide such issues. However, in order to decide an application under 247 Succession Act, the probate court may well decide prima facie the extent of the estate of the deceased. For such purpose, the probate court can definitely decide, although tentatively, as to the extent of property. Now, please see two things there. First, that was not an application under 247. Why? I tell you, Lordship, the difference. But the decision on the extent of the estate had already been done 15 years before that. Administrator was appointed. Parties, had both filed affidavit of assets. Then, the APL committee formed a list of the assets belonging, the inventory report, which is undisputed by both the parties. So, the extent of the estate had already been decided many years ago. Justice Munshi was not exercising Section 247 jurisdiction at all.
Yes.
So, at the time of deciding the extent of estate and only at that time. Now, in this case, that had already been done. It was complete. This one.
Yes.
Now, the other paras, which I rely on to show that this para doesn't mean what my learned friend is saying. It will appear from the subsequent paras, para 105, for example. There are many other paras. Go straight to 201. I have to reach on Lavache. It's no point showing you lots of 20 other paras. I'll just show one para. You just 200. Yeah. But para 201, which will be at page 5, volume 4, page 504.
Yes.
Issue 1. A testamentary court cannot decide issues of title.
Same one. The same thing.
Please see this. A testamentary court cannot decide issue of title conclusively. Such power lies purely within the domain of civil courts. Deciding an application under 247, etc., the testamentary court may decide the extent of estate prima facie. So, this certainly doesn't confer the jurisdiction on the court deciding that matter to decide any question of title. This could only have been done in a 247 for limited purpose, and that had already been done and it was achieved long ago. And I've showed you lots of the other paras. which had said that these orders can't be passed against third parties. There is no subject matter jurisdiction. APL had no jurisdiction, and therefore the probate court also had no jurisdiction. Those are all not those paras of the judgment I've already indicated.
172 read with 178.
But just make a noting of this, that Justice Munshi did not appoint the order of 23rd August 2012. And the extent of the estate had already been decided by earlier orders passed by Justice Pinaki Ghosh, Justice Arindam Mukherjee, etc. And what the affidavit of assets has been shown to your lordship earlier also. So Justice Munshi had no power or jurisdiction to decide the extent of the estate, and therefore, this case of it does not fall within the limited purpose of. Okay.
Yes.
I'm sorry.
Now, who will argue?
I appear for Harshvardhan Lodha. I had made my submissions after Mr. Bachawat. Well, I don't intend to repeat anything Mr. Bachawat submits. Kindly, whatever extra, my opening submissions were quite elaborate. Kindly give me 2 days. In case I find there is nothing much to add, I'll finish in 1 day. But kindly keep 2 days as of now at my whenever
The Mitra has got a very good background.
That's some
background and foreground.
Whether you're in Bangkok.
Background and
No. That is, I'm not so lucky. Not so lucky.
Or in Pattaya.
I wish.
In the foreground, something is there.
Leaving the juniors, you will went there.
Is very annoying. Even juniors and colleagues join the profession together, same time.
Okay. Mr. Bachawat has concluded his argument. So who will argue first?
Mr.
Mitra.
Mr. Mitra will telling that he will argue the last week.
No, I can argue next also. Though I would like to argue for last, but still, I'll leave it to my lord. I like to leave it to my lord.
31st August. 31st August and 1st September at 3 p.m.
Grateful to my lord.
My lord, I appear for the petitioner, my lord, in this matter. My lord, this is a writ petition, my lord, challenging the refusal, the order of the Registrar General of Marriages, whereby he has declared that the marriage certificate issued by the marriage registrar is null and void, my lord.
Yes.
Now, if your lordship will, my lord, the petitioner
who has declared the
married to one person, my lord, Registrar General. My lord, if your lordship will kindly come to page 16 of the writ petition.
Yes.
My lord, what has happened is, I got married to the person, Mr. Nahata.
Yes.
Marriage was registered by a marriage officer.
Yes.
But thereafter, I come to know that this particular marriage registrar has been suspended from the department.
Yes.
However, there was no notification. I made a RTI inquiry. I come to learn that appointment, there was a notification. Removal of the marriage registrar, there was no notification. I write to the marriage registrar, the Registrar General. He responds, my lord, may I show your lordship page 16. With reference to your aforesaid letter on subject cited above, the undersigned is to inform you that as per record of this office, the photocopy of marriage certificate enclosed with the referred letter shows that the marriage in question solemnized on 22/2/2017 under section 13 of the Special Marriage Act by Srimati Shikha Tapsi, who was not an official marriage officer appointed by the government of West Bengal on the particular date of solemnization. Therefore, the certificate is illegal in the nature as produced in violation of Rule 14.3 of the West Bengal Special Marriage Rules 2010. Now, so therefore, their stand is that this particular officer was not the marriage registrar as on that date. Now, if your lordship will kindly come to the marriage certificate, which is at page 11, my lord. there is no dispute that this officer was appointed as the marriage registrar, my lord. Now, this is the certificate which has been issued to me, my lord. I, Shikha Tapsi, at page 11, my lord.
Yes.
I, Shikha Tapsi, hereby certify that on the 22nd day of February 2017, Ratan Lal Nahata, son of such and such, and Mamta Agarwal, daughter of such and such, appeared before me, and that each of them, in my presence of the three witnesses, have signed hereunder. So, my lord, she gives a certificate. Now, my lord, in another proceeding, I come to learn, my lord, that the other party has taken this point that my marriage with the gentleman who has now died in the meanwhile is not a valid marriage. I file a application under right to information. Your lordship will kindly take page 12. Just two documents I will show to your lordship, my lord. Page 12, I make an RTI application to the Office of the Registrar General of Marriages. What was the date of appointment of Srimati Shikha Tapsi as marriage officer? First question. Second question is, was there any notification issued for the appointment of Shikha Tapsi by the government? If yes, then please provide the details. Now, the answer to this, my lord, at page 13. Date of first appointment of Srimati Shikha Tapsi is 8/3/2001. Replies in the affirmative, that is whether there was any notification for the appointment. So they say notification number 786J6, dated such and such. Now, if your lordship will kindly take the next page at page 14. Now, this is on the point of law, my lord. When an officer has been appointed by notification and there is no notification for her removal, then what is the stand? Now, if your lordship kindly takes page 14, whether any notification was issued for removal of Srimati Shikha Tapasvi from her office as marriage registrar, if so, please provide the notification details. Now, to this, they send me a reply at page 15. The page 15, my lord. The Judicial Department, Government of West Bengal issued order number. My lord, now this is very relevant. Issued order number, no notification. Order number 1617J such and such, dated 24/6/2016. Srimati Shikha Tapasvi was removed from the post of non-official marriage officer and non-official Hindu marriage registrar. Now, therefore, my lord, her appointment was by way of a notification. Her removal, there was no notification. Internally, an order may have been communicated to her, which the general public at large does not know. She has issued a valid certificate with the valid witnesses, my lord, and now I am made to suffer. And not me, my lord. Many people like me, my lord. Now, on the point of law, I will cite two judgments, my lord, which deals with this principle. When there is no notification,
right,
my lord.
You are appearing for? Yes.
My lord, now just two judgments I will cite on this proposition, my lord. When there has been a notification for the appointment of a public authority and when there is no notification for the removal, then what is the consequence of this, my lord? Now, the first judgment, if I may just cite, my lord, this is judgment of Rajasthan High Court in 2001, SCC Online, Rajasthan 106. Now, if your lordship will kind, my lord, the point here was the concerned officer was appointed, my lord, by the government, and thereafter he was removed, but there was no notification. May I just place, my lord, paragraph 3 first. We have perused the pleadings and judgments under appeal. The facts and circumstances leading to the case are that the first respondent was nominated by the state government in exercise of powers under Section 9 of the Rajasthan Municipalities Act 1959 as a member of the municipal board, such and such, by an order dated such and such, along with Shri Parmanand, which the order was published in official gazette on 25/11/2000. However, by order dated 12/12/2000, Yunus Khan was nominated in place of the first respondent, Bhawan Lal, and that the government order stood notified in the official gazette on 13/12/2000. Hence, the writ petition by Bhawan Lal. Now, your lordship will kindly come, my lord, to paragraph 8. We have perused the materials and also considered the arguments put forth by Shri Kailash Joshi, learned counsel, appearing for the appellants. In the instant case, the government had not issued any notification for removal of the first respondent here in nominating respondent number 4. The order dated such and such and the notification dated 13/12/2000 provide for a corrigendum to the effect that in place of Bhawan Lal Verma, the name of Yunus Khan be read. Before the learned single judge, the appellants had admitted that the respondent stood nominated by mistake, which was rectified by nominating respondent number 4. In our view, for removal of the first respondent and nomination of respondent number 4, corrigendum cannot serve the purpose. The government ought to have issued a clear notification for removal of the first respondent and nomination of the respondent number 4 in his place. Now, if your lordship will kindly come to my lord, paragraph 11. In the instant case, impugned corrigendum has been issued to correct any typographical error or omission therein, which tantamounts to withdrawal of the vested right of the respondents herein. In the instant case, the appellant government has not sought corrigendum to correct a typographical or arithmetical mistake. It amounts to removal of the respondent and nomination of respondent number 4. The government has not issued any notification for that purpose, and therefore it cannot be permitted to take away the vested right of the first respondent, Bhavarlal Verma. My lord, therefore, in this case also, appointment of this marriage registrar was by way of a notification. That is, my lord, a message to the public at large, that everyone comes to learn that this person is acting as the marriage registrar. Everyone goes to that marriage registrar, but her removal is by a private order, order which has not been made public, and there is no notification, and public does not have knowledge about that, my lord. My lord, I was humbly praying, my lord, that such an action on the part of the Registrar General of Marriage, wherein admittedly there is no notification for her removal, my lord, it cannot say that the certificate which was issued by the registrar, by the marriage registrar, is illegal, my lord. Her appointment was legal.
Where is the notification appointed the Sikha Tapasvi as a marriage officer?
Yes, yes, your lordship, my lord, in the RTI, they have answered this. Your lordship will kindly come to page 13. I showed this to your lordship, my lord, page 13.
2001.
Yes, my lord. Date of appointment of Sikha Tapsi, 8/3/2001.
Correct.
And the next question was there any notification? They say yes. Second answer, my lord. Reply is in affirmative. Notification number 786.J6, dated 8/3/2001.
Correct.
Now then I asked them, was there any notification for the removal? They do not give any notification number. They give the order number. Next page, if your lordship kindly takes at page 14. Whether any notification was issued, page 14, my lord, whether any notification was issued for removal of Srimati Sikha Tapasvi from her office as marriage registrar. If so, then please provide the notification details. Now, the next page, answer is at page 15. The Judicial Department, Government of West Bengal, issued order number. My lord, this is just the order number. There is no notification, my lord. If my learned friends can clarify, my lord, whether there was any notification or not, my lord, things will be clear, my lord. Otherwise, I have been made to suffer, and there are several people like me.
Then the respondent has to file the report out there when
Yes,
she was.
will kindly direct them, my lord.
You need a report. Yes, you file the report. This court find that this writ petition is to be decided only after exchange of affidavit. Accordingly, respondent authorities are directed to file affidavit in opposition within 2 weeks, specifically disclosing the initial appointment of Sikha Tapasvi as marriage officer and her removal from the post of marriage officer. Also to clarify that whether at the time of removal any notification has been issued or not.
My lord.
2 weeks बोला ना? क्या बोलो पर क्या बोल रहा है? ठीक. Issued or not? Good. Reply, if any, they are to be filed within a week thereafter. Release the matter on 19th of August 2020.
My lord, any subject to your lordship's, my lord, list, if it may be fixed, my lord.